move ahead. I would welcome committee members of the public, persons in the attendee space to the meeting of the Judiciary Committee on February 22nd, 2022. Today we have 4 public hearings in the morning. I will be conducting the first 3, then turning the gavel over to Senator Carney for the final public hearing of this morning. And as we always do, I will begin with committee introductions, and I will call on people as I see them on my screen, starting with Representative Babbage.
Thank you, Mr. Chair. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk. Good morning.
Thank you. Representative Thorne.
Good morning. Thank you, Mr. Chair. Welcome, committee from Carmel, Maine. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and a portion of Etna. And this morning, unfortunately, we are heavy of heart as we lost our sheriff's deputy supervisor in the town of Herman, Staff Sergeant Bobby Pelletier, in a snowmobile accident up north. So our prayers go out to his family and friends and all members of our community.
Very sorry for your loss, Representative Thorne. I'd read about that tragedy in the paper over the weekend. Representative Moriarty.
Good morning, all. I'm Steve Moriarty. I'm the state rep for House District 45, which is Cumberland and part of Gray.
Thank you, Representative Moriarty. Representative Poirier.
Thank you, Mr. Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. Representative Galgay-Reckitt. You're muted, Representative Reckitt.
Thank you. Good morning. My name is Lois Galgay-Reckitt, and I represent District 31 in the ocean end of South Portland.
Thank you. Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is northern Oxford County, and 2 communities in Androscoggin.
Thank you, Senator Keim. And my co-chair, Senator Ann Carney.
Good morning, everyone. I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And Representative Thorne, I'm so sorry for your community's loss. That's a real tragedy.
And I see we have been joined by our colleague, Representative Rena Newell. Representative Newell, if you could introduce yourself, please.
Thank you, Mr. Chair. Good morning, everyone. My name is Rena Newell, and I serve as the Passamaquoddy Tribal Representative.
Thank you, and it's nice to see you again, Representative Newell. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside, and I serve as the House co-chair. And I see that Representative Laura Libby is in the attendee room. If Soupy or Peggy, if you could move Representative Libby over, and it looks like that's happening. I will wait till she arrives. Give it another minute. I am not seeing her in the, yep, here she is. Good morning, Representative Libby. Don't know why you ended up in the attendee room. Sorry about that. If you could please introduce yourself and welcome this morning. And you're muted, Representative Libby.
Thank you. All sorts of technical difficulties this morning. I am Representative Laura Libby. I live in Auburn, and I represent part of Auburn and all of Minot.
And sometimes I cannot get my email to cooperate and forward the link to the secondary device that I use.
Okay. Thank you. And as we are joined by other members, I will have them introduce themselves, but I'd like to begin, before we begin our work, I want to recognize that we are also joined by our analyst, Peggy Reinsch, and our committee clerk, Supi Panett, who goes by the name of Judiciary Committee. Welcome and thank you both for your assistance today. Supi, if you could please move over the bill sponsor for LD 913, Representative Hassenfuss, so that I may open the public hearing on that bill. I will wait till he arrives.
Mr. Chair, I do not see him in the attendee space.
Okay, could you please contact the House Democratic Office to see if they can reach the bill sponsor?
I will do that.
I will see if I have the ability to contact him as well.
Mr. Chair,
Yes, Representative Thorne?
I just wanted to let it be known that I'm doing double duty in marine resources. So if you see my hand go up on the side, it's not for judiciary.
Okay,
Thank you.
thank you. If you could mute your mic, because I think we're hearing the marine resources, and I am waiting to see. We'll email Representative Hassenfuss.
Representative Harnett, Senator Diamond is available if need be in the attendee.
Why don't, what a wonderful suggestion, Senator Carney. So with that, we will try to locate the bill sponsor on 913, but move to the next bill on our agenda, which is LD 1943. Welcome Senator Diamond back to the Judiciary Committee. I will now open the public hearing on LD 1943, an act to expand the address confidentiality program to victims of certain human trafficking crimes. And again, welcoming to the Judiciary Committee, the bill sponsor, Senator Bill Diamond. Go ahead when you're comfortable, sir.
Thank you very much, Senator Carney, Representative Harnett. I want to say before I begin my brief testimony that I appreciate all the time that you all put in on my last bill that I came before you, and this will be my last bill before you this session. So I want to extend my appreciation for your time. I represent Senate District 26. I live in Wyndham, and my towns include all the towns circling Sebago Lake: Wyndham, Standish, Raymond, Casco, Baldwin, and then one town in the middle of the lake, Fry Island. I am before you today to introduce LD 1943, an act to expand the Address Confidentiality Program, ACP, to victims of certain human trafficking crimes. I'll take you back to July 27th, 1981. Adam Walsh was with his mother. He was shopping at a mall in Hollywood, Florida. 6-year-old Adam was in the toy section 3 aisles over from his mom when she was looking at lamps, and that's when he was abducted. His body was never found. However, a man named Otis Toole, while on his deathbed in prison, confessed to abducting and killing Adam. He'd also been convicted of murdering other children, abducting them and killing them as well. Adam's mother and father, John and Reve Walsh, channeled their grief by creating the National Center for Missing and Exploited Children in 1984. You might also know John Walsh from his long-running TV series, America's Most Wanted. John and Reve lobbied Congress to pass the Adam Walsh Child Protection and Safety Act of 2006, also known as the Sex Offender Registry and Notification Act, SORNA, signed into law on July 27, 2006, exactly 25 years to the day of Adam's abduction. SORNA, by the way, in Maine, the Criminal Justice Committee in 2005 and 2006 reconstructed our sex offender registry laws with the guidance of the Adam Walsh Act, and as did other states. Maine has already been proactive on victim protection issues and as an adopter of address confidentiality standards. Maine's address confidentiality statute explicitly provides protections for survivors of domestic violence, stalking, or sexual assault. But child survivors of trafficking and abduction are not eligible program participants. An address confidentiality program that fully prioritizes child protection will include provisions that enable child survivors of sex trafficking, sexual assault, exploitation, and abduction to enroll, shield survivors' addresses from public disclosure, offer substitute addresses for enrollees, provide free email forwarding to enrollees, and accept services of process on behalf of enrollees. Similar to domestic violence and sexual assault victims, child survivors of trafficking, exploitation, and abduction live in fear that their abuser might find them and harass them, potentially harm them again. The wording in LD 1943 was recommended by the National Center of Missing and Exploited Children, and Dayton Lynch, Corporate and Policy Counsel, is here to present his testimony. Dayton, along with John Clark, President and CEO of NECMEC, contacted me and asked that I submit this after deadline bill. Secretary of State, by the way, will also testify briefly to explain how this process works out of her office. In light of the special safety needs of these child survivors, I ask you to support this bill so we can make sure that we eliminate this oversight and address these serious loopholes in our statute. Again, I thank you for your time on this issue, and I would be happy to answer any questions.
Thank you very much, Senator Diamond, for bringing this important bill forward. We appreciate your time and testimony this morning. Are there questions from committee members for the bill sponsor, Senator Diamond? If so, please raise your electronic hand. And I am not seeing any hands. So again, thank you very much for bringing this bill forward. As the bill sponsor, you are welcome to stay with us as a panelist if you have the time to do so.
I do. Thank you for inviting me.
You're very welcome, Senator Diamond. And before moving forward, I want to welcome two additional members of our committee and give them the opportunity to introduce themselves, starting with Representative Evangelos.
Morning, everyone. Thank you, Chair Harnett. Apologize for being late. I have another matter to attend to. It's Jeffrey Evangelos, House District 91. Thank you.
Thank you, Representative Evangelos. Representative Galgay-Reckitt.
Sorry, I introduced myself earlier, but I had to dash off for a sec. But anyway, I'm represent District 31 in South Portland. Thank you.
Okay. Thank you. I will, and we will proceed as follows. I will call on persons wishing to testify in support of LD 1943. Then I will go to any persons wishing to testify in opposition, if there are any, and then to those testifying neither for nor against. All persons testifying will be limited to 3 minutes, and my co-chair will run the 3-minute clock, and I will follow her guidance. Her hand will be up so that she is visible to anybody testifying. And I'm going to look at the attendee room and ask for persons who wish to testify in support of LD 1943 to please raise your electronic hand. And I will ask for Secretary of State Shenna Bellows to be moved over as a panelist. Secretary of State Bellows, welcome to the Judiciary Committee where you used to serve. It's nice to see you again. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you, and good morning, Representative Harnett, Senator Carney, and members of the Joint Standing Committee on Judiciary. I am Secretary of State Shenna Bellows, a resident of Manchester, and I appreciate the opportunity to testify today in full support of LD 1943, and we appreciate Senator Diamond bringing this forward. I wanted to just share with you, for those of you who may not be familiar, a little bit about the Address Confidentiality Program. It is administered by the Secretary of State, provides an important service to residents of the state of Maine who are survivors of domestic violence, sexual assault, or stalking. And as such, this expansion makes perfect sense and is perhaps overdue. The program has two basic parts. First, the Address Confidentiality Program provides a designated address to victims who have moved to a new location unknown to their abuser. And secondly, the program provides participants with a free first-class confidential mail forwarding service. ACP allows both state and local agencies and the courts to contribute to the safety of domestic violence, sexual assault, and stalking survivors. And if the bill passes, that will be expanded to those who've experienced human trafficking and minor victims of kidnapping. It will deny abusers the opportunity to use public records as a means to locate them. So in 2021, sexual assault support centers and the Maine network of children's advocacy centers served 172 survivors who had experienced trafficking or sexual exploitation in Maine. During that same year, our office helped 250 individuals through the ACP remain safe from their abusers. For our office, managing the ACP includes ensuring all mail for all participants is processed daily, taking phone calls from participants, training application assistants, staff at nonprofits across the state who assist people in applying, managing certifications, and troubleshooting any additional issues that may arise, which usually do. We do all of this within the existing resources of our agency. One thing that came to my attention that I think is important for you to know is that there has never been a dedicated source of funding for this program, but we are really proud of our staff, Nicole Ledner, who runs the program. I'm going to stop here. I'm available for the work session. In our testimony, we identify one issue that we'd like to work with a sponsor and advocates to clarify. We are tremendously proud of this work and think it's extraordinarily important, and thank Senator Diamond for bringing this issue forward.
Thank you very much, Senator.
I owe you candy, right? Former members of the committee are supposed to bring back candy to the committee. So next time you're in person.
hold you to that when we do meet in person again. But thank you very much for being here to testify on LD 1943. And I am now going to see if there are questions from committee members for Secretary Bellows and call upon Senator Keim.
Good morning, Senator Bellows.
Good morning.
Secretary Bellows. So my question is just, I had kind of assumed that that a minor that was involved in anything like this wouldn't have their address made public anyway.
So right now, the statute is very specific to survivors of domestic violence, sexual assault, or stalking. So this bill is necessary because it expands who qualifies for the program to the minor victims of kidnapping.
So what you're saying is that it's just expanding the program if they want to take advantage of it, but it's not as if their information and address is out there publicly anyway. This just gives them a program to use. Am I not understanding that right?
So you're correct that minors' information is generally confidential, but one might be shocked and surprised at how easily public records could help a perpetrator hunt and find a survivor, including minor survivors. There is the ability to pull together address information that is publicly available is truly chilling. And what this program does is it allows people to mask their records in all public records. And that's why we're asking for a little bit of clarification in the proposal to ensure that it's covering adjacent individuals, so parents, custodial parents, perhaps, or legal guardians of the minor victim of kidnapping, so that they, the legal guardians, can mask their address, utilize our program, so that we are the ones that are responsible for first-class forwarding of their mail, and that no abuser or perpetrator could put together that information from publicly available records that are available around a legal guardian or custodial parent.
Okay, thank you.
Thank you, Senator Keim. Are there additional questions from committee members for Secretary Bellows? Representative Thorne.
Thank you, Mr. Chair. Welcome, Secretary of State Bellows. I was just curious if there was a anything that this would be competing against that entitles somebody to know someone's address. In other words, if this is overriding just general information or release of it based on some type of already law in place that would allow someone to obtain the address.
So what's currently available in public records, and as Judiciary Committee members, you deal with public records every day. So for example, property records may be available through the Registry of Deed. Voter information is available to any candidate or campaign. Those address records are available through release of the voter file to certain entities. So the address confidentiality program does something that's really important. It essentially creates a new address for participants in the program. Now, our office reviews all applications to ensure that the people requesting participation in the program meet the qualifications under the law. And then the new address is assigned. And that new address is actually recorded in the voter file and in other areas of the law across the state. So for example, a campaign who's accessing voter information would just see the address that's used for the address confidentiality program that's used for all participants and would not see their actual address. In the redistricting process, we worked really carefully with authorized personnel to make sure that participants in the address confidentiality program were placed in the correct districts, but to do so without sacrificing their confidentiality. And I would argue that when someone has experienced such a terrible crime and has had such a dangerous experience where the abuser or the perpetrator may at some point have the ability to then track them, that participation in the program makes a great deal of sense.
Thank you. Thank you, Madam Secretary. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions from committee members for Secretary of State Bellows? And I am not seeing any. So again, Secretary Bellows, thank you very much for your time and testimony. We greatly appreciate your spending some time with us this morning.
Thank you.
And before turning to additional persons to be heard, I want to welcome to the committee, thanks to school vacation week, Representative David Hagan, and give him the opportunity to introduce himself.
Thank you very much, Mr. Chair. I'm David Hagan. I represent Hampden and Newburgh, House District 101. Thank you again.
Thank you very much, and good to see you this morning. I will now ask the committee clerk to please move over. We have two additional persons who wish to testify in support of LD 1943, Dayton Lynch and District Attorney Jonathan Sarbeck. I will wait for them to be moved over. And I will begin with Dayton Lynch. Welcome to the Judiciary Committee, Dayton. And I should remind everyone testifying today, please begin with an introduction, your name, your place of residence, and any organization that you represent. So Dayton Lynch, with that, again, welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you feel comfortable.
Well, first of all, good morning, Chair Carney, Co-Chair Arnett, members of the Judiciary Committee. My name is Dayton Lynch. I live in Virginia, and I'm pleased to be here on behalf of the National Center for Missing and Exploited Children to testify in support of LD 1943. The act to expand address confidentiality, the address confidentiality program to victims of certain human trafficking crimes. As Senator Diamond eloquently noted, 3 decades ago, following the abduction and murder of their son, John and Reve Walsh came together with other child advocates to create the National Center for Missing and Exploited Children in 1984. Today, our organization is the leading private nonprofit organization that's working to help find missing children, reduce sexual exploitation, and prevent child victimization. Our organization's mission and work to prioritize child protection is why I'm testifying before you today about address confidentiality and protections for child victims and their families. Maine's address confidentiality program serves victims of domestic violence, stalking, sexual assault, as Secretary Bellows noted earlier, and is protecting their residential addresses of these victims from public disclosure. This important legislation provides child victims of sex trafficking and abduction with access to the same protections, and it will help support victim recovery. As members of this committee understand, children victimized by sex trafficking or traumatized by abduction can use all of the help they can get. Child sex trafficking and abduction are traumatic forms of child victimization. Child sex trafficking is abuse that occurs when a child under 18 is advertised, solicited, or exploited for anything of value, such as money, drugs, or a place to stay in exchange for sexual activity. Traffickers can be anyone who benefits from the exchange of a child for sex, including family members, foster parents, gangs, adults in a position of authority. And traffickers can be relentless in pursuing a child who they have previously trafficked, even searching through public records to find a victim's new address. Victims of child abduction also live in fear that their former abductors will locate them. Because the most common form of abduction is a family abduction, the fear that the estranged family member could use public records to locate, contact, and harm the child again is very real. Address confidentiality protections are an important part of a victim safety plan. And under LD 1943, Maine's address confidentiality protections would not only hide the address of these vulnerable child victims from public disclosure to traffickers and abductors, but it will also provide these children and their families with additional peace of mind. 21 jurisdictions have already begun to extend address confidentiality protections to child victims and victims of trafficking. That is noted in my written testimony, which I've submitted to the committee for record. Today, NCMEC is asking legislative leaders in Maine to join the effort. Your support for LD 1943 will help child victims of sex trafficking and abduction rebuild their lives by ensuring that perpetrators can no longer use public resources to locate, harass, and harm them again. Chair Carney, Co-Chair Harnett, members of the Judiciary Committee, thank you for your time. I'm open for any questions.
Thank you very much, Dayton Lynch, and thank you for your time and testimony before our committee this morning. Are there questions from committee members for Dayton Lynch? I will begin with Representative Galgay-Reckitt.
Welcome to your virtual trip to Maine. I wish you a real one at some point. My question is, you said that this initiative or a similar one is existing in multiple of other states at this point. I can't remember how many you said, but basically what's been the track record as has been both for the good that the legislation may have facilitated elsewhere, but how large is this particular problem in continuation in the rest of the country, in your estimation?
Well, it's 21 other states who jurisdictions, because DC is one, so I guess that's not technically a state, though you would like to be. Over the last 5-7 years, these states each consciously added, in particular, protections for human trafficking victims, understanding that, as I noted in my oral testimony, that traffickers are relentless. There becomes this sense of ownership, as we learn from speaking to our operational team, that traffickers get over their victims. And if they feel like they have that control, they pursue them. And it's that peace of mind that the address confidentiality program has provided to domestic violence victims and sexual assault victims and stalking victims in Maine for 20 years, that child victims of sex trafficking and abduction really benefit from. Now, the beauty of the program is that it typically has a low fiscal impact when you add more victims, because people have to apply to it, and not everyone will do it. And the program is not for everyone, and you have to have a new address, as you know, as Secretary Bellows noted. But this program provides another component of an overall safety plan. It's not going to solve all the problems that these victims, these survivors, will experience as they're trying to recover and grow and rebuild their lives. But it's a component. It's a key component. So each of the states who allow child sex trafficking victims to enroll, what they're seeing is there's enrollees, right, who otherwise wouldn't be able to access their program. They don't really disclose the number for obvious reasons. It becomes, a trail that people want to hunt down. But the programs have been successful for domestic violence victims for 2 decades, and the goal is to help other victims, these young vulnerable victims and their families, be able to also access this small aspect of a safety protection solution as they're trying to move forward.
Thank you.
Thank you for the question, Representative Reckett. Thank you for your response, Dayton Lynch. Did you have an additional question, Representative Reckett?
No, I'll pass. I'll be fine.
Thank you. Representative Babbage.
Thank you, Mr. Chair. I appreciate that. And welcome, Mr. Lynch, and thank you for providing testimony today. Help us understand this issue. It's interesting. You said the last 5 to 7 years, there's been some momentum around the country, and but as of right now, a majority of states have not taken action. And I think your wording during your testimony was that 21 states have begun. I'm not sure of the process or whatever. Can you identify how many states actually have passed language that is this or very similar?
Yes, I can. California, I tell you, it's California, the District of Columbia, Idaho, Indiana, Iowa, Kansas, Maryland, Michigan, Missouri, Nebraska, Nevada, New York, North Carolina, Ohio, Oregon, Tennessee, Texas, Vermont, my state, Virginia, Washington, and Wisconsin have all added of these things. Now, the reason not all states actually, there's a group of states who don't have an address confidentiality program, which we're working on right now. And there's others who just, as we know, over probably about the last decade or so, and definitely over the last few years, this recognition by legislatures that sex trafficking and human trafficking is such a pervasive issue that's been going on for such a long time. And now it's so in the public eye, and it's so beginning to be understood a little more, that it's an area where states have added human trafficking statutes, along the same time period. And they're trying to adjust and find ways that the state can use its law enforcement resources, its child welfare resources in many cases, to start providing additional protections for this group of people, this group of kids. And so it's kind of a momentum building thing. When I say 7 years, we're talking about California, who's always, putting forth initial steps that might be a little step ahead of, other parts of the country, because they're dealing with this, so many issues that they're in their full-time legislature, they're always up and running. So that would be more of the 7 year, maybe even 8 year time period in the start of this. It's been over the past, probably 5, 3, 2 years that we've seen states starting to, once they recognize that this is a group of victims that aren't being served by the program, then they add it. There's this misconception many times that, sexual assault covers this. But no, it doesn't, because when you go look at the statutory definition of sexual assault, it doesn't include sex trafficking, because sex trafficking is a thing apart. It's got all these nuances, a commercial act and buyers and also an abduction and kidnapping is not included. Just a thing that people wouldn't think about. People don't understand the traumatic effect it has. And of course, as I mentioned, family abductions are actually the leading cause of abduction. Stranger danger is an important concern. Family abductions are 90+% of abductions in the United States. And so the reason you're seeing kind of the momentum and states adopting is really because they're just not aware, which is why in the winter and into this year, the National Center decided that we want to start helping identify for states some of these areas, these gaps that we see that we really believe leaders in the legislature can help fill, so we can start providing and building that safety protection for children that's not already covered, because it's just not understood that the law doesn't cover it already, right? As Secretary Bellows describing the program, and it's all this nuance and all these things, and I'm really thankful for her to come on and do that, because it does show you that the law does not always cover what it might seem, because as you well know, all the statutory definitions are really specific and really narrow, and that's the case in Maine. The sexual assault statute does not cover what we're talking about here today. So as we start speaking before committees like your committee, it's our hope that we can to start protecting these child victims and make sure that they're able to take advantage of a program like Maine's awesome address confidentiality.
Thank you for that answer. And Mr. Chair, may I follow with one question?
Yes, you may.
Thank you. Thank you for that answer, Ms. Lynch. I appreciate it. Helps me a lot. I'm trying to navigate. Secretary Bellows actually mentioned the voter file, and I was reading testimony while listening to her, but I missed the beginning of her sentence. And is that, from public records, what's the friction from greasing this passage all the way through the country? Is it that kind of thing? Are people off the voter files as a result of having to do this?
No, Representative. What ends up happening is they remain on the voter file. It's just right now, if your address says 123, name street, right? That's where you live. What the address confidentiality program allows you to do, it allows you to say, no, my address is 127 Secretary of State Avenue, right? For the purposes of the file. And the Secretary of State becomes holds the designated address. So now the person can participate, but they don't have to disclose their residential address to the public. Now, that address is still available when it's necessary and needed. Courts can access it through court order or any kind of other provisions. Of course, the Secretary of State's going to know it, but it allows people to shield their address from, so they don't even have to disclose it. But they can still get their mail, still participate in the world, right? Still, and not have the fear that their residential address is going to leak out. And so that's the benefit. It's a little bit better than P.O. Box too, because a lot of P.O. boxes don't get a lot of types of mail in particular. Some mail.
Thank you for that example, and I appreciate your testimony. Thank you so much. Thank you, Mr. Chair.
Thank you, Representative Babbage. Are there additional questions from committee members for Dayton Lynch? Not seeing any. Dayton, we very much appreciate your being here today, sharing your time and testimony with us. Thank you.
Thank you.
Representative Babbage, if you could lower your electronic hand. Thank you. The next person to testify in support of LD 1943 is District Attorney Sarbeck. Welcome back to the Judiciary Committee. Jonathan, it's good to see you again. Please begin your 3-minute testimony when you're comfortable. You're sounding a lot like Alvin and the Chipmunks right now. I'm not sure. Maybe gonna try to come back. I think District Attorney Sarbeck is going to try to rejoin us. Soupy, if he joins the attendee room, if you could please move him over once he is there.
Is this better?
That is much better. You sound just like Jonathan Sarbeck.
Well, I'll tell you that much. That's the first time this has happened in a public setting. I can't tell you it's the first time it's happened, but sometimes my voice on Zoom is all out of sync. But anyway, thank you very much, Representative Harnett, Senator Carney, members of the judiciary for having me. My name is Jonathan Sarbeck. I'm the district attorney in Cumberland County, and here I'm representing the Maine Prosecutors Association and the Office of the Attorney General in support of LD 1943. I very much appreciate Senator Diamond bringing this important legislation to this committee, and we are in support of it ought to pass. And also, I'd like to say thank you to the National Center for Missing and Exploited Children for bringing this to the attention of the legislature in Maine. I can tell you from a person who's married to a woman who used to work at America's Most Wanted, all the good work that the National Center does in bringing these important issues to protect children and victims of sexual violence. As you've heard already, part of the reason that this is important legislation and we're backing it is before I became district attorney, I was the prosecutor who handled human trafficking cases in Cumberland County. And human trafficking often means sex trafficking as well as labor trafficking. I can tell you from speaking to many survivors of human trafficking and also victims as they came through the court system, these individuals are some of the most marginalized and victimized people who we see in the criminal justice system because of what has happened to them. And very much their experience, the trauma that they've gone through is on the level of domestic violence and sexual assault victims itself, because quite frankly, human trafficking is sexual assault. So we understand and appreciate Senator Diamond bringing this bill forward, and also from hearing from Secretary Bellows, who kind of explained what the process would look like and how expanding what's already existing to victims of human trafficking and kidnapping is very important. I can tell you that, just as was said by Mr. Lynch, a lot of this has to do with the power and control dynamic that I'm sure people have heard of when it comes to domestic violence, but human trafficking is very much that same type of exploitation that happens with the power and control dynamic. And I've had conversations with survivors of human trafficking that still see the face of the person who trafficked them at random places, even when I know that that person is behind bars, and that is something that they're seeing in their head, but it's because of the trauma that they've endured. And if they could have that sort of mechanism where they know that they're going to have a confidentiality when it comes to their address, it might just be one thing that will help them heal. And this is one of the very large reasons why we're supporting this bill as LD 1943 and urging the committee to vote that it be ought to pass. So I'd be happy to answer any questions that the committee might have for me, but I appreciate your time and attention to this, and again to the bill sponsor and for the time here at the committee.
Thank you very much, Attorney Sarbeck, for being here and sharing your testimony with us today. Are there questions from committee members for Jonathan Sarbeck? And I am not seeing any. So again, thank you very much for your time and testimony. Will you be submitting the testimony in writing? I've not seen a written testimony in the file.
I was going to prepare this. This was not prepared today. I usually don't prepare stuff in writing. I just kind of talk off the cuff, but I can definitely put something that says in writing that the Maine Prosecutors Association and the Office of the Attorney General is supporting this legislation.
Thank you very much for that. Greatly appreciate it.
Thank you.
I will turn back to the attendee room and ask if there are any persons who wish to speak in support of LD 1943. If so, please raise your electronic hand. And I ask the committee clerk to please move over Penny Morell to become a panelist. And Penny, as soon as you are able, if you could please activate your video so that we can see you. Welcome back to the Judiciary Committee. Nice to see you again. Please begin your 3-minute testimony as soon as you're comfortable.
Thank you, Representative Harnett. I won't go through my introduction. You know, I'm Penny Morell and I'm with Concerned Women for America of Maine. And CWA of Maine supports LD 1943, an act to expand the address confidentiality program to victims of certain human trafficking crimes. Federal anti-trafficking laws. The Trafficking Victims Protection Law, TVPA of 2000, is the first comprehensive federal law to address trafficking in persons. The law provides a 3-pronged approach that includes prevention, protection, and prosecution. The TVPA was reauthorized through the Trafficking Victims Protection Reauthorization Act, TVPRA, of 2003, 2005, 2008, 2013, and 2017. CWA supports these steps towards protecting victims of such crimes and believes protecting contact information is a step Maine should take to further these protections. We agree with the sponsor of this bill that it is an emergency that needs to take effect immediately. Because of these reasons, we respectfully ask this Judiciary Committee to vote LD 1943 ought to pass. Thank you, and I'm happy to take any questions.
Representative Harnett, we're not able to hear you.
Thank you. Thank you again for your time and testimony today. Greatly appreciate hearing from you. Are there questions from committee members for Penny Morell? And I am not seeing any. Thank you very much again for being here today. We appreciate your input.
Thank you.
I am going back to the attendee room, checking one more time if there are any persons who wish to testify in support of LD 1943. Please raise your electronic hand. And I am not seeing any. Are there any persons who wish to testify in opposition to LD 1943? If so, please raise your electronic hand. Again, I am not seeing anyone, and I will last ask if there are any persons who wish to testify neither for nor against LD 1943. If so, please raise your electronic hand. And seeing none, having heard from all persons who wish to testify on LD 1943, I will now close the public hearing on that bill with thanks to the bill sponsor, Senator Diamond, for bringing this important piece of legislation forward. Thank you for your time and testimony today.
Thank you very much. I appreciate your time.
We will now go back to the first bill on our schedule for today. I am asking the committee clerk to please move over Representative Hassenfuss to become a panelist. And I will, as he's being moved over, open the public hearing on LD 913, which is an act to enact the Maine Data Collection Protection Act. And Representative Hassenfuss, as soon as you, thank you, I can see you now. Welcome to the Judiciary Committee. and please begin your testimony as soon as you are ready.
Senator Carney, Representative Harnett, and the esteemed members of the Judiciary Committee, my apologies for not promptly getting to that link there earlier, and I appreciate your ability off to the second bill of the day. What I'd like to do is, you have my written testimony, and I typically don't recite from my written testimony as it's there in writing to read. And I suggest taking just a couple of minutes quickly and going through that as it answers some technical questions. And additionally, I think it's necessary to have the background that this bill's original text have essentially been scrapped and replaced with amendment. The reason being the original text was going to place burdens on consumer debt collection agencies, which after the bill text was published, I became aware that that created some significant constitutional issues. Instead of going forward with a bill that most likely would be struck down as unconstitutional, I decided to address it on the other end, limit what data would be placed online in the first place by the courts. To better illustrate who this bill protects and why it is good, let me tell you a story. There was a young family of four, mom, dad, and their two children. They both work full jobs, making slightly more than minimum wage. And because of a mishap on a credit card debt back in school, their credit score isn't stellar, and they're having a hard time finding a bank that will give them credit to purchase the home that they currently live in, let alone the $50,000 needed for a down payment to purchase it outright. Fortunately, they found a great landlord who was willing to rent them the home of their dreams and extend them an offer to purchase the house at a reasonable price when they were ready and could find the financing. For the last 2 years, they had been exceptional renters, never missing a payment and always keeping the house in excellent repair at their own expense. Then, out of the blue, this fall, real estate values were historic highs. They received a notice from their landlord that they had to be out of their house in 30 days. This came as a huge shock, as they had every intention of purchasing their house for what they believed was an agreed upon price from 2 years prior. They have two children in the local school system, one of whom has special needs, but great teachers and staff supporting her, and the other is the senior captain of what is shaping up to be a state championship football team. After the shock of this notice wore off, the family quickly realized that the tentative oral understanding of a future purchase amounts to nothing under Maine law. And the only real legal right that they had was to look fiercely for a new place to live until they were served a writ of possession. They scoured the newspapers, Craigslist, and even had a local realtor helping them find something in town that could accommodate at a price they could afford. But with each passing day, it became more and more helpless. They knew the housing market was hard, but never imagined it would be anything like this. The houses in their price range were swallowed up by a state over asking price. A few applications for 1 or 2 bedroom apartments were pending approval, and anything with 3 or 4 bedrooms was more than what they could even afford to pay a mortgage on. Finally, after 28 days of looking, they find something that can at least get them by. It's an overpriced student apartment in a rough part of town that requires a year lease, but it's better than the streets. Fortunately, it won't be open for another 3.5 weeks. 2 days later, a sheriff shows at the door with a summons indicating that they have been summoned to appear in court in 1 week. Once in court, the family is told by the judge that unless they can show that they have a claim to title on the property or that the eviction is retaliation, then there is practically nothing that they can do to stay in the house. The family understands their predicament. and understands that though they feel betrayed by the landlord choosing to sell it out from underneath them, it is his house and they need to leave. The family explains their situation and pleads with the attorney to let them stay until they're able to move into the apartment. But under tight closing deadlines, the landlord and attorney refuse any additional time. The family brokenly accepts the judgment for the plaintiff, and 7 days later, saving what little pride they have, move out of the house before the sheriff can arrive to serve the writ. The family is just settling into the second night, sleeping in their car, when the property manager for the new apartment calls. I regret to inform you, but when I was doing my final review of your application this afternoon, I looked at court filings from my office computer and it have an eviction on your record. We just can't take the risk and we'll be denying your application. Though this is a fictional story, most of the elements of this story came from things that I've seen in eviction court. I'm sure that people testifying after me can tell even more heartbreaking stories. I'm by no means an expert in evictions, but I've handled a number of them on both sides through my general practice firm in downtown Winthrop. This bill does not address the hardships that experience when they leave their home. What it addresses is finding the next one. Our eviction laws are premised on the belief that there is another place to go. No-fault evictions allow both tenants and landlords to terminate rent agreements, as I believe they should be. However, if our court practices result in people no longer being able to find housing after going into the court system, then the system itself will break down. And as you will learn from those following me and from the written testimony, having eviction on one's record can make future housing nearly impossible. When the eviction records are placed online, this only adds to the concern, as in a number of states, the data has shown that when they've published eviction data online, it has effectively created tenant blacklists, where it takes them years to find new housing. And as you know, Maine is about to put all of its court records online. And that is why this is a very timely bill. And this bill is intended to make sure that the good, easily accessible court records does not inadvertently make it impossible for good tenants to find future housing. And I appreciate the fact that all of the hard work that the court has done in bringing these records online, they've thought about this. And in their rules, they essentially say that in consumer, small claims cases, in FED matters, which are eviction cases, and in foreclosures, the filing will not be placed online until there is a judgment entered against the defendant, which this bill also addresses that particular fact. And I think in many ways, they one strengthens the other. Many of the protections of this bill will be provided under the rules. However, I believe it is important for this branch of government to weigh in and codify law that those provisions of the regs prohibiting complaints and other court filings from being published online before they have vetted hearing is important. This bill, if passed, would do just that. Additionally, I'm happy to work with the courts to alleviate any concerns it may have about implement this with their data and their software. I've been in communication with them, and I look forward to continuing that communication and throughout this process. And I believe that this amendment, with some minor adjustments, finds the right balance between what works for the courts, what the legislature in its branch of government would like to do, and the right balance between tenants being able to find future housing and landlords being able to adequately screen for prospective tenants. And with that, I yield back to this committee, and I'm happy to answer any questions that you might have. And there also are a number of other individuals coming after me that probably know even more, actually, that do know even more than I do. So
thank you very much.
With that,
I'm sorry. Thank you very much, Representative Hassenfuss, for bringing this bill forward, LD 913. Just so I am clear, the amendment dated February 16th of this year represents the bill in its entirety now. Is that correct?
That is correct. Everything from the original draft from last year has been struck. And also the initial public hearing in the IDEA committee was on the amended version of the bill. There was
up there.
Yes, the initial public hearing in IDEA also was on the amended version of the bill. And most of the persons testifying were aware of that. I think there was maybe one who testified in opposition, but it was based on the draft of the bill.
It looks like Representative Harnett may be frozen, and so I'll just call on committee members with their hands up until he's able to return. And I think Representative...
I apologize. It looks like I froze up. I apologize for that. Representative Hassenfuss, I will now turn to questions from committee members, beginning with Representative Reckitt.
Thank you. Representative Hassenfuss, I'm desperately trying to find a copy of the amendment that replaces this bill. So if someone could give me a hint as to where to find that. I'm looking at the...
in the electronic file under committee materials.
Okay. Thank you.
Did you have an additional question, Representative Reckitt?
Not till I see the amendment. No, thank you.
Okay. Representative Moriarty.
Thank you, Mr. Chair. I just wanted to respond to my colleague. Peggy sent this out by email dated February 16. So that's where I found it.
Thank you very much.
And then I did have a question for Representative Hassenfuss. I realized that the amended bill is all basically new language. And section 9-C begins with the two words court records. Is that two-word phrase defined elsewhere in Title IV? I mean, it's probably a logical and easily understood term, but I just wonder if there is an accepted definition out there somewhere.
I don't know the answer to that question as far as what the particular wording of court records should be. I think we all understand what we're speaking of when we say court records, filing of complaints and answers and that sort of thing. I would defer to the committee analyst to, if the committee chooses to tighten that language up and
okay,
with whatever legal terms should be there.
Okay, thanks. Mr. Chair, I just have one quick follow-up.
That's fine, Representative.
Representative Hassenfuss, we have written testimony for the Administrative Office of the Courts indicating that the judicial branch took part in a lengthy public process involving multiple public hearings and acceptance of testimony before promulgating its rules. Were you part of that process, or are you aware of other organizations that were?
I was not part of that process. And I think there was a number of organizations that were part of that. And that question may be better posed to some of the individuals after, as I suspect that they may have played some role in that process.
Thank you.
Thank you, Representative Moriarty. Representative Babich.
Thank you, Mr. Chair, and welcome, Representative Hassenfuss. I just wanted to get an idea of, how new this language is or how much it's been vetted. There are 9 exceptions here, A through, what is it, I? And is this borrowed language or, are they time limits like, an investigation that's older than 3 years in F, that kind of thing? I just wondered if, this is borrowed from another state or from an organization or how far along has this language been vetted?
No, this is not borrowed from another state because a lot of this language is particular to the main eviction statutes, for instance, anything in Title 4, 6, 601, et cetera. But I have been working with stakeholders at, Maine Housing, Maine Equal Justice, to work on language that works, that takes into consideration the Maine court process for evictions and addresses all of the different areas and different results that we see in both evictions and consumer debt, small claims cases.
I appreciate you bring this issue to us because in the current climate, finding new rentals is already very, very difficult for folks. So thank you for doing that.
Thank you, Representative Babbage. Senator Carney.
Thank you. Thank you, Representative Hassenfuss, for bringing this bill forward. And I had a question that relates a little bit to the information you were just providing. Are the subcategories intended to only apply to cases within forcible entry, detainer, and small claims court? Because, for example, F refers to court records that are part of civil court case or government action or investigation older than 3 years. So I'm just trying to figure out if the small claims and FED is sort of an umbrella and all of the paragraphs are qualified by that, or if that is something that would apply even outside of the FED actions and small claims court actions.
No, this is intended to only apply to the FED small claims actions. So the older than 3 years would apply to evictions, or if it was a credit card debt case, something like that. But no, and I think the court rules also make that distinction between every civil case and and the FED cases, foreclosures and small claims. So that distinction has already kind of been made in separate from the judicial branch. Has been made by the courts, and so this is sort of piggybacking on that, and it's not intended to have any bearing on their civil cases.
Thanks for that clarification.
Thank you, Senator Carney. Representative Babbage, do you have an additional question?
I do not. Thank you, Mr. Chair.
Thank you. Senator Keim.
Thank you, Mr. Chair. Welcome, Representative Hassenfuss. I have a couple of questions, I guess, just sort of trying to understand a little bit better the background of this. So if I understand correctly, you're not trying to take records that are public and classify them as not being public, but you just want to make it difficult for landlords to find the information, more difficult for them?
No, that's not necessarily correct. I don't want to do anything to change what current practice is. So this is not putting any further burdens than what is currently on any landlord or anybody looking at any case files in the state. What it would do is it would just restrict cases moving forward, the cases that can be put online. And as we've already discussed, the court has already limited a number of the cases that will be put online. And this is just further clarifying. So it is not making it any harder than the current process is. And it's making sure that tenants have the due process that they deserve before the record of their eviction is published online. However, there are cases where there is a finding against the defendant. That finding will be published online and will be available for anybody at their desktop computer or iPhone or what have you. So I'll be clear that it is not making any additional burdens than what already exists.
So because your connection isn't super strong, I'm having a hard time understanding because your voice drops off, and I'm pretty sure it's yours and not mine. But so I just have to clarify again because I didn't quite understand. But you're saying that if we ask the landlords to go get this information at the court rather than being able to look at it online, it's the same information, but that extra step of going to the court, which in fact I would probably qualify as being more difficult, but that is the goal here. Is that right?
The goal here is to avoid, and some of those coming after me can speak to this better, but the goal here is to avoid what has happened in other states where because information is posted online and is incredibly, super easy to access, there will be companies from other states, California, let's say, that aggregate that data, post it out there, and can easily submit a list to anybody of all the individuals in Maine who are subject to eviction proceedings. Whereas currently, it would require that company to go to the court and to actually participate in the process and understand what's going on. And like I said, I think that landlords have the ability to see whether tenants have had eviction judgments against them. But we need to be careful because those who have had an eviction complaint filed against them should not be lumped into a category of tenants with evictions just because it's super easy and these companies are being lazy and don't want to fully vet what happened in the case and actually through the case records. Whereas if you're at the courthouse, you by default are looking through case records.
Okay, I think I understand. And then my second question is just if housing wasn't a crunch right now, would you see this still as something that you would want to move forward with, or is it because you think it's difficult for people to find housing and you're trying to address that situation?
No. Anytime I look at a bill, I say, government's all about doing the right thing. And one of the fundamental aspects of our government is due process. I think that every single individual should be and is acquired due process.
Okay.
And I am concerned that if you let any eviction complaint that has not been fully vetted and fully screened by a fact finder on the internet, then those individuals are not going to be in due process because people are not going to take the time to hear their story like a judge would. And so the judge in these cases will be the determiner of what gets published online.
Okay.
And what doesn't.
Okay, thank you. Could I have one follow-up, Mr. Chair?
Yes, you may.
Okay, so then I guess when I hear that, I don't understand how the older than 3 years fits into that. What you're saying is if it isn't fully vetted, you don't want it online, but then I think you're also saying that you don't want it online if it's older than 3 years, which obviously is fully vetted.
Yes, and so the 3 years issue in a number of things in court, have time frames. For instance, evidence of crimes, certain crimes of dishonesty over 10 years cannot be brought into evidence. So I feel like time frame, and that time could be moved by the committee. It was like 5 years or 3 or 1 or what have you. It's after a certain amount of time, your past is not a great indicator on what future.
Okay.
But I leave that to the committee to work through what that timeframe should be.
Okay. Thank you so much.
Thank you, Senator Keim. Are there additional questions from committee members for the bill sponsor, Representative Hassenfuss? I am not seeing any. Thank you very much for bringing this bill forward. It's our committee's practice that you're free to stay and remain as a panelist for the remainder of the public hearing if that is something you are interested and able to do.
I will probably try to juggle this and my own committee's hearings, but thank you very much. And I'm more than happy to work with the committee on any issue that it sees or any way that it would like to steer this bill. So thank you very much for taking the time. I look forward to speaking to you.
Thank you. I am now going to turn to the attendee room and ask persons that wish to testify in support of LD 913 to please raise your electronic hand so that I can have you moved over as a panelist. And I will begin by asking Committee Clerk Panett to please move over Andrea Stark and Catherine McGovern. And I will wait for them to get moved over. And I will begin with Andrea Stark as soon as you are able to. Thank you for activating your video. Welcome to the Judiciary Committee. When you are comfortable, please unmute your microphone and begin your 3-minute testimony.
Thank you very much. And good morning to you all, dear Chairs Carney, Harnett, and members of the Committee of the Judiciary. Thank you very much for the opportunity to offer testimony on behalf of the National Consumer Law Center, NCLC, in support of LD 913. My name is Andrea Bob Stark. I grew up in Portland and now live in Saco. I'm a staff attorney at NCLC, which is a nonprofit organization located in Boston that uses its expertise in consumer law to work for consumer justice and economic security for low income and other disadvantaged people in the United States. We work with thousands of legal services, government and private attorneys, as well as community groups and organizations who represent low income and elderly individuals on consumer issues. As a result of our daily contact with these advocates, we have seen many examples of the damages wrought by abuses from consumer reporting agencies and the harms of relying on eviction records and other public records to make decisions about rental housing applicants. Today, to rent an apartment or a house, you almost always have to go through a tenant screening process. Tenant screening typically involves review of a rental housing applicant's credit, criminal, and rental history. Landlords often automatically reject applicants with a prior eviction record, regardless of the outcome, context, how long ago the case was filed, or whether the case was based on unlawful grounds. Simply being named in an eviction case can therefore lock people out of housing, trapping them in, quote, a dangerous cycle of poverty and instability, end quote. Some landlords go directly to the court's online database to see whether a prospective tenant was previously named in an eviction lawsuit. Many others purchase reports from specialized tenant screening companies, which often scrape information, including the name of the landlord, the name of the tenant, and property address from online courthouse databases, or buy that information from a third-party data broker. Under the Federal Fair Credit Reporting Act, tenant screening companies are only supposed to report eviction records for 7 years, but in many places, the records continue to be available online without any time limit. Housing court records are incomplete and ambiguous, typically lacking key details such as personal identifying information, like social security numbers and dates of birth, that are critical for accurately matching court records to the correct consumer. The big three nationwide credit bureaus have actually stopped reporting civil judgments on credit reports because they lack these identifiers. Such problems with housing court records have not stopped tenant screening companies from reporting them, however. This practice disproportionately affects communities of color. Even before the COVID-19 economic crisis, eviction rates were higher for Black and Latinx renters, as well as mothers and their children. One study found in Maine that Black female renters were filed against for eviction at double the rate of white renters. As a result, these communities are disproportionately affected by landlords' blanket policies that exclude applicants with eviction records. The COVID-19 economic crisis makes it more critical than ever to prevent. Yes.
Your 3 minutes is up. The committee had written testimony. If you could wrap up in a sentence.
Yes.
And you'll
So
be
I just,
available for questions. So.
absolutely. Just to wrap up, that by ensuring that only eviction records are accessible online, LD 913 would help ensure that Mainers can secure safe housing and have a fair shake at recovering from the COVID-19 economic crisis. Thank you. And I did provide written testimony, and my contact information is on that if you have further questions after this hearing.
Thank you very much, Andrea, for your testimony and your time before the committee today. Are there questions from committee members for Andrea Stark? I will begin with Representative Moriarty.
Thank you, Mr. Chair. Ms. Stark, I've reviewed your written testimony, and it seems as though you're only concerned with eviction matters and not small claims cases. Is that fair to say?
Well, that is what I'm testifying on behalf of today. The National Consumer Law Center would be concerned with the small claims as well, but our testimony for today is focused on eviction because that seems to be the most pressing matter at the time.
Okay, a quick follow-up. It seems to me that in the universe of court records, that eviction proceedings and small claims cases are a very, very small percentage, and that other court records such as criminal convictions, findings of civil liability, which may relate to one's reliability as a tenant and so forth, are really not only more numerous, but much more important. Why do you attach so much importance to small claims matters and evictions?
That's a great question. Because evictions carry a stigma that they shouldn't necessarily carry, especially if somebody has an eviction matter that is resolved, that is dismissed, that is for no fault, a no fault eviction. But landlords and tenant screening companies use these records and can easily access them in other states online. And if there's an eviction, it creates what's considered a blacklist for a tenant, and they can't procure further housing. And there are lots of studies I've cited in my testimony, lots of statistics to show just how ambiguous and misleading eviction records are, especially if they're online where they're easily accessible. They don't tell the full story, and they prohibit tenants from seeking further housing, and it could be based on no fault of their own.
Thank you.
Yes.
Thank you, Representative Moriarty. Are there additional questions from committee members for Andrea Stark? I am not seeing any, so again, thank you very much for your time and testimony today and for submitting it electronically as well.
Thank you very much.
Next up is Catherine McGovern. Catherine, as soon as you are comfortable, welcome to the Judiciary Committee. Please begin your 3-minute testimony.
Thank you. Good morning, Senator Carney, Representative Harnett, and members of the committee. My name is Catherine McGovern, and I'm an attorney at Pine Tree Legal Assistance. Pine Tree is a statewide organization that provides free legal services to low-income Mainers, and we have attorneys practicing in district court all over the state. We represent low-income people in many eviction cases. In 2021, we assisted low-income Mainers in over 2,000 eviction cases. Pine Tree Legal Assistance supports LD 913 because it balances the need for court transparency and access to information with the need to protect Mainers from unfair tenant blacklisting by limiting the availability of information regarding some evictions. As has been discussed, LD 913 will not prevent access to information currently available at the courthouse, but it will prevent some types of evictions from being more widely disseminated through electronic court record systems. I wanted to draw the committee's attention to the fact that last week, the American Bar Association adopted a resolution urging all federal, state, local, territorial, and tribal legislative, judicial, and other government bodies to promulgate laws and policies that implement its 10 guidelines for residential eviction laws. Among those guidelines, the ABA urged entities to have sealing of some eviction records and a process to seal records after the fact. The ABA resolution noted that many landlords automatically decline rental housing to applicants with records of being sued for eviction, even if the cases were dismissed or otherwise resolved in favor of the tenant. And substantially all landlords treat such applicants less favorably. This practice incentivizes tenants to move out before an eviction case is filed, even when the tenants have a meritorious defense. And that's a dynamic that undermines the fundamental legitimacy of the judicial forum. The current housing market is very difficult for low-income Mainers. The increase in housing costs in Maine during the COVID pandemic has had several effects that we see from the people who are calling us for legal help. One example of that is that according to the intakes that we have done since September of 2021, over a third of the eviction cases we have seen do not allege a reason and are either a 30-day notice to quit served upon a tenant at will without a stated reason or the result of the expiration of a lease term. In addition, recently we have seen in courthouses across the state a number of tenants who are defaulted in eviction cases because they have called the court to let the court know that they have COVID symptoms and so would not be permitted to enter the courthouses. Those cases result in defaults. Thank you for the opportunity to testify in favor of LD 913, and I'm happy to answer any questions.
Thank you very much for your time and testimony today, Catherine McGovern. Are there questions for Catherine McGovern from committee members? Senator Carney.
Thank you, and thank you for providing testimony and especially pointing out the ABA resolution. I had a quick question for you. Could you please describe to us a little bit more what's going on with the default judgments when people are unable to enter the courthouse for the hearing because of COVID symptoms?
The court has issued guidelines that are on its website that let people know that if they have been diagnosed with COVID or if they have COVID symptoms, that they're not permitted to access the courthouse. So that tenants would become aware of that if they called the courthouse to find out what the process was, or if they show up at the screening. At screening, they're being asked questions about whether they've been exposed to COVID or have been diagnosed with COVID. And so tenants then aren't permitted, or any litigants aren't permitted to enter the courthouse if they answer yes to those questions. The response during the docket call for evictions varies widely. And so we have seen a number of cases, defaults granted in favor of the plaintiff in those cases where tenants are not able to come to court. And in some cases, the court will postpone those cases, but in other cases, they're going ahead and entering defaults.
Thank you.
Thank you, Senator Carney. Are there additional questions for Catherine McGovern from committee members? I am not seeing any. So again, Catherine, thank you very much for your time and testimony today. The committee greatly appreciates your attendance.
Thank you.
Committee Clerk Panett, if you could please move over Frank D'Alessandro, Whitney Parrish, and Ben Martineau. And I will call upon Frank D'Alessandro. Welcome back to the Judiciary Committee, Frank. Please begin your 3-minute testimony as soon as you are comfortable.
Good morning, Senator Carney, Representative Harnett, and distinguished members of the Committee on Judiciary. My name is Frank D'Alessandro. I'm the Legal Services Director of Maine Equal Justice. We are a statewide civil legal services organization, and we work with and for people with low income seeking solutions to poverty through policy, education, and legal representation. Thank you for the opportunity to offer written testimony to you in support of LD 913. We support this bill because we must prevent tenant blacklists from coming to Maine. The benefits of moving court records online should not come at the expense of housing opportunities for low-income Mainers. LD 1913 simple protections will ensure that online court records don't unfairly prevent Mainers from finding housing. As we all know, Maine is in the midst of an affordable housing crisis. 60% of Maine renters are house burdened, which means they are paying over 33% of their income in rent. Currently, there are only 19,000 affordable housing units across the state and a shortage of over 20,000 of those units. Given the substantial costs of creating housing, it is critical we do not create barriers to tenants who need to access housing. As amended, this bill prevents certain eviction records from being accessible by the public online. Cases with complaints for eviction based on a no-cause notice, cases resolved by agreement, cases dismissed or resolved in favor of the defendant, or cases where the judgment is set aside or vacated. To answer one of the questions that was raised earlier, this does not make it more difficult for landlords to access housing eviction records than what currently exists. Those records this maintains the status quo. All the records are still available at the courthouse. What this does is this is actually an improvement for both landlords and tenants. It's an improvement for landlords because landlords will be able to access judicially stored, electronically stored judicial records online, and that will be easier. And there's also, you've heard already how landlords some landlords automatically blacklist tenants just because they've been involved in an eviction case. This, by creating this standard of what records can go online and what records can't go online, you establish a vetting process so that only tenants who have actually been found to have violated a lease provision or violated the provisions of the tenancy will statute and caused trouble or caused a problem are available online. So we believe that this is an improvement. In answer to the question about why consumer cases, whether this applies to evictions or consumers, since this bill is carried over from last session, and last session, the legislature passed a law which prevents credit card cases from being brought in small claims court. So that's why the focus of this bill is now on eviction cases. And I'm happy to answer any questions.
Thank you very much, Frank D'Alessandro, for being here this morning with the Judiciary Committee to testify. Are there questions for Frank D'Alessandro from committee members? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much for your time and testimony today, Frank.
Thank you.
Next up, I have Whitney Parrish. Whitney, welcome back to the Judiciary Committee. Please begin your 3-minute testimony as soon as you're comfortable.
Thank you, Chair Harnett. Good morning, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Whitney Parrish. I'm the Acting Executive Director of the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations. I'm honored to offer testimony and support to this amended bill LD 913. The Permanent Commission is an independent entity with a mission to examine racial disparities across Maine and to work toward improving the status and outcomes for currently and historically disadvantaged racial, indigenous, and tribal populations. Further, the Permanent Commission is empowered by state law to advise and consult all 3 branches of government. As you've heard, discrimination in housing based on race was legal in this country as late as the 1960s, and there have been many documented examples of illegal discrimination since. One can easily see the effects of this in the shape of cities and towns across the country today. Here in Maine, only 30% of Black residents are homeowners as compared to 72% of the population as a whole. That means 70% of Black Mainers rent while 28% of all Maine households rent. This disparity in home ownership for Black residents is higher in Maine than it is in the nation as a whole. The goal of LD 913 is to protect tenants from the mass use of court records as a tenant screening tool, as you've heard. The benefits of moving Maine's court records online should not come at the expense of housing, as has been the case in other parts of the country. Affordable and acceptable rental housing is more difficult to obtain for racial, indigenous, and tribal populations in the state. Those with housing report a lack of basic housing necessities, such as proper facilities or space, at a higher rate than people who are white. In addition, Mainers who represent these populations experience houselessness at a greater rate than those who are white. This disparity is most pronounced for Black people, who represent 26% of those who are unhoused, while only consisting of 1.7% of the state's total population. If landlords begin accessing eviction court records online and using them to effectively place prospective tenants on a blacklist, even tenants who made no mistakes or broke any rules, then Maine will see more unhoused individuals and families of all races and ethnicities. For this reason alone, and for all the other reasons mentioned above, we respectfully urge you to support LD 913. And we thank you so much for your time and consideration of this bill. I'm happy to answer any questions. Thank you.
Thank you very much, Whitney, for your time and testimony today. The committee greatly appreciates your presence. Are there questions from committee members for Whitney Parish? If so, please raise your electronic hand. I am not seeing any, so again, thank you very much for your time and testimony today. Next on my list to testify in support of LD 913 is Ben Martineau. Welcome to the Judiciary Committee. Please begin your testimony as soon as you're comfortable.
Good morning, Senator Carney, Representative Harnett, and esteemed members of the Committee on Judiciary. My name is Izzy Ostrowski, and I am testifying on behalf of Ben Martineau, who is an advocate with Homeless Voices for Justice. My name is Ben Martineau. I'm a resident of South Portland, and I was born and raised in Portland. I'm here today to speak on behalf of Homeless Voices for Justice in support of LD 913. Homeless Voices for Justice is a grassroots organization that works for social change with and on behalf of people experiencing homelessness. 5 years ago, I experienced homelessness. In November of 2016, my landlord gave me a 7-day eviction notice due to poor choices on my part. I knew I messed up and that the eviction was warranted. For that reason, I took the 7-day eviction to avoid a 2-month fight in court. Plus, I knew that if I went to court and was evicted anyway, that eviction would be on my record and jeopardize my ability to get housing in the future. I arranged to move out, and even though I had a housing voucher, the 7-day notice wasn't nearly enough time to find another place I could afford and that would take my voucher. Without anywhere to go, I ended up homeless. While I was homeless, I went from a person who was making poor choices to someone who corrected their life through recovery, from a poor tenant to a model tenant. This is work I'm very proud of and work that made me into who I am today. But even that work didn't change the fact that the experience of being homeless was stressful, traumatizing. While I was homeless, I applied for public housing through the Portland and South Portland housing authorities. In the spring of 2017, the Portland Housing Authority approved my application, seeing no evictions on my record. In spring 2019, South Portland Housing Authority approved my application, also seeing no, quote, evictions on my record. Both agencies collected a lot of information about me, including my name, social security number, and even my fingerprints. So if I had had an eviction on my record, they would have found it. Not going through the court eviction process saved my housing record and allowed me to secure the housing I needed faster than I would have had I gone through the court eviction process. It made it so that I didn't have to stay in homelessness for more than 5 months. But no one should have to make the decision I did when I got that eviction notice. The choice between homelessness now to avoid having an eviction on my record or homelessness later from having an eviction on my record. Court evictions already have a grave influence on an individual's opportunity for housing. We must pass LD 913 to ensure that as court documents become increasingly public through online access, past eviction records do not cut people off from the housing that they so desperately need. Housing is a human right, and this bill will help protect that human right in the state of Maine. Thank you.
Thank you very much, Izzy, for presenting the testimony of Ben Martineau to the committee today. Are there questions from committee members for Izzy Ostrowski? I am not seeing any, so again, thank you very much for your time and testimony today. It's greatly appreciated. I will now return to the attendee room to see if there are any other persons who wish to testify in support of LD 913. If so, please raise your electronic hand. I am not seeing any. I will now ask if there are any persons who wish to testify against LD 913 to please raise your electronic hand. And I would ask Committee Clerk Panett to please move over Representative Amy Arata and Daniel Bernier as panelists, and I will call on them as soon as they're moved over. Representative Arata, as soon as you are able to do so, please activate your video. Welcome to the Judiciary Committee. It's nice to see you again. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you. It's nice to see you too, Representative Harnett and Senator Carney and distinguished members of the Judiciary Committee. As you may know, my name is Amy Arata and I'm your colleague in the State House. I was a member of the Commission to Increase Housing Opportunities in Maine, along with Speaker Fecteau and Senators Pouliot and Hickman. And one of the strategies the Commission developed was to get more regular people involved in the housing business by encouraging the development of up to 4-unit properties. These small multifamily homes are more likely to be owner-occupied and owner-managed, with the pride of ownership that makes good neighborhoods. However, property management is not an easy business. I'm often asked why anybody would want to be in this business. I'm sure you've heard the horror stories of tenants who trash their apartments and terrorize their neighbors. In fact, 3 landlords were murdered just last year. You've also probably heard of so-called professional tenants who get into an apartment with a plan to refuse to pay. They take advantage of the judicial system by delaying eviction until after living in an apartment for free for a substantial amount of time. All of these things can bankrupt a landlord. This is why new landlords are counseled about how important an eviction records check is when screening potential tenants. However, LD 913 will make it difficult to do this, resulting in bad experiences for new landlords, so fewer people choose to become housing providers. In order to increase the supply of good quality housing and thereby lowering market rent, we need more people to choose to become housing providers, not fewer. More information about eviction history should be available, not less. This would allow a conversation to take place between the tenant applicant and a landlord so that they can make a good decision. Also, as the housing supply increases, more landlords will be willing to fill their vacancies with those who have an eviction or other issues. But in order to do this, we need to increase the housing supply and not scare away potential landlords. So I'm asking you to please oppose LD 913, which could decrease the housing supply. And I'd be happy to answer any questions. And I will submit my written testimony as well.
Thank you, Representative Arata, and you took away the first question that I had for you on your testimony. Are there questions from committee members for Representative Arata? Senator Keim.
Thank you for being here, Representative Arata. Could you, and I'm sure this is something that we could get for work session if you don't know sort of more off the top of your head, but what generally is the time frame and cost around an eviction? Like if you were given notice to a tenant at X date, when generally are they getting actually moving off the premises? Just sort of two like best case, worst case scenario on both those, if you could give it to us.
Well, it's been a long time since I've done an eviction. I always try to work with my tenants if there's a problem. But in the past, before COVID, it would probably take about 3 months before somebody would finally be removed. But now during COVID, with everything backed up, I'm not sure. I mean, I've heard some horror stories, and that's if everything goes perfectly. So these professional tenants, they know what to do. They sometimes get free legal help, and the landlord is usually somebody's grandma who's trying to rent a unit and doesn't always know what she's legally entitled to do. But these professional tenants will do things like request a jury or, just they know ways to get more time. And so if you do a Google search on professional tenants, you'll find a bunch of horror stories. It can be pretty bad. Did I answer your question?
Yeah, so you're saying generally when things go well, it will take about 3 months. An eviction would take 3 months.
If everything goes perfectly.
And if it doesn't, then it's just who knows after that. And then the cost to the landlord for an eviction, do you have any idea on data for that? Or even someone after you might, so it's all right if you don't.
A lot depends on if you hire a lawyer. If you hire a lawyer, it's probably, that the legal fees plus the court costs and the FED, all these things, delivery of the notices, because it's not just me telling the tenant you need to get out. There's a process they have to go through. I'm thinking a couple $1,000s. Okay. And the next testifier might have a better idea because it does that more often than I do.
Yeah, thank you for that. I appreciate it.
Sure.
Thank you, Senator Keim. Representative Thorne.
Thank you, Mr. Chair. Welcome, Representative Arata.
Thank you.
Just a real quick question. I'm not a landlord, so I don't know, and you alluded to it, mentioned to it. Is there a list out there of problem tenants that somebody would be on, that you as a landlord would be able to find out from the Housing Commission or whoever, that maybe these people have a history of being trouble tenants?
No, there's no list that I know of. There are eviction lists, and I was listening to the previous testimonies. I believe someone has to be actually evicted and found to be in the wrong in order to be on an eviction list. I don't think that they're just merely being on the docket is enough to get you on an eviction list. Of course, in the state of Maine, it is difficult to get this information. What I would like to do is actually have more information, because I've had as part of a screening process, I would find out if a person's name comes up, if they've been evicted, and that's available right now. People going in by hand and getting names, and sometimes they're very common names. So if I had more information, such as who the plaintiff was and where. What was the address of the eviction, then I could find out if it's actually the same person or not. So I would rather have more information rather than less. And I've had a couple times where I've done some digging and have been able to find out, hey, this person didn't even live in the jurisdiction of the court that did the eviction, because I look at the credit report and their address history and say, oh, well, he never lived there, so he's telling me the truth. Most landlords are willing to have a conversation and not just automatically say no if someone has had an eviction. But it's important information to have, because there are those out there who just take advantage of the system repeatedly, and it's not just a one-time mistake. So. And
ultimately, that decision is up to you.
Well, right, and it's not like landlords are going to leave a unit vacant indefinitely. They're going to put somebody who's been a good tenant in the past in there. They deserve housing too. Right now, I guess it's difficult for everybody to find housing, especially people with pets and things like that. So they need a chance too. Just because you've been a good tenant in the past doesn't mean you should be at a disadvantage. So.
Thank you. That was helpful. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions for Representative Arata? And I am not seeing any, so again, thank you very much for your time and testimony today.
Thank you.
The next person registered to testify in opposition to LD 913 is Daniel Bernier. Welcome back to the Judiciary Committee. Please begin your testimony of 3 minutes as soon as you're comfortable.
Good morning. My name is Dan Bernier. I represent the Central Maine Apartment Owners Association. whether or not someone has been evicted is very relevant as to whether or not they will be a good tenant. In fact, for many years, landlords have been asking on applications, have you ever been evicted, but asking the tenant to essentially self-report. Tenants also have an unlimited ability to get any eviction action that's brought against them dismissed by simply moving out and handing in the keys prior to the court date. And I've met tenants 5 minutes before hearing at the courthouse. They've handed me the keys. We've walked in and dismissed the case. And one thing I want to be clear is when I testify against the amendment, I'm particularly against sections 1A, B, and E. And I think F, 3 years is too short. A couple of the other sections I have less issue with. Landlords have a legal right to ask a tenant to leave the property that they own. They have to give them proper legal notice and they have to comply with the lease. If a tenant refuses a lawful request to leave is when an eviction action is brought. In fact, if you go to the court website and pull up their standard complaint for evictions, that the court recommended wording in paragraph 4, it says the defendant has unlawfully refused to quit the premises and still refuses to quit the premises. An eviction is an action dealing with an unlawful refusal to leave. When I first started practicing almost 30 years ago, it was extremely rare to request a writ of possession, the document you get at the end of a eviction on a tenant. I probably did it in 1 in 50, maybe 1 in 100 cases. That's the document you need to remove them. About 15 years ago, people started advising tenants, you know, you can stay at least till 9 days after the hearing. You have a right to do that. And that is technically true, but that advice came with the consequence of you have an eviction on your record. And the people who gave that advice need to take some responsibility for that it is not in the interest of the tenant to push it all the way to the last day. Today in my practice, I request writs of possession on probably the vast majority of my cases, I guess somewhere around 80%. And I probably enforce them where we send the sheriff out to serve them with a writ of possession on probably about half my cases. Very different from the 1990s or the early 2000s and what was going on. When we talk about evictions, over the last 30 years, I've probably handled over 2,000 evictions. I'd say somewhere between 2 and 3 would be my best guess. I've lost 3 cases in those 30 years. 2 of those were on procedural grounds where we came back a month later and got rid of the tenant. The only substantive case I've ever lost in 30 years was one of these leases with an option to buy, which I think are a nightmare for landlords. Up here, landlords lose those. The one last thing, when I'm running out of time, I would point out that I feel that C and D do have some merit, but where I've run out of time, if anybody's curious why I think they have merit, I'd be happy to answer a question on it.
Thank you very much, Mr. Bernier, for your testimony today and staying within the 3 minutes. Questions from committee members. I will begin with Senator Keim.
So I take the bait on the items that you think are important, but before you go to that, you mentioned that the evictions, I think you said in the early 2000s, I think is what you said, were very different than they are today. And I just wondered if you could explain that, what kind of comparison you were making there and what the difference is.
Well, it's I had to do it quickly. Understand, you serve a tenant a notice, you have a hearing. If you win at the hearing, 7 days later, you can get a writ of possession when the appeal period expires. The writ of possession is the document which allows you to remove the tenant from the premises. You send the sheriff out to serve the tenant with a writ of possession, and they have to leave 48 hours later. That's where the 9 days from the hearing, after the hearing comes, 7 plus 2. The reality is nothing works as fast as it's supposed to, so it's really probably closer to 2 weeks. In the 90s and in the early 2000s, you almost never had to request a writ of possession. I'll confess the first time I had to request one, I'd been practicing for about 5 years, and the clerk had to explain to me how to request it. I didn't know because it was just so rare for a tenant to still be there at the end of the 7 days. Today, it's pretty routine. I request a writ of possession on practically every case we get judgment, and we're probably serving about half of those on tenants, where we're actually having to send the sheriff out to remove the tenant. It's significant, and it kind of ties into why I think C and D have some merit. In the old days, tenants used to often just move out before the hearing and you would dismiss it. That's important because if you have an eviction on your record, you're also not eligible for Section 8 housing vouchers. And why I think C, which is that we're not going to publish if it's been dismissed or there's been a motion to vacate, the tenant who walks and meets me at the courthouse 5 minutes before the hearing and hands in the keys rather than forcing us to go through a hearing, I tend to agree they should be rewarded for doing that. And I also will do a lot of motions to vacate if a tenant makes an agreement, doesn't damage the premises, and behaves themselves on the way out. I probably hand out motions to vacate, far more often than I should. And so I think those two have merits because those are ways as a landlord's lawyer, you can offer a reward to a tenant who's behaving themselves properly. And the judges will routinely sign the motions to vacate. Quite frankly, I just say the parties agree and the judge will sign it. I don't have to give them anything beyond that for a reason. And so I tend to think, now maybe that this should be done by court rule, not by statute. I think there's a debate, but I do think cases that get dismissed and cases that get vacated, those are handy tools to offer a tenant who's behaving themselves that they will not have it on their record. And I actually use those tools all the time as a landlord's lawyer already. So I guess did I answer your question?
Yes, it does. And then hopefully we can get the court to talk about whether or not C and D that could be done by court rule. Thank you so much.
Thank you, Senator Keim. Representative Moriarty.
Thank you, Mr. Chair. Mr. Bernier, I need some information on the status quo. Under the law court adopted rules of electronic courts systems, what rules, if any, apply to eviction proceedings currently?
You're catching me. I haven't reviewed that rule. I mean, this is the whole getting evidence of electronics. I don't think there's anything in particular where evictions have been singled out that I've heard of, but I'm not going to confess that I didn't read that rule before the hearings.
Okay.
Historically, you could only get them on paper. And to be honest, there were some landlords who would go take a snapshot of the court docket outside the courtroom with their phone. And they'd take a picture of the list of evictions. And in some ways, I think we are better off having quality information produced by the courts than having somebody taking a snapshot on their phone. So I actually see this bill as hurting tenants in a way because the ways you're getting information right now are not terribly high quality. And when you get it directly from the courts, I think the quality of the information will be higher.
A follow-up, Mr. Chair?
Yes, you may, Representative.
To that latter point, Mr. Bernier, today, if a major tenant chooses to go to the courthouse and to physically inspect records, are eviction records isolated separately within the court system for easy reference? Are they commingled with everything else that takes place in district court? And how often do people make the trip down to the courthouse?
Nobody I know of. And I've had some of the associations come to me and ask advice for how they can do these things. Nobody I know of goes to the court and says, can I look through your eviction files? And I don't know that the clerks, you'd probably get on the really bad side of the clerks if you did that. And staying on the good side of the clerks is probably the most important thing in eviction practice. You do not get on their bad side. The one thing you had, and of course the courts for some reason, I don't know if somebody talked to them, are no longer posting the docket for the day up. It used to be posted right outside on the bulletin board where you could see the list of evictions for that day. The only way I know of people that were doing that was they're going in with their phones, taking a picture and assembling a list of the names on the list. And part of the thing where I think we'd be better off giving the information, that obviously doesn't tell you did those cases get dismissed or what. And so I think the quality of the way information is gathered now is poor. And this, if we can actually get the information from the court, I think it would be better for tenants because it would be higher quality information.
Well, do members of the association that you represent, to your knowledge, go to courthouses and ask for this information?
I don't know if anybody's ever gone to a courthouse to ask for the information other than, like I say, the phone snapshot piece on the day of the hearings.
Thank you.
Thank you, Representative Moriarty. Representative Hagan, I saw you had your hand up. Are you okay? Okay. Thank you. Are there additional, Senator Keim?
Thank you. Yes, just because of what you just said then makes me have a further question. So how are landlords getting eviction information if they're not going to the courts getting it?
Right now, they will ask you on your application, have you ever been evicted? Now, understand, landlords vary a lot in how much screening they're doing.
Right,
So they'll
of
ask you,
course.
have you ever been evicted? And they might ask you for your prior landlord's phone numbers to call some of your prior landlords. That is how they would get that information. And, you know, of course, a tenant can just not say anything on the application. When you get the prior landlord's phone number, sometimes you'll find out they gave you the phone number of a friend. One thing I've always been surprised about over the years is how many people who get evicted find another apartment. I mean, here, Waterville's my hometown. I can think of one guy I've evicted at least 5 or 6 times at this point because he keeps finding a new landlord who will let him in. And so people, my experience in general is people who've been evicted find a landlord who lets them in. How they do it, I don't really, you know, some maybe they're not good screeners, some maybe, I don't know. I do think as a consequence of the COVID restrictions on evictions, landlords probably are doing more screening now than they ever have, because when you make it harder to evict, landlords start screening more on the front end. And that's been kind of one of the consequences of the COVID restrictions.
Okay, so they're not going to the court to get the information. They're just getting it in a roundabout way. Okay.
Correct.
Okay, thank you.
Thank you, Senator Kime. Are there additional questions from Mr. Bernier? And Representative Babbage.
Oops, I'm sorry, I didn't realize I wasn't on video. Excuse me. Thank you, Mr. Chair, and thank you for being here, Mr. Bernier. I just wanted to say that when we go to work session, I really appreciate knowing people's points and the justifications for them. You've given us a lot to think about here today, Mr. Bernier, so I'd really appreciate you providing written testimony if you could.
I will do that and get it to you by the work session. And I often like to hear what the sponsor has to say before I start attacking their bill too much, but I will see that you get my points in writing.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Babbage. Additional questions for Daniel Bernier? Seeing none, thank you very much for your time and testimony today. We appreciate your input. Now going back to the attendee room, are there additional persons who wish to testify against LD 913? I am not seeing any. I would ask if there are any persons who wish to testify neither for nor against LD 913. Ask Committee Clerk Panett to please move over Julie Finn as a panelist. Thank you, Committee Clerk. Welcome back to the Judiciary Committee. Julie Finn, please begin your 3-minute testimony when you're comfortable.
Good morning. Thank you, Representative Harnett, Senator Carney, members of the Joint Standing Committee on Judiciary. My name is Julie Finn and I represent the judicial branch, and I would like to provide some information regarding the amendment contained in the committee file and dated 2/16/22. As you know, the judicial branch is in the process of transitioning from a paper-based file system to an electronic e-filing system. The first courts to adopt the electronic system are in Bangor and in the statewide Business and Consumer Court. Other parts of the state will come online one by one as we move forward with implementation of the Odyssey project. Recognizing that access to electronic files is very different from access to paper files housed in courthouses, the judicial branch engaged in a lengthy public process that involved multiple public hearings and acceptance of testimony from several interested parties. After reviewing this material and balancing the competing interests of public transparency and personal privacy, the Supreme Judicial Court issued the Rules of Electronic Court Systems, which we call RECS for short. These rules establish 3 layers of access for non-parties: no public access to certain case types or file materials; 2, public access of materials only at a courthouse; and 3, remote public access from any device with internet connectivity. The RECS rules are linked in my testimony if you would like to review them in full. With respect to evictions, small claims, and foreclosure cases, The Rex rules draw a bright line between pre-judgment and post-judgment case materials. In these three case types, the files are viewable only at a courthouse up until the time a judgment is issued. After judgment, the file information may be viewed remotely. This decision was made in part to create an easily understandable rule, the administration of which would not be overly complicated. In reviewing the amendment to LD 913, the same analysis applies. If the statute requires multiple levels of scrutiny and includes different treatment of similar outcomes, the result for the judicial branch will be more complex and more expensive in terms of programming and implementation. That said, there are several specific questions that we would like to raise regarding this legislation. First, the phrase "no wrongdoing alleged" in subsection 1A is undefined and somewhat vague. It really would be very helpful to us if the same language that describes different grounds could be used there. I just have a few more things I'd like to point out. I'll wrap up quickly. Subsection 1E and 1H may require a judge to make findings. The section on the COVID-19 health emergency, not sure if that has been mooted or not. And in that same section, that mentions consumer debt cases. However, this case type is not referred to in other parts of the proposed amendment. And finally, personally identifying information in subsection 2, this is really important. The amendment would allow names, addresses, and personally identifying information other than names to be provided. We cannot do that. We do not release that information. The Rex rules allow the release of names only and only after judgment if the judgment finds against the defendant. The judicial branch defers to this committee and the full legislature with respect to important policy decisions regarding online availability or unavailability of file materials. We will assist the committee as needed. Thank you very much for your consideration and for a little bit of extra time.
Thank you very much, Julie Finn. As you know, you have time in the bank from all of your testimony that's been under 3 minutes in the past. Are there questions from committee members for Julie Finn? If so, please raise your electronic hand. Representative Moriarty.
Thank you, Mr. Chair. Ms. Finn, I just wanted to ask about the lengthy process that you and the department undertook. Do you recall whether landlord-tenant problems were a significant part of that process?
I'm not sure I understand your question, whether evictions were one of the major portions of this that folks testified on. Yep. Yeah, I think there was a fair bit of testimony on evictions. It's certainly been of interest. We also had a fair bit of testimony from the media, which I haven't seen here today. But we had several different iterations of the rule, and it took a very long time to get where it is. That said, it is absolutely the purview of the committee to draw the line wherever the legislature sees fit. The court drew a line and a bright line at judgment. And
so currently, and I gather it's only in Bangor for the time being,
correct.
Under Rex, an inquiring party can get only the name of an individual and a judgment against a tenant who would have been the defendant in the eviction proceeding.
Correct, after
That's
judgment.
It? And that's it?
Yes, that's the way the rule works at the present time. So in other courthouses, we, as you know, we still have paper files.
Sure. Okay, thanks very much.
Thank you, Representative Moriarty. Are there additional questions for Julie Finn from committee members? Senator Keim.
Thank you for being here, Ms. Finn. So Dan Bernier testifying earlier, I don't know if you heard him, said that he felt that C and D had merit, but he didn't know if it could be done by court rule. I didn't know if you could comment on that now, or maybe comment on that for the work session. His suggestion on those two.
Well, a couple things about those two. I think as Senator Carney asked a question earlier about the language about part of a court case or government action, the application of this amendment is a little bit unclear. I mentioned that as well about, whether the consumer debt applies. At the very top in the first paragraph, it says small claims and FED. It seems like they mean only, but then it goes on and talks about other cases. So I think that language, which is in both C and D, might need to be cleaned up. Under our current rules, if they're resolved in favor of a defendant, our current rules already, they would not, the records would not be available. Set aside or vacated, that's a little less clear. I'd have to come back to you about that one.
Okay, and then just another question, sort of out of curiosity, but he also said that the courts are no longer posting the schedule of the day. Is that a change in policy, or how what is that referring to, do you think?
I'm actually not sure about that. That would be a courthouse to courthouse thing where some courthouses post a list on the wall, or we have electronic boards for that. As far as I know, I actually don't know the answer to why that isn't happening.
Okay, so if you could just look into that and get us that information. I recognize it isn't necessarily just germane to only this bill, but I'm just curious. Thank you.
Sure.
Thank you, Senator Keim. Are there additional questions from committee members for Julie Finn? And I am not seeing any. Thank you very much for your time and testimony today. The committee greatly appreciates your input.
Thank you.
I'm going back to the attendee room for the final time on this bill. Are there any other persons who wish to testify neither for nor against on LD 913? Seeing none, having heard testimony from all members of the public interested in testifying on LD 913, I will now close the public hearing on that bill and extend the committee's thanks to the bill sponsor, Representative Hassenfuss, and all those who testified before us today. Thank you very much. The next bill that we will hear is LD 1945, an act to regulate the use of biometric identifiers. I would ask that the bill sponsor, Representative Margaret O'Neill, please be moved over as a panelist. Representative O'Neill, nice to see you before the Judiciary Committee again. Welcome, and please begin your testimony on LD 1945 as soon as you're comfortable.
Thank you, Mr. Chair. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Maggie O'Neill. I represent House District 15, which is in Saco. Thank you for the opportunity to present LD 1945, which is an act to regulate the use of biometric identifiers. It's no secret that our personal information is collected, used, and monetized at an alarming rate. As people subject to data collection, we often aren't given an alternative. I sponsored this bill to protect our personal data and to give us more of a choice as Mainers. Specifically, this bill will put guardrails in place to protect our biometric identifiers. Right now, I'm a law student at UMaine, and the idea for this bill came from my privacy law classes. There's a similar law in Illinois that has been very important for changing big tech company behavior. I drafted the bill with input from faculty and national consumer privacy experts. Some of those folks are here today: the Electronic Privacy Information Center, EPIC for short, which is a public interest research center that's dedicated to protecting privacy, and also the ACLU's Deputy Director of Speech, Privacy, and Technology is here with us. I encourage you to see them as resources and ask questions and request information for the work session. I've also consulted with a range of stakeholders, including co-sponsors from both parties, young people, seniors, and local business leaders. I've also consulted with the AG's office. Attorney General Fry has submitted a letter of support for the bill that you can find in the written testimony section of your file. After the public hearing, I'll bring suggestions from various parties in the form of a friendly amendment at the work session, because I could see there were a lot of things that folks had raised. So I have a lot of good information to share today, and I'm happy to bring back more information at your request. So first, I'll start with biometric data. What is it? What are biometric data? Biometric identifiers are things like fingerprints, retina or iris scans, the sound of our voices, or scans of our hand or our face geometry. Because they are biologically unique to you, they can be used for authentication, for example, accessing a secure facility, with your thumbprint, or unlocking our phone by holding it up to our face, and for tracking or surveillance. Biometric identifiers don't include plain photos or videos. We're talking about things like scans of your face and scans of your fingerprint that can be used to identify you. Biometric data is extremely sensitive to identity theft and abuse. It's unique to you, it identifies you, it's easy to collect, and you can't change it in the event of a breach. The harm is done once your data is compromised. That's because once it's out there, there's no recourse because you can't change your face or your fingerprint. Think about how scary it is when you get a notification alerting you that someone stole your password or your bank information. With biometric identifiers, the consequences are even more permanent. Unlike a credit card or even a social security number, our biometric data can't be revoked or reissued. They aren't like passwords that can just be changed. Once we lose control, we're identifiable forever. Our stolen identifiers could be used to gain access to our sensitive accounts, our cell phones, and more. They can also be used to track us. Just as an example of some breaches, a company named Pay by Touch had 3.7 million fingerprints on file. When they went bankrupt, those fingerprints linked to financial accounts were considered assets that could be sold. In another example from 2015, hackers stole over 5.5 million fingerprints from the federal government. Those kinds of data compromises make us incredibly vulnerable. It goes without saying that biometric data must be treated with exceptional care. Its misuse can expose us to significant harm, including increased risks for fraud, scams, and identity theft. The next thing I want to touch on about biometric data is imperfect technology and disparate impacts. In addition to data security concerns, biometric surveillance technology is prone to make mistakes. These mistakes could impact anyone. Any of us could be wrongly identified, wrongly ejected from a business, or have the police wrongly called on us for a crime that we didn't commit. Even if this technology was perfectly accurate, it would still be a nightmare for our civil liberties. Face recognition technology and other biometric surveillance gives governments, companies, and individuals the power to spy on us wherever we go, tracking our faces at protests, political rallies, places of worship, the doctor, and more. We know the burdens of biometric surveillance are not borne equally, as Black and Brown communities are already targets of discriminatory surveillance. Making matters worse, face surveillance algorithms tend to be worse at accurately analyzing the faces of people who have darker skin, women, the elderly, LGBTQ community members, and children. Simply put, the technology is dangerous when it works and when it doesn't. That's why Maine has already banned government use of face recognition technology. That bill passed unanimously through both bodies of the legislature last year. This bill really continues that work. It goes to the root of the problem by giving us control over whether this sensitive data gets collected in the first place. Facial recognition and other biometric surveillance, other kinds of biometric surveillance technology, infringe on our freedom to live, work, and act without being watched, followed, or tracked. Folks here today, ACLU, Data for Black Lives, GLAAD, Equality Maine, Maine Transnet, and EFF will all be able to speak to this. A couple things I want to cite just as examples. Employees of color whose companies use facial recognition to monitor their activity at work were kicked out of the system more often than their white colleagues. A couple examples with young people. In Detroit, a 14-year-old was kicked out of a skating rink, even though she had never been there, because the facial recognition system matched her to someone else by accident. And there's another story where Apple wrongly accused a young Black teenager of shoplifting in New York, in part based on facial recognition. And Rite Aid installed more facial recognition, collecting cameras in areas that were less wealthy and less white. In areas where people of color, including Black and Latinx residents, made up the largest racial or ethnic group, Reuters found that stores were 3 times more likely to use the technology. After negative media exposure, Rite Aid stopped that practice. Right now, there are no rules. Despite how sensitive biometric data is, there are 0 restrictions for the ways corporations can collect, use, and even sell our personal, unchangeable biological characteristics, such as our fingerprints and our face prints. Companies can collect our biometric identifiers without our consent, and there are no rules regarding how long they can keep them or what they can do with them. Corporations don't have to tell us how or when they are using, aggregating, or even selling our data. They don't have to tell us how they are collecting our data, analyzing it, or storing it. They don't even have to tell us who will have access to it. We deserve to know and to have choices. And I think most people would be surprised to learn that this data isn't protected already. A recent poll from Morning Consult across the country actually showed that 88% of voters think that we as lawmakers should act to protect our biometric data. So next I'm going to go through what the bill does. And essentially it provides guardrails for biometric identifiers, where we've established that there aren't protections right now. So first, what it does is it requires companies to get our consent. If a company wants to collect biometrics, the company has to get our express written consent before collecting them. This provides notice to people that something serious is being asked for, and it gives us a choice about whether we want to give it away. In Illinois, this consent can be pen and paper or digital signature. In an employment context, this can be as simple as signing a form with your employees. The second piece is no discrimination. Under this drafting, companies wouldn't be allowed to treat us differently or deny us service if we don't consent. As an example, you could use a password instead of your face for unlocking a phone, if that's what you wanted to do. Next, there's a ban on the sale of biometrics. The bill would ban companies from selling our biometric data. The way it's drafted currently doesn't reflect this, and that was just a drafting error on my part. So I'll present a friendly amendment at the work session to that effect. Next, it will require that companies use reasonable data safeguards. The bill says that companies can't keep our data forever, that they can only hold on to our data for a limited amount of time once they collect it and they're finished using it. It also requires companies to use appropriate safeguards to protect our biometric data while they hold on to it, and to make their data retention policy available to the public so that we can see it and see what their policy is. Upon request, companies must tell people what data they have about us. This means that you could reach out to Facebook or Amazon and ask what kind of biometric data they have about you. You could also find out where they got it and who they shared it with. If a company doesn't collect biometric information, they won't have to worry about this requirement. And next, there's a distinction in the bill that it makes a distinction between data collectors and companies that process data according to a contract with another company. This is a common distinction in privacy regulations, and it's my understanding that this was an accommodation to business requests. But I'm happy to take input from folks about how that distinction works. Next, it allows regular people to pursue violations of the law. And this is the really important part. It's the teeth of the bill. The bill creates a private right of action for individuals harmed by violations of the statute. Statutory damages can reach $1,000 for negligent violations and $5,000 for intentional or reckless violations. A privacy law is really only as strong as its enforcement tools. And the best enforcement tool is a private right of action. In many cases, government agencies can't or won't enforce a statute. Regular people have to be free to protect their own rights. Including a private right of action is how legislators normally approach privacy laws. Many privacy statutes contain a private right of action, including federal laws on wiretaps, stored electronic communications, video rentals, driver's licenses, credit reporting, and cable restrictions. I've also listed other kinds of laws that protect the public, including federal laws on clean water, employment discrimination, and access to public records. Big tech companies told Congress for years that they could self-regulate. They haven't been held accountable. Now, as public opinion has shifted, they work to block protective laws like this one and to pass weak laws to shield their companies. Their opposition indicates that this law will actually hold tech companies accountable. Other states have laws like Illinois, but without a private right of action in the law. And this should tell you all that you need to know. The Illinois law passed in 2008 with a private right of action, and a similar law passed in 2009 with only AG enforcement in Texas. And since then, people in Illinois have been able to bring cases to court and change the behavior of big companies like Facebook. In Texas, after more than a decade, the AG filed their very first suit last week. And it's essentially a replica of a successful Illinois lawsuit that shifted Facebook's behavior globally, called Patel. Texas is now filing for the first time to get its cut of the money, but it never would have filed suit if not for the success of the Illinois law. Without a private right of action, Mainers will not have accountability. AG's offices have limited resources to fight the biggest companies in the world. That's why people need to be able to take these companies to court themselves. The only way to actually have biometric privacy is to enforce biometric privacy laws. Big companies know that, and that's why they oppose the private right of action. They don't want to be accountable to you or to me. On another note, the law in Illinois doesn't require a plaintiff to prove an injury beyond a violation of the statute itself. Likewise, this bill's private right of action will be triggered when a private entity fails to adhere to the statutory procedures, because our right to maintain our biometric privacy vanishes when the law is violated. And the last part of the bill I want to cover is that the Attorney General can also enforce the law. The AG's office can also step in to defend consumers. The office has provided feedback on language, and I'll present an amendment at the work session. To be clear, the Maine AG's office doesn't have the resources to battle Facebook and the other most powerful companies every day. But this is a good option to supplement the private right of action, which is the real teeth of the bill. I looked into this with experts. There is precedent for multiple ways of enforcement. Just one example is the Telephone Consumer Protection Act that has 3 ways of enforcement via private right of action, FCC, and AGs. So you'll hear from opponents today. They're going to make this sound really scary. They're going to drag out tired arguments about our civil legal system, saying that we should leave it to government regulators, that this bill will only be good for lawyers. Corporate lobbyists have attacked our civil legal system for a long time because they know that it's one of the only places that a regular person like you or me can hold them accountable. That's why they came here, to be here from DC. It speaks to how important this law is to give us a choice.
Point of order, Madam Chair.
Representative Thorne.
Sorry, Mr. Chair. It seems to me that we're always told not to question others' motives, and it seems like that's what's being done right now. And I just wanted to, hear from Representative O'Neill in her own words on her own site, not speaking for other people and their motives or what they'll be doing later. Is that plausible?
I would ask Representative O'Neill to continue with her testimony. I don't see this as a personal attack or questioning motives, but focus on the bill and why it should be enacted rather than testimony that we might hear from opponents.
Thanks. I'll continue and just know that, arguments, rebuttals are part of speaking about your position on a bill. So I just think the opposition that you might see for big companies speaks to how important the Illinois law has been for holding companies accountable. As I mentioned, the law in Illinois has gotten companies like Facebook to change their behavior. I talked about how for almost 10 years, Texas had a similar law in the books that doesn't let people bring a claim in court, and that they filed their first enforcement action against a company this week. And I did want to tell you a little bit more about that suit, which is Battelle versus Facebook. Facebook settled for $650 million, and they agreed to change their practices globally and get opt-in consent before collecting biometrics. And that was a direct result of that strong law in Illinois. Facebook was harvesting and storing users' facial data from photos without asking for our consent or providing notice. So that Illinois case and that strong law made Facebook change their actions, not government regulators. The truth is, businesses have been asking lawmakers to not regulate their data practices for a very long time, and we can see where that has gotten us. Civil liberties, human autonomy, and democracy are all threatened. This bill is targeted to very specific and incredibly vulnerable data. To corporate lobbyists that have taken the time to be here today, if you are in the data collection business, you are in the data protection business. The stakes for individuals who consent to the use of their biometric data is extremely high, and the consequences for mismanagement of our data should be equally high. Companies already have a choice. If they can't take adequate steps to protect biometric data, they shouldn't be collecting it in the first place, period. So why are they so opposed to us having a choice? And it's about profit. Big data is big business. And again, I want to emphasize that if a company can't protect our biometric data, they should not be collecting it in the first place. A couple things that you'll hear about today and I want to address that I'll be working on. A note about financial institutions. Testimony from the banking lobby that's been submitted suggests that this law should not apply to financial institutions because of an existing federal law that pertains to them called Graham-Leach-Bliley. And the claim is that that is sufficient to protect consumers, so the law shouldn't apply to them. Financial institutions often come to public hearings for consumer privacy bills and ask for a total exemption on everything they do just because of this law. And it's important for us to have a conversation about how the law isn't super protective of consumers. That said, I won't die on that hill, and I'm willing to discuss this with the banks. I've reached out to them to set up a time, but I wanted to make sure I provided a little bit of info about that law. So Graham-Leach-Bliley, the federal law mentioned, does not preempt state laws that offer stronger protections, as this bill does. GLB has been criticized for being a weak privacy law. A longtime congressional staff person who drafted HIPAA and other landmark privacy legislation has commented that the privacy provisions of that law for financial institutions are so weak that consumers would actually be better off if Congress repealed the law. And the privacy part of that law really only does two things for consumers. First, they have to have a privacy notice. In 2022, banks are going to have privacy notices with or without this law. And second, the law provides that a financial institution that wants to share your personal information with a non-affiliated third party, which means anyone that's outside of the corporate family, has to give consumers the chance to opt out just under some circumstances. Even if a consumer doesn't opt out, the law prevents sharing of account and credit card numbers for third-party marketing uses, but the opt-out doesn't apply to joint marketing agreements with other financial institutions. That means that if one financial institution wants to share consumer information with another financial institution, it can do so through a joint marketing agreement, and consumers don't have opt-out rights. So that's the strong federal law that banks say protects you here. Limited opt-out rights and a privacy policy are clearly not the same as this bill. That said, I've reached out to our local banks to meet, so I want to be available and have a dialogue about it. I'm willing to accommodate their concerns within reason. I saw another thing that I wanted to address ahead of time. Folks had also suggested working this bill side by side with another one, which is LD 1982. Respectfully, that bill, my perception is that it's written to benefit industry, not Mainers. I reached out to the sponsor and he confirmed that he is actually removing the privacy component from the bill. So it's just something to keep in mind when you hear that and consider that suggestion. It wasn't his intent to benefit industry. He's a privacy advocate. And it's the reason I raise it is it's important to note during this discussion that there have been a number of Trojan horse bills written by tech lobbyists. And they're not just in Maine, they're around the country. Companies and industry groups are submitting them around the country to prevent legislatures from enacting real protections. In my testimony, I linked an article that's titled, "Big Tech is Pushing States to Pass Privacy Laws, and Yes, You Should Be Suspicious." The other privacy bill referenced by lobbyists, some of whom are here today, TechNet and State and Privacy Security Coalition, would enact watered down protections and repeal an important law in Maine that protects our privacy with internet service providers. Lobbyists have been trying to get rid of that law for a while. It's kind of like whack-a-mole keeping up with it. Good local internet providers like GWI supported that internet privacy bill, and it's important that we protect it. Leading up to this bill, I met with Fletcher Kittredge, who's CEO at GWI, and he supports this bill in front of you today. He submitted written testimony because his schedule didn't allow him to be here. But GWI is a good example of businesses building privacy into their business model. Not all businesses are fighting these laws. They know that privacy is important to their customers. Young people have also taken the time to tell you why this bill is important to them. I encourage you to take time to read their testimony. Many of them couldn't be here today, but they have to deal with our legislature's, actions or inactions, and they don't have a vote to cast. In closing, there are few rules governing the use of biometric identifiers, despite the explosion of technology that's gathering them. Other states, such as Illinois, have laws like LD 1945, and they have successfully protected consumers. I urge you to pass this bill so that Mainers can have the same protections. And thanks so much for your time.
Thank you very much, Representative O'Neill, for bringing this bill forward today. We appreciate your time and testimony. I will now open the hearing up to questions from committee members. If committee members have questions for the bill sponsor, Representative O'Neill, please raise your electronic hand and I will call on you in the order that I see them come up. I will begin with Senator Kine.
Thank you. Thank you for being here, Ms. O'Neill. Nice to see you. Representative O'Neill, sorry. My question for you is, when you were crafting this, did you consider the overlap between the information that the government collects on us as well, and try to capture, protection from the government actually using our data in this way, or were you just wanting to focus on business?
Thanks for the question. I'm absolutely concerned about both elements, and that's why I brought the scheme of privacy bills that I have brought to your committee. I brought a constitutional amendment, which has to do more with government. And this law, the way it's written, doesn't apply to government, and I think that's a really important piece. But something I took into account as I was drafting it, and that other states have talked about, is that a facial recognition ban is really the most important place to start. And Maine has already led on that and has the strongest protection in the country there. I think what's important about this law is there's really a corporate government partnership with this kind of surveillance. So if we go to the root of it and just try to use it only really when it's needed and use proper safeguards, then there will be a benefit on that government end as well, if that makes sense.
Yes, it does. Thank you.
Thank you, Senator Keim. Representative Moriarty.
Thank you, Mr. Chair. Representative O'Neill, as I try to get up to speed on this issue, I have a few sort of questions that are just really in the weeds. I'm looking at page 2 of the bill, and up toward the top is a definition of the term processor. And as I read it, it's any company that collects, processes, or stores identifiers, but on behalf of another entity. What if a processor collects and stores data and keeps it? I don't quite understand why the definition relates to a second company.
Thanks for raising that, and I'll do my best at explaining it. So very often there's a distinction in privacy law between the entity that controls the data. They might have a direct relationship with you, they collect it, they control the purposes that the data is used for and the terms. And they might not have the capability for processing, so they might contract with a processor. And the processor isn't controlling those kinds of things, they're operating according to a contract. So that distinction is something that came from some work that others had done. And it really was requested by businesses to reflect the way things really work. So that's my intent with it. And I'm happy to be in dialogue with people if they think there are tweaks to make it make more sense and reflect how things actually work. But that's the goal there, is you have the controller and the processor.
Okay, I've got another question, but I'll rotate back. Thank you very much.
Thank you, Representative Moriarty. Representative Galgay-Reckett.
I'm sitting here trying to figure out the major complexities of this bill, which seem on the surface to someone who doesn't delve in this stuff all the time, except I suppose I do delve in it, not knowing that I'm delving in it. But I'm remembering, I think it was a couple of years ago, I can't remember why, but we were dealing with a bill in this committee that had to do with the contracts we all sign when we say, I agree to this, in order to have whatever application it is we're going to put on our phone, and Facebook being at the top of the list. And I took on the assignment of reading the contract that we never read when we say I accept, because we want to do something. And it was quite astonishing. I couldn't tell you 3 words about it, but I remember being horrified that I signed it like everybody else does quickly. So my brain is focusing on Facebook in this discussion because that's the only one that I read, a couple, 3, but I don't even remember who the other companies were that I read that had all these details that we accepted as we went along. So I'm curious and I'm sitting here thinking about how I got onto my computer this morning, which I opened the thing and it recognized my face, and so it let me in. Sometimes it doesn't, and I have to put a password in, which now I'm thinking I should have done that all the time and to forget my face in the computer. So I'm really, I'm feeling like a not terribly educated consumer in this discussion. And I'm really glad that someone who, like yourself, who appears to understand what you're doing with this bill, whether one agrees with it or not. I mean, at least you understand what you're saying. Me, not so much. So I'm interested to know, just on a minor piece, you talk about the Illinois suit against Facebook that had essentially an impact on the Texas case. I'm asking if there was a case that affected everybody on Facebook, or not just the people in Illinois. And is that why they've changed sort of what they're doing with photos and piling up people with the same face and, you know, that kind of stuff that's going on right now, which, don't ask me the technical part of it. But the thing that I'm interested in is how much is one group of cases going to affect the whole blessed country, to the good or bad. So I'm just, I mean, am I out in total left field, or is that what was happening? That is happening with Facebook now, as an example.
Thanks for the questions. So I think what I'll say first about privacy policies is that we all agree to a million things every year. And there's old data, I think it's 10 years old, that said 10 years ago, it would have taken you 30 hours out of your year to read everything that you agreed to. And think of how much more it must be now in 2022. So you're right, there's a lot there, and it's a really good thing that we have public interest groups and press and others that take the time to read these privacy policies and protect our rights. So in response to your question about how the private right of action in Illinois has been very powerful and has protected everyone beyond just Illinois residents, the Patel suit is the best example that I can raise. And you're right that it was about facial recognition and not getting adequate permission. I'll let the folks behind me explain it a little better, but what I can say is that suit is a perfect example of how the law has had good results for people globally, because as part of the settlement, Facebook didn't just change their practices in Illinois to be in compliance with the law. They moved to get opt-in consent around the world. So that law really benefited all of us.
Thank you, Representative Reckitt. Representative Babbage.
Thank you, Mr. Chair, and welcome, Representative O'Neill. Perhaps this is a piggyback on Representative Reckitt's question. Early in your testimony, you mentioned that biometric identifiers don't include regular photos and videos. And, you know, I guess I want to ask why. It seems to me, I mean, if you're posting on Facebook, I realize, or do I, that the Patel case applies to Facebook only. But I guess what I'm saying there is the reason you said that because legally they're treated differently, or technology capacity, or why does it not include plain photos and videos that may be online? Thank you.
Thanks for the question. So I'll give you an example going back to Rite Aid. So Rite Aid could have security cameras. They could, they can have normal security cameras to monitor their premises and just, for security reasons. But under this law, something that would change is Rite Aid wouldn't be able to run technology that measures the face of everybody that comes through their store, collects that data, and then, runs it through some kind of a database to search who they are. And the people behind me can speak more to the mechanisms of that. But it's saying there's a difference between having a security camera and measuring your biological characteristics to identify you, and, collect that data. What are you doing with it? How are you saving it? Are you selling it? That kind of thing.
I understand your meaning now. Thank you. Thank you, Mr. Chair.
Thank you, Representative Babbage. Representative Moriarty, did you want me to circle back to you for an additional question?
If no one else is waiting, sure.
There is nobody else waiting.
Okay, thanks very much. So Representative O'Neill, back to where I wanted to be. The top of page 2, section 9602, says that a processor is not required to comply with the provisions of the law if that processor is under agreement with another private entity. I'm wondering why a processor who is sort of serving a middleman function shouldn't be held to compliance.
Thanks for the question. So if we go back to the elements of the bill, it's get consent, have reasonable data handling practices. There's that list, and pursuant to the contract, I think it should be taken care of. But I'll take another look at it to see and run it by the advocates here to see if they think it adequately addresses what you're raising, which is, should more stuff apply to processors?
This issue sort of comes up again at the bottom of page 3, section 9606, titled Prohibitions. And it says that a private entity may not collect, purchase, or receive this information unless they comply with the various prerequisites. So there it seems as though an initial processor is prohibited from collecting unless they themselves go out and get the permission and all the rest of it. Is that your understanding as well?
What can you tell me the citation, what line you're
referencing? Section 9606, titled Prohibitions, the bottom of page 3 as printed.
All right. Yeah, let me take a look. Honestly, I'm just too slow to look through it, and I think know what you're looking for. So what will you articulate the question one more time, and I'll take it down
sure.
for info.
Well, we've just previously discussed how a processor who sells to a private entity doesn't have to comply under section 9602. Here under 9606, it seems to say that a private entity may not collect, purchase, or receive any of this information unless they've complied with all of the prerequisites. And so the two seem to me to be in conflict with each other. Just as a heads up, I don't need an answer, but I would alert you that I see a conflict there.
Thanks for raising it. I'll take another look through it, and it was definitely on my list to go through this processor controller distinction with folks just to iron out the mechanics of it too. So definitely want people's input.
Thanks.
Thank you, Representative Moriarty. Are there additional questions for the bill sponsor from committee members? I am not seeing any. Thank you very much, Representative O'Neill, for bringing this bill. I'm sorry, Senator Carney.
Thank you. I was slow on getting my hand up. I am feeling a little like I've received a lot of detail, and I'm wondering, Representative O'Neill, before we start to hear from other proponents of the legislation, if you can just give us the top 3 or 4 benefits to consumers, to all of us here in this room in our private lives. We are consumers. Can you give us the top benefits to us and other consumers like us of this legislation, just to help us refocus a little bit?
Absolutely. So this bill is about really a specific subset of data called biometric data that has to do with measuring things like your face or your fingerprint or your iris or something like that to identify you. And this data is super sensitive. And once it gets out there, you can't roll it back. You can't change it like you can change your password or your credit card number. So that's why it's really important to make sure that companies that are collecting it get our consent. So that's the first part, is they get our permission to do it. And the second big part is that they use reasonable data handling practices, that they're responsible with our data. And the third big part of it is that regular people have the ability to hold companies accountable in court, because we know that just having regulators take care of it isn't enough, that we really need to be able to have our court system open so that regular people can enforce the law. And that's what we've seen among the different versions of this law. The one that's been the most powerful has been the one where regular people can go to court. So those are the big three, I think.
Thank you.
Thanks.
Thank you, Senator Carney. And I'll check as I miss Senator Carney. Are there additional questions from committee members for the bill sponsor? I am not seeing any. Again, Representative O'Neill, thank you for bringing this bill forward. It's the practice of our committee that the bill sponsor is allowed to stay as a panelist on for the remainder of the public hearing. I'd leave that up to you, but you're welcome to stay if you would like. I am now going to turn to the attendee room and ask persons who wish to testify in support of LD 1945 to please raise their electronic hand, and I will have the committee clerk move you over. I would ask the committee clerk to please move over Riona Fitzgerald, Nathan Wessler, and Mary Bonato. And I will begin with, and I know I'm getting this name wrong, but Kate Leona Fitzgerald. If you please activate your video and camera. Your camera and microphone. Welcome to the Judiciary Committee. I will remind all persons testifying to please state your name, residence, and any entity that you represent, and recognize that you will be on a 3-minute clock. And my co-chair, Senator Carney, will hold up her timer cell phone when you have about 20 seconds left, and then I will have you wrap up when you hit the 3-minute mark. So please feel free to begin, and welcome to the Judiciary Committee.
Thank you, Chair Harnett and Chair Carney and members of the Judiciary Committee. Thank you for the opportunity to testify today in support of LD 1945. I'm Katrina Fitzgerald, Deputy Director at the Electronic Privacy Information Center, or EPIC. For over 25 years, EPIC has been a leading advocate for privacy, and we've long advocated for strict limits on the use of biometric data. The passage of LD 1945 will be a really important step towards protecting the privacy of Mainers. This bill, as Representative O'Neill mentioned, is based on the Illinois Biometric Information Privacy Act, or BIPA. BIPA is one of the most important privacy laws in the country. And BIPA and LD 1945 set out a really simple privacy framework for protecting individuals' biometric information. It's 1, businesses may not profit from a person's biometric information. 2, businesses must delete biometric information after it's been used for the initial purpose. And they must obtain opt-in written consent before collecting biometric information. Most crucially, BIPA and LD 1945 include a private right of action that allows individuals to enforce their rights under the statute. And the private right of action is what has made BIPA the most effective privacy law in the country. The private right of action is absolutely essential to this bill, and it's the most important tool the legislature can give Mainers to protect their privacy. History informs us that leaving the enforcement of privacy rights up to government regulators just simply isn't enough. They don't have the resources, companies know that, and so they just continue on business as usual. They're willing to accept the small risk of enforcement as a cost of business. But a private right of action has truly proven to provide a meaningful deterrent that will prevent abuses. And a couple of years ago, news broke of a company called Clearview AI that had created a massive facial recognition database of billions of photos scraped from all across the internet. And just last week, the Washington Post reported on a presentation that Clearview has been giving to investors, in which it was telling them that it is on track to have 100 billion facial photos in its database within a year, enough to ensure, and this is a quote, and it's creepy, quote, almost everyone in the world will be identifiable. So Clearview likely has all of our faces in its database. And this company that none of us have ever interacted with then sells access to that database, profiting off our personal biometric information that they just found online. The only good news when it comes to Clearview AI is that BIPA is slowing it down. In 2020, Clearview said it would no longer sell access to private companies, citing BIPA as the reason for the change, and it terminated all contracts in Illinois, even with law enforcement. And that Washington Post article last week, Clearview CEO said that if they sold their database to any non-governmental buyer, they would first have to tell the federal court in Illinois because the suit is still pending. So we need more state legislatures to stand up and say that these blatant, dangerous violations of our privacy are not okay. And Maine, with its strong ethos of valuing personal privacy, is the perfect legislature to do that. This is urgent. It's Clearview today, but tomorrow it's the metaverse with its potential for eye and body movement tracking. As a privacy advocate, I'm fighting every day to deal with the regulatory and policy failures that allowed technology companies like Facebook and Google to commodify every tiny bit of our personal data. There were no rules of the road. They took advantage. And now it's just so hard to go back and change those business practices. So let's not make the same mistake with our biometric data. The stakes are just too high. Thank you for your time today. I respectfully request a favorable report, and I'd be happy to answer your questions.
Thank you, Katerina Fitzgerald, for your time and testimony today. Are there questions from committee members for Katerina Fitzgerald? And I am not seeing any at this point. So again, thank you very much for your testimony and for your, I'm sorry, Senator Carney, I have to look for your real hand.
I know I'm getting all confused. I'm sorry about the delay. Katerina Fitzgerald, could you, I am not at all familiar with EPIC, and I know you kind of gave us a little blurb about it initially, but can you tell us more about what EPIC does and what brought you to testify here today?
Absolutely. So EPIC is based in Washington, D.C., though I'm based in the Boston area, and I will give my Maine credentials. I'm married to a Mainer. My in-laws live in Gray, Rep. Moriarty. And so we litigate cases a lot of the time. We've filed a lot of amicus briefs in court in support of BIPA in those cases in Illinois. We have sued the federal government when it's used facial recognition without going through the proper procedures. And we've been around for 25 years. We do not take any funding from any corporations.
Thank you.
Thank you, Senator Carney. Representative Hagan.
Thank you, Mr. Chair. Quick one. I missed the name of the company that you said has billions of faces.
Clearview AI.
Clearview, thank you.
Yeah.
Thank you, Representative Hagan. Are there additional questions from committee members for Katerina Fitzgerald? Representative Hagan, I see your hand is still up. Are you done? You're set. Senator Keim.
Thank you. I have kind of a broad question. So Representative O'Neill mentioned the case that she said was most helpful to everyone against Facebook, and I think it was Patel that was the name of it. Mm-hmm. I'm wondering, what was the outcome of that case? I mean, what happens now because of that case for everyone? I missed that part.
Yeah, so last November, Facebook announced that it was ending its use of facial recognition to, when someone would upload a photo and it would automatically suggest who was in the photo because it was using facial recognition to identify the faces. They're not going to do that anymore. And that is basically in a direct result of BIPA hanging over their heads and various suits they were facing. So it's an Illinois law that's protecting us all.
So that is a direct result of the Patel case. Is that right? Is that what you're saying?
I'm trying to remember if it was specifically tied to Patel. I may have to get back to you on that, or whether it was more, they have been facing a number of BIPA suits, and I think got tired of defending them. But that was, I think Patel was the largest settlement they had to pay so far.
Okay, thank you very much.
You're welcome. Thank you, Senator.
Thank you, Senator Keim. Are there additional questions for Katerina? And I am not seeing any. Again, thank you very much for your time and testimony today. We greatly appreciate your input.
Thank you.
Next person I will call upon is Nate Wessler from the ACLU. Nate, it's been a long time, but nice to see you again. Welcome to the Judiciary Committee, and please begin your 3-minute testimony as soon as you're comfortable.
Thanks so much. It's wonderful to see you as well. Senator Carney, Representative Harnett, members of the committee, good afternoon. My name is Nate Fried Wessler. I'm a Deputy Director of the ACLU's Speech, Privacy, and Technology Project. I live in New York, but I'm a Mainer. I grew up in Maine, so I'm particularly delighted to be here this morning, if virtually, to talk to you all. At the ACLU, among other issues, I work on ensuring that people can maintain privacy and control over their personal biometric identifiers. This has included litigation under Illinois' path-breaking Biometric Information Privacy Act. On behalf of our members, the ACLU and ACLU of Maine urge you to please support LD 1945 because it would help protect Maine people from invasions of their privacy by private companies. As you've heard, biometric identifiers, including fingerprints, iris and retina scans, facial recognition scans, and voice prints, are unique to each individual. They can be used to instantaneously identify and track us, and if they're disseminated or if they're leaked, the harm may be irreparable because unlike a credit card number or even a social security number, they cannot be changed. Without strong and enforceable legal protections, Maine people will be left vulnerable to violations of their privacy, civil rights, and security. And although everyone will experience those risks, members of marginalized and vulnerable communities, including people of color, LGBTQ people, immigrants, survivors of intimate partner violence, and others, will experience some of the greatest harms. Abusive collection and use of biometric identifiers is becoming increasingly widespread, and it's really time for the legislature to act now. I want to recap the main provisions of this bill. I know you've heard it, but I think it's important to go over them to just underline this is not a ban. This is a set of reasonable guardrails. This legislation would require companies to provide notice and obtain written consent before collecting, using, or disclosing a person's biometric identifier. It would prohibit companies from withholding services from people who choose not to consent to collection or use of their biometric identifiers. It would require businesses to delete Maine residents' biometric identifiers at least 1 year after the person's last interaction with the business. It requires safeguards against unauthorized disclosure when an individual's biometric identifier is collected, stored, or used. And critically, it saves taxpayer dollars by empowering individuals to sue companies who violate their rights under the act. As you've heard, Illinois has a similar law. It's been on the books for more than a dozen years. Maine should follow suit. As a Mainer, I'm proud of this legislature's leadership, really national leadership in protecting Maine people's privacy in the digital age in recent years. This bill will ensure that advances in technology do not leave Maine residents vulnerable to abuse of their biometric identifiers by companies like Clearview AI or Facebook or Google or others. My written testimony spans 7 pages. I'm out of time, so I won't try to read more of it, but I direct you to it for more details. I urge you to please vote ought to pass, and I would welcome any questions, including about the critical importance of maintaining the private right of action in this bill. Thank you very much for your time and attention.
Thank you very much, Nate Wessler, for your time and testimony today. Are there questions? Well, let me start with one. You sort of teed it up. What is the importance of keeping a private right of action as opposed to just allowing government to enforce this right?
Yeah, so I think that experience has shown that state attorneys general, other regulatory agencies just don't have the resources, the person power to adequately oversee the thousands of companies out there who want to collect this information. And if you look at the experience of the 3 states that already have biometric privacy laws, you can see this play out in really concrete terms. In Illinois, where there is a private right of action, individual residents of that state have been able to sue companies like Clearview AI, like Facebook, as you've heard, like Google, like others. And those suits have resulted in changes to those companies' policies to start obtaining consent and complying with other provisions of the law. In Washington, where there's been a biometric privacy law without a private right of action on the books for a number of years, the state AG has never sued to enforce the law. And as you heard from Representative O'Neill, in Texas, where the law's been on the books for 21 years, only last week or the week before did the state AG sue for the first time in this kind of copycat action following an Illinois private action. I think it's tremendously appropriate for there to be concurrent jurisdiction for the state AG's office, consumer protection litigators, like what my father did alongside you, Representative Harnett, years ago in the state AG's office, to be able to step in. But that will never be sufficient given just the scope and scale of this problem.
Thank you very much. Representative Evangelos.
Thank you, Mr. Chair, and hi, Mr. Wessler. Just a quick question. Have there been any precedent setting, such as Supreme Court decisions or others, addressing our Fourth Amendment protections regarding unreasonable search and seizure? Where do we stand on our protections? And building on what Senator Keim had mentioned, I don't want the FBI and CIA doing this either. And what are our protections there?
Yeah, thank you for that question, Representative. So of course, as you all know, the Fourth Amendment applies to the government and not to private actors. And that's partly why it's so important to pass this legislation to get at questions that constitutional protections that run against the government just can never get to. It's also important, of course, to remember that when we're talking about federal law enforcement, as you raised, a state legislature just is without power to do a lot because of the supremacy clause. And so it often will fall to Congress or to the Fourth Amendment. We are looking very carefully at what police and at the federal, state, and local level are doing using face recognition technology and other biometric technologies around the country. Maine has best in the nation law to regulate and strictly limit how police can use this technology. We are on the lookout for the first law enforcement agency that decides they want to test out face recognition technology on live video. We think that would clearly be a Fourth Amendment violation and would be ready to sue immediately. I'm also counsel in a suit in Detroit, raising a Fourth Amendment false arrest claim on behalf of a man named Robert Williams, who was arrested based on a false face recognition match. Some video footage of somebody shoplifting a store in downtown Detroit was sent to the state police face recognition system. It incorrectly spit out Mr. Williams as a match. He's a Black man. We know that this face recognition technology works much less reliably on darker skinned people. And he was arrested and jailed for 30 hours, subjected to prosecution. And we're alleging that violated the Fourth Amendment because there wasn't probable cause. And the police should have told the magistrate judge in advance that they use this glitchy technology. So there are a number of theories under the Fourth Amendment. They're only just starting to be litigated in the courts because this is relatively new. But I think it's really critical that lawmakers get ahead of the curve and pass these kinds of really reasonable protections.
Thank you. Real quickly, Mr. Chair. I'm not sure at the very beginning when you answered my question, I got it right. You were addressing federal Fourth Amendment protections. So let me narrow it down. Is the FBI allowed to do this?
The FBI claims the authority to use face recognition technology. In fact, they have access to a number of states' driver's license databases, driver's license photo databases, against which they run face recognition searches using their own technology. So yes, they are doing it. We think that's tremendously problematic. We're working with members of Congress to try to rein it in, and are certainly thinking about Fourth Amendment theories. But it's happening right now by the FBI and other federal law enforcement agencies.
So whether it's law enforcement or these private corporate entities, we have a burgeoning Fourth Amendment problem that we're just getting our arms around because it's so new and just beginning to be litigated. But at the moment, other than a couple of our jurisdictions or states or localities, it's a free-for-all out there?
I think that's a perfect summary. That's right.
It's a yes or no question because I want to move the hearing along. Thank you.
Thank you, Representative Evangelos. Representative Babbage, and then Senator Carney.
Okay, thank you, Mr. Chair. And I appreciated Katrina Fitzgerald's testimony, and I appreciate yours as well for trying to get hands around this. I just wanted you to comment for me, if you could, on the consequence of this legislation as far as, some might say the horse has left the barn. What is the obviously upcoming generations could be impacted. But what about those that have had breach and so forth? What is the impact over the next decade, do you think, of this legislation?
Yeah, thank you for that question. So I think, the companies that have already collected biometric identifiers and have been hacked or breached and they're out in the wild, that harm is done. You're right. But I think this legislation is critical and will make a real difference immediately. The retention period, for example, for companies that have already collected will be subject to the retention limitations, and they either have to delete biometric identifiers when they're no longer needed, or at the very least a year after somebody's last interaction with them. And by getting your face print or fingerprint out of their database, you're no longer at risk of a future breach. And if they want to keep collecting and using it on an ongoing basis, they have to try to get consent. And if you deny consent, then they need to act accordingly and get rid of your data.
Thank you for that. Thank you, Mr. Chair.
Thank you, Representative Babbage. Senator Carney.
Thank you, Chair, and thank you, Mr. Wessler, for being here. I wanted to ask you about the discrimination provision. I guess it's on page 4 of the bill. And can you explain that a little bit? And I guess what I'm trying to understand does that say that I, as a consumer, couldn't be denied, for example, the right to log into a website just because I refuse to give biometric data?
That's exactly right. That's exactly right. So the idea here is that companies shouldn't be able to coerce people into giving consent by saying, for example, sure, you want to deny consent to give us your biometric identifier? That's fine, but now you're going to pay twice the rate for this service or this product, right? We want people to have an actual choice. And if they want to protect their biometric identifiers, they can still use essential services on the internet or in the physical world. Now, this provision does make clear that if the service being offered is itself dependent on use of a biometric identifier, then, for example, let's say there was some service to be able to, search through your uploaded photos to look for photos of yourself, right? And if that's all the service does, and you say, no, I deny consent to use my biometric identifier, the service just won't work, then that's fine. Then they can say, I'm sorry, we just can't offer this to you. But in every other regard, say you want to walk into a pharmacy and get your prescriptions, and they try to get your consent to take your face print at the front, and you say no, they have to let you in to get your prescriptions. That's the idea here.
Go ahead, Senator Carney.
And so would they be required to offer an alternative? Like, would I have the option to create a password that was unique to me that I could store however I wanted and change it if I wanted to?
Yes, that's exactly the intent. That's right.
So I would be in the driver's seat rather than them having my face print.
That's exactly right.
Thank you.
Thank you, Senator. Representative Babbage, did you have an additional question? Thank you. Are there additional questions from committee members for Nate Wessler? And I am not seeing any, so thank you again. Just nice to see you. Thank you very much for your time and testimony today. We greatly appreciate your input.
Thank you.
The next person that I have registered to testify in support of LD 1945, welcome back to the Judiciary Committee, Mary Bonato. Please begin your 3-minute testimony as soon as you're comfortable.
Thank you. Good afternoon, everyone. Chair Carney, Arnett, and members of the committee. Mary Bonato, Portland. I'm here on behalf of my own organization, GLAD, as well as Equality Maine and Maine Transnet. We are in firm support of this law. I should say that in the last session, we testified in the Criminal Justice and Public Safety Committee about a bill to prohibit the use of facial surveillance by certain government employees and officials, which is now law. And as Mr. Wessler just pointed out, the Fourth Amendment protections and whatever has been accomplished vis-a-vis the government does not exist in the private sector. And that is a big reason why we are supportive of this bill. In our view, it is coming just in time. Ordinary individuals are not equipped to push back against the large technology companies that are using and selling this technology, collecting information and marketing it. And it's among the reasons why I think bringing in the unfair trade practices law and bringing in a private right of action are essential to enforcement and making sure this has any teeth. And as you've heard already, the civil rights implications here are staggering. You know, we've all grown up with this idea that there's this right to be left alone. Well, maybe that's true to some degree vis-a-vis the government, but without what we see as the very measured regulation provided in this bill, where we go, with whom we go, you know, clearly can be tracked, and that information can also be monetized. We really do need safeguards in this area and are very appreciative actually of the fact that the technology can be used, but more for people who consent and really put some definite standards into place. Another reason why we need standards is that, as has already been noted, this technology is not entirely reliable, particularly along racial and gender lines. There was already discussion of a lawsuit in the Detroit area. This technology has been relied on and has resulted in false arrests, ejections of people based on racial lines. In addition, the technology sorts people by male and female. And I will just say there is tremendous diversity in our world, so it's not always easy to rely on those generalizations, and that has also resulted in misidentifying people and harm from that. So on trans people, it's virtually hopeless. So I would just say that there's really a lot of concerns about how this is used and the civil rights issues that it is causing. And for all the reasons you've already heard, we would strongly urge the committee to vote ought to pass on this bill. Thank you.
Thank you very much, Mary Bonato, for your time and testimony today. The committee greatly appreciates your input. Committee members, are there questions for Mary Bonato on her testimony regarding LD 1945? If so, please raise your electronic hand. And, Senator Carney.
I'm full of questions today. It's
Sure.
I appreciate everybody's patience with me. I wanted to ask you a question, Mary Bonato, because you talked about the inaccuracies of this technology for a lot of different groups of people, and it got me thinking about age. And I'm wondering if you know whether this biometric data is being collected on children who actually, if you're under the age of 18, you probably don't have the right to consent to collection of it. And then also, are there inaccuracies as people get older?
I think those are fantastic questions. I will say that in my own family with my own children, I've been horrified by use the thumbprint. How about we scan your eyeball? You know, so, and again, I'm not sure they're always interested in knowing how old people are, but that aside, I think these are really questions for people who know more than I do, but I think they're fantastic. Thank you.
Thank you, Senator Carney. Are there additional questions from committee members for Mary Bonato? I am not seeing any again, so thank you very much for your time today. Going back to the attendee room, and I'm going to ask if there are any additional persons wishing to testify in support of LD 1945. Cole, if I could have Cole Cochran moved over to panelist status to testify in support of LD 1945. Welcome, Cole. Welcome to the Judiciary Committee. As soon as you are comfortable, please activate your microphone and begin your 3-minute testimony.
Thank you. Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee, my name is Cole Cochran, and I am testifying on behalf of both Maine Youth Action and MYCJ, both youth activist organizations amplifying youth opinion. I live in Saco and am currently a junior at Thornton Academy. I'm speaking in support of LD 1945, an act to regulate biometric identifiers. I've grown up in a society in which social media has had an overwhelming presence. From Instagram to Snapchat, we are constantly bombarded with content, advertisements, and influencers. Social media companies have pursued invasive strategies by collecting data on us, creating dangerously addictive algorithms, and influencing us with precisely targeted advertisements. These algorithms, which in effect alter what we see and to what extent, extremely impair our freedom of choice. Freedom of choice requires all options to be available. We must have a choice about whether companies can collect our data and about what they do with it. Despite the conditions for such freedom, companies use our data to manipulate our choices, habits, behaviors, etc. This poses a direct threat to our youth, and as I have talked to dozens of youth about this issue, they agree with those sentiments as well. It is imperative to start regulating the usage and type of data that is being collected, and one of them being biometrics. Biometrics are by far one of the most invasive and dangerous pieces of data that companies can collect from us. Unlike financial information or one's interests, biometrics are something one cannot change. I think an example that was quite astonishing was how it relates to advertising. As I was gathering some background on this bill, I actually came across a website that talked about biometric data. The website was offering guidance through this new type of data and said the following, quote, using uniquely identifying consumer characteristics to associate each consumer with his or her consumer behavior profile, end quote. This alone indicates what these data points are being used for, and if companies still have the potential to use our physical features, it is only accelerating towards a future in which we have limited freedoms. However, we are at a significant moment where we will still have time to address this issue. In closing, young people in Maine are not able to vote on these issues. We count on adults and you, the legislature, to protect us now and to protect our future. By passing LD 1945, the state is doing as such. Therefore, I urge the committee for a motion of ought to pass on LD 1945. Thank you for your time, and I'm happy to take any questions.
Thank you very much for your testimony, Cole Cochran, and thank you for bringing the voice of those that are not yet old enough to vote to the Judiciary Committee. Greatly appreciated. Are there questions from committee members for Cole Cochran? I am not seeing any, so again, thank you very much for your time and testimony. The committee greatly appreciates your input. Going back to the attendee room one more time, asking if there are any persons wishing to testify in support of LD 1945, to please raise your electronic hand. Seeing none, I would ask if there are persons wishing to testify against LD 1945, to please raise your electronic hand. And I am going to start with Carl Szabo, Andrew Klingman, and Elizabeth Frazier. If I could have those three individuals brought over, Committee Clerk Panett. And I will begin with Carl Szabo. I hope I'm saying that right. If you could please activate your microphone. Thank you. Welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Thanks, sir, and pretty spot on with the last name, so I appreciate it. Good afternoon now. My name is Carl Szabo. I'm Vice President and General Counsel of NetChoice. I'm also an adjunct professor of Internet Privacy Law at George Mason's Law School. I'm also one of those DC lobbyists that we were warned about, but I'm also a businessman, so I know what it means to sign the front of a check. So what made Patel, Senator Kim, you asked about Patel, what made it such a big deal? Well, it basically rang a dinner bell for trial attorneys across the country to certify what are basically absurd privacy law cases. So rather than listening to me, I want to quote from an individual. He said, "The technology has bypassed what this law was intended to combat." And that's not me, that's the president pro tem of the Illinois State Senate. Illinois has recognized that their bill has gone wildly off course. A couple of the lawsuits that were brought, one against St. Bernard Hospital, another against Vanny Food Company, another against DePaul University, Audubon, Nissan, Community Nursing and Rehabilitation Center. Why? Because an AG wouldn't bring some of these truly absurd cases. And this is what you get with the private right of action and statutory damage. Representative Rickett, you mentioned unlocking your computer with your face. Well, if somebody else tries to unlock your computer with their face, they could actually sue you now under this bill because your computer has now collected their biometric information. Biometric information is not like a credit card number where anybody can pick it up and identify those numbers. Every time biometric information is collected, it's essentially anonymized unless you have that specific system to read it. So data collected by one business can't actually be read by another business. So the idea of it spilling out is kind of a false narrative. But even if it did, Maine has data breach laws that require businesses to notify. You heard from the ACLU that there are existing remedies and existing law to address abuses of biometrics, and anyone, regardless of the medium, who uses it to engage in unlawful discrimination violates anti-discrimination laws. Maine has one of the largest percentages of elderly in the country. Think about a Ring or Nest doorbell that identifies friend from foe or from a post person when they arrive. That technology is not available in Illinois. Think about Athea. It's an app to help the blind be aware of their friends and family around them. That technology is not available in Illinois because of this law. Think about a vending machine to safely dispense medicine, not available in Illinois. Cameras in truckers to help prevent drowsiness. And Senator Carney, to your question about discrimination in the law, well, Six Flags uses season passes with biometrics to make sure the person isn't like cheating and trying to sneak somebody in. Well, imagine, and they were sued and had to settle a case for $36 million because of that technology. And essentially this would outlaw pharmacies from using biometrics to prevent opioid abuse. There's a litany of reasons not to pass this law, and only a handful of bad practices we're trying to stop. So I suggest we not advance this legislation and follow basically every other state in the nation since 2008 in not enacting this law. Thank you.
Thank you very much, Carl Sabo, for your time and testimony today. We greatly appreciate your input. Are there questions from committee members for Carl Sabo? Representative Hagan.
Thank you, Mr. Chair. Quick one, Mr. Sabo. Which states have not purposefully not done this?
States include California, New York, Maryland, Virginia, Indiana. I can basically run through almost every single state has considered and not moved forward with this legislation, because while polling, as was cited earlier, shows that 88% of people want protections in law of their biometric information, when asked, would you support something that denied your ability to search your own personal photo album by face, most people say no. So no other state, aside from Illinois, has passed this law with a private right of action and statutory damages.
Thank you, Representative Hagan. Thank you, Carl Sabo. Are there additional questions from committee members for Carl Sabo? Representative Evangelos.
Thank you, Mr. Chair. Hello, Mr. Sabo. So, Mr. Sabo, I'm trying to read between the lines of your testimony. Specifically, you're testifying that you're opposed to this law, but it's coming across to me that you have a fairly wide latitude and entitlement to information that maybe shouldn't belong to you. I mean, where do you draw the line?
Thanks for asking. No, I fully believe I'm actually a privacy advocate. I helped draft model privacy legislation. I've written terms of service and privacy policies before. I fully support privacy protection. What I don't support is legislation that empowers abuses that harm businesses. And what we're talking about in this legislation, the way it's been weaponized in Illinois, it's not been used to actually protect consumers. In fact, consumers in Illinois are worse off today with respect to security than they were when the law was passed. So I'll give you an example. When I call my telephone company, they will sometimes use voice recognition technology to verify my identity and prevent identity theft. Make sure somebody else isn't pretending to be Carl Sabo. That type of technology is not allowed in Illinois. And that's because of the private right of action and statutory damages. Any business who tries to do a good thing gets whacked with this law. So let's use that telephone company using voice recognition for security purposes. How would I give express written consent ahead of the phone call? How would I give express written consent on the phone call? It's a phone call. There's no written consent to be given. So the problem is that you get these truly absurd cases. So I do support legislation to address privacy harms. I do support legislation to address actual harms. What I don't support is essentially gotcha legislation that results in tens of millions, if not hundreds of millions of dollars in damages. And to the extent that this will save taxpayers dollars by essentially privatizing law enforcement, There have been over nearly 400 cases in Illinois alone on this law. Courts are paid for by taxpayer dollars, and they're getting slammed with frivolous lawsuits. So I fully support privacy legislation. I fully support a national framework for privacy legislation. I support a national framework for data breach legislation. What I don't support is this legislation.
Thank you.
Thank you, Representative Evangelos. Are there additional questions for Carl Sabo? I am not seeing any, so thank you very much for your time and testimony today. We greatly appreciate it.
Thank you.
We'll turn to Andrew Klingman. Andrew, welcome to the Judiciary Committee. As soon as you are comfortable, please begin your 3-minute testimony.
Thank you. Good morning, Mr. Chair. Can folks hear me okay?
Yes, we can.
All right, great. My name is Andrew Kingman. Mr. Chair, I'll just say it's a rare day when people pronounce Carl's name correctly and just stumble on mine. And also, not to be outdone by some of the folks on the other side of this argument, my in-laws also live in Maine up in Otisfield. And so look forward to going up to Casco Days every summer here. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a multi-sector coalition. I also am a privacy attorney and so help counsel clients all over the country through various privacy laws. Although my testimony echoes much of what Carl pointed out, I think it's worth just stating this bluntly, which is the Illinois law, which this is based on, is the single most toxic privacy law in the country for much of the reason that Carl laid out. In the last 4 years, Illinois trial lawyers have initiated over 1,000 lawsuits, class action lawsuits, that are aimed at businesses that literally are unable to comply with the law. It's created a strict liability standard effectively, particularly for the companies that are defined as processors in this law. There is no cybersecurity or fraud exemption here. And so what we are looking at is a private right of action, as in Illinois, that will overwhelm companies' abilities to offer services that protect Maine businesses, that protect Maine consumers. I think it's also important to talk about some of the provisions that are novel here that are not in the Illinois law. I'm happy to take questions about the BIPA pieces, but I want to focus on a couple of other things. There's an access right in this bill for consumers with regard to their biometric information, but it is also tied to all other personal information that could possibly be linked to their identity and could also be possibly linked to their household. In California, when we worked on the California privacy law out there, we worked very hard on removing the definition of household and eventually limiting it, because the risk is that a single person, perhaps it's somebody who's a victim of elder abuse, perhaps it's somebody who's a domestic violence victim, who asks for their biometric information. If it's the abuser, the company is literally required by law, under the way this is written, to return all of that household information that could be linked to anybody in that household. So that's geolocation information, that's all other types of information. And it has dramatic consequences for the amount of information, the utility to consumers, as well as, I'm sorry, Senator Carney. Okay. So anyway, the other piece here that's novel is the bill contains a 1-year look back period, meaning that businesses are going to be incentivized to retain personal information for longer in a good faith attempt to comply with this law. So there are any number of unintended consequences here that I think really point towards not moving this bill forward. Thank you.
Thank you. Thank you very much for your time and testimony. I will note I did get the pronunciation of your first name correct.
That's right. That's right. Yeah, you nailed it. Thanks.
So with that, questions from committee members for Andrew Kingman. Representative Hagan.
Thank you, Mr. Chair, and thank you, Mr. Kingman. I'm curious, you've got me interested in some of the other consequences, unintended consequences, if you could provide a list and an explanation of some of those.
Yeah, absolutely. So first of all, the bill requires returning any biometric information to a consumer. And, in and of itself, that is not particularly objectionable. I don't think it's particularly useful for consumers because the vast majority of biometric identifiers at this point are stored in what's called a hashed format, which is, if it's your thumbprint or your face print or your voice, it's converted to a numerical string of numbers that is then encrypted. And so just returning that, I don't think will be particularly useful, but businesses are able to do that. However, there's another consequence here, which is that in addition to the access right, businesses will be required to turn over this very sensitive information back to consumers. So if your social security number is linked to your biometric information, maybe your payment information is linked to your facial recognition feature, you're required to return all of that information back to a consumer, which makes it more vulnerable to attack sitting in a consumer's email inbox than it does when it's stored securely on a business's architecture. In California, again, the regulations to the privacy law there recognize that that businesses are not required to turn sensitive information back over to the consumer to address just this specific security risk. And so I think, again, when we look at this bill, there are any number of ways in which there are, it's not written nearly precisely enough to actually encompass only that activity that it purports to get at. I would also say that, when we talk about Maine's population, Carl mentioned it's got the largest per capita, elderly population. You're talking about, being able to provide consent to people who come to your door, right? And the ability to offer that. The reason that the lack of a fraud exemption is so harmful here, and we've seen it in Illinois, is that, of course, criminals will never provide their consent to have their biometric information collected, right? And so it leaves consumers actually more vulnerable. And when you combine that with the private right of action, I regularly counsel businesses to simply not offer their biometric services in Illinois because of the litigation risk. I work for, I have clients who do authentication work and offer cybersecurity and anti-fraud services, and they do not operate in Illinois because of the litigation risk. So it is we have seen through the class action abuse that it really has had a detrimental effect on the safety of Illinois consumers. We do not want that to be the case here in Maine.
Thank you, Representative Hagan. Are there additional questions for Andrew Kingman? I am not seeing any, so thank you very much for your time and testimony.
I think Mr. Caverly.
He's
okay,
here to testify, not to ask a question. So thank you for your time and testimony. And I just want to alert the committee, people in the attendee room, and anyone watching. At 1 o'clock, I'm going to take a 10-minute break, and then we will come back to finish this public hearing. 1 o'clock will have been 4 hours straight that people have been sitting. We will come back and complete the hearing on 1945 and then take a longer break before wrapping up the public hearing and going into work sessions. So with that, I will call upon Elizabeth Frazier. Welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are able.
Thank you very much, Chairman Harnett, Chairwoman Carney, and honorable members of the Judiciary Committee. My name is Elizabeth Frazier. It's a pleasure to have been with you this morning and to be with you this afternoon. I am with you this afternoon on behalf of the Alliance for Automotive Innovation. So unlike a couple of the previous speakers, I think we come at it from a very unique perspective. And my goal for today is really just to put on the committee's plate that automobiles are wrapped up in this conversation, that there is information that is collected by a vehicle today, and particularly likely into the future even more so, that could be implicated by the bill. For example, there are, new technologies coming out in cars all the time, some of which I haven't experienced yet, some of which you haven't experienced yet, but there is a technology, for example, that can be used to recognize whether an individual is actually disengaged from driving the vehicle. So if an individual is looking at their phone, for example, some cars now have cameras that look to see if your eyes are focused on the road or not, and will alert you if you're not focused on the road. As you can imagine, with the coming of autonomous vehicles, there are outward-facing cameras that look to identify obstacles, including pedestrians versus cars versus seagulls. So that information is captured, and it's not always identifiable, but under the language of the bill, could be potentially disallowed. I'd also mention that there is a piece that was a little bit confusing to us with respect to why only financial transactions would be exempted. So I think we would just call your attention to that. That's a little bit outside of the auto specific world, but something that we did have a question about. And then really, rather than read you what's in my written testimony, which does go through in a little more specificity some of those unique examples that come up in cars versus other types of technology. That has been submitted to you. You have my written statement. I would just ask that to the extent there is work done on the bill for either an amendment or exemptions, or if you have questions about how autos would be implicated, we would be happy to participate in a work session and follow up. So really just to plant my flag in the ground to say, don't forget about cars, because that could be pretty easy to do in this context. And to thank you, and of course, be happy to take any questions that you may have. And if I can't answer them, to get answers and bring them back to you for the work session.
Thank you very much, Elizabeth Frazier, for being with us this afternoon and presenting your testimony. Are there questions for Elizabeth Frazier from committee members? I am not seeing any. So again, thank you very much for your time. We greatly appreciate your input.
Thank you very much. Look forward to working with you all further on this.
The next person to testify will be Lisa McCabe. Welcome to the Judiciary Committee, Lisa. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you, chairs, members of the committee. My name is Lisa McCabe, and I'm here on behalf of CTIA, the Trade Association for the Wireless Communications Industry, in opposition to the bill. I think that a lot of what I was going to mention has been raised, but I think it's also important to note that there are a number of examples. This bill, as we said, places businesses under the threat of litigation with little benefit for consumers, does not account for fraud and cybersecurity uses, and is not reflective of the current online ecosystem. Without this exemption, it would not include activities that promote security and prevent security fraud. For example, facial recognition is used as an authentication tool for access to devices and applications by users and businesses to protect privacy and security. Also, the written consent requirement doesn't reflect the current online ecosystem and is likely unworkable in a practical sense. This bill could preclude protections for disabled populations, the elderly and others, as they would be unable to use voice or facial recognition to consent to services that protect themselves and others from cyber threats. And this could also even impact the use of voice recognition services like those used in cars to help avoid distracted driving. As mentioned about the access rights, it would have unintended consequences, including the risk that biometric identifiers and other sensitive information could land into the hands of bad actors, posing as consumers exercising their rights under the law. This bill, raises complex issues and replicates an outdated statute, as you know, which is very litigious and was passed a long time ago. And so we feel like this is probably not the best path for Maine to take. Thank you.
Thank you very much, Lisa McCabe, for your time and testimony today. We greatly appreciate the input. Are there questions from committee members for Lisa McCabe? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much. Let me just check. No, thank you very much for your time today. The next person that we will hear from, and then we will take a short break after that, is Robert Caverly. Robert, if you could activate your video so that we can see you.
Mr. Chair, this is Robert, and I don't seem to have the video button, but I do see that I'm coming through to you guys, so I know you can hear me. But
we can hear you. Ideally, we'd like to see your face as well, but if you can't do that, we will simply proceed with your 3-minute testimony. Welcome to the Judiciary Committee.
thank you very much, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Robert Caverly, and I serve as the Vice President of Governmental Affairs for the Maine Credit Union League. I'm here to provide testimony on behalf of the League in opposition to LD 1945. The credit union system takes our commitment to protect the personal information of our members very seriously. This commitment is rooted in both our responsibility to our member owners and, perhaps more importantly in today's context, in accordance with the Graham-Leach-Bliley Act of 1999. Though the Graham-Leach-Bliley Act already applies to federally chartered credit unions, Maine's Title 9B also applies to this strict privacy framework to state financial institutions, assuring a strong, proactive approach to data privacy and security. Emerging biometric technologies such as fingerprints and voice recognition are growing in popularity and is a useful tool to verify an individual's identity. Biometrics technology is now mainstream identity protection service offered at nearly every financial institution. We are concerned that the harsh punishments proposed in this bill will chill the use and expanded adoption of these important consumer-friendly security measures, in effect, leaving account holders less protected than they are today. Financial institutions are one of the heaviest regulated industries in the United States. Among many of the things examined are the security and protection of data and private information held within the credit union. The federal government has mandated clear requirements and expectations on how credit unions must protect personal information, along with clear consequences for failing to do so. Credit unions can be penalized or even closed should they fail to comply with these very strict and important regulatory mandates. It surmises that the direct and comprehensive regulatory protection is what led the Illinois legislature, that we've heard a lot about today, to offer their financial institutions an exemption in the biometric privacy law they enacted in 2008. We would encourage the committee to consider such an exemption. LD 1945 correctly identifies that data security and privacy is an important issue that needs policymakers' time and attention. However, this issue would be best addressed at the federal level, where a universal standard could be applied, offering consumers protection no matter where they live. Such discussions and negotiations are ongoing in the halls of Congress, and the League and our credit union allies across the country continue to encourage and support these efforts. The League appreciates the opportunity to present this testimony to the committee. We would urge the committee that should you decide to pursue LD 1945 further, that you strongly consider adding an exemption for Maine's financial institutions. Without an exemption for Maine's strictly regulated credit unions, then the League would urge the committee to adopt an ought not to pass report. The League stands ready to work with the committee and other interested parties on this important issue. Thank you very much.
Thank you very much, Robert Caverly, for your time and testimony today. Are there questions from committee members for Robert Caverly? If so, please raise your electronic hand. And I'm Senator Carney. You keep moving around.
I know this question stands between everybody and a much needed break. Just quickly, Mr. Caverly, you referred to, this type of security being offered to credit union members. And I guess that gets me back to the question of consent. Like, why isn't having a consumer consent
an acceptable threshold for using this biometric data?
That's a good question, Senator, and I will happily go back and come up with a better answer for the work session for you. But I would offer just quickly that, I think it also kind of applies to what people expect of their financial institutions these days. I mean, we've heard from other opponents this morning that state, these services have been offered, but they're not offered in Illinois because of this law. And I think, from a credit union perspective, we want to make sure that our members in Maine have access to all the available technologies that other members across the country have. So, but I will definitely dig in and try to get you a better written response to your direct question.
Thank you.
Thank you, Senator Carney, and thank you for the response, Robert Caverly. Are there additional questions for Robert Caverly from committee members? Seeing none, we will take a break for till 1:10. We have at least 4 people who still wish to testify in opposition. I know that we have a few testifying neither for nor against. When we come back, we will pick up at 1:10. I would ask committee members to please shut off your video and mute your microphones, and please be back so we can start promptly at 1:10. Thank you all very much. Good afternoon, Jen.
Hello.
Representative Harnett?
Yes.
I wanted to let you know that I'm back. I need to make one quick phone call, but I will be with everyone as soon as I possibly can.
Can I ask you a quick question? We have one more public hearing, which is 1958, which has my introduction and only 4 people signed up to testify. Would you like to go right through that and then take a break before the work sessions? You will be running that.
Yes, that
public.
seems like a good plan.
Okay, thanks.
Okay, I'll be right back.
We'll make your call. Thanks. Committee members, as you return, please turn on your video so I know that you are back. Thank you. And as we are waiting for additional committee members to return, I'm going to turn to the attendee room. And I know that I had more hands up before, persons wishing to testify in opposition to LD 1945. If you could please get your electronic hands up, that would be great. Again, this is those opposed to 1945. And Soupy, are you back on? Could you move over Bill Kay at Saco and Biddeford Savings, Bruce Garrity, Charlie Sultan, and Deborah Hart? Thank you. Okay, committee members and attendees, it's a little after 1:10. We are going to finish up the testimony in the public hearing on 1945. Then we will go to a public hearing on LD 1958, which should not be terribly long, famous last words. And then we will take a more significant break before our afternoon's work sessions. So with that, I am going to, looking at those who have been moved over from the attendee room, I am going to start with Bill Kay from Saco and Biddeford Savings. Bill, welcome to the Judiciary Committee. As soon as you are comfortable, please begin your 3-minute testimony, realizing that my co-chair will hold up a phone when you have about 20 seconds left. Thank you.
Thank you very much. Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Bill Caney, and I'm a resident of Saco. I'm a Senior Vice President at Saco and Biddeford Savings. and I am the chair of our legislative committee, our meaning the Maine Bankers Association. Our association supports protecting our customers' biometric information. However, we oppose LD 1945 as currently drafted because it does not recognize existing federal and state regulatory frameworks and the strong privacy and data security standards that are already in place for the financial sector. Banks are one of the most highly regulated industries in our country, and we are subject to extensive federal privacy and data protection laws such as the Graham-Leach-Bliley Act, or GLIBA. It's important to note that Maine law obligates us to protect our customer information, and it also obligates us to comply with the GLIBA. Furthermore, the privacy of our customers' non-public information is the cornerstone of our industry. Our ability to protect our customer information is one of our most important assets, and the suggestion to the contrary, quite frankly, is a bit insulting. The proponents of LD 1945 cite the state of Illinois' comprehensive biometric privacy bill adopted in 2008, commonly referred to as BIPA. In BIPA, the Illinois legislature recognized that financial institutions already had a comprehensive and vigorous regulatory framework for safeguarding customer information, and therefore provided the following exemption. Nothing in this act shall be deemed to apply in any manner to a financial institution or an affiliate of a financial institution that is subject to Title V of the federal Graham-Leach-Bliley Act of 1999 and the rules promulgated thereunder. That exception remains in the Illinois law to this very day. And as a result, Maine Bankers Association would respectfully request that because of the safeguards we already have in place, that this legislature adopt a similar exemption for financial institutions if you decide to move forward with the bill. There's no question that biometrics do address the security versus convenience issue that businesses face by providing a highly secure method of authentication using unique identifiers our customers always have with them. For example, a few Maine banks, including our own, utilize voice recognition to provide a safe and secure way for their customers to conduct their banking transactions. Voice recognition application is 99% effective, but its use will be discouraged by this bill because of the private causes of action and because people will need to sign up in advance as opposed to consenting over the telephone to use that type of authentication, which consent is then verified in writing after the fact. We would prefer to use something that is 99% effective as opposed to using the time-consuming process of asking everyone for the name of their first dog. We do have other concerns about this bill, but time prevents me from getting to those, as I can see. So thank you for the opportunity to testify. We would encourage you to adopt an exception for any GLIBA-regulated financial institutions in terms of this bill, and we will be available for the work session. Thank you very much.
Thank you very much, Bill Caney, for your time and testimony this afternoon. We greatly appreciate your input. Committee members, are there any questions for Bill Caney? Representative Moriarty.
Thank you, Mr. Chair. Mr. Caney, my question will start as though it sounds like a joke. An old man walks into Saco and Biddeford Savings, and that's as far as I'll go. But suppose I do that. What are you in the bank doing as far as my appearance, my eyeballs, my fingerprints, the size of my hands are concerned, and why?
We are currently not doing anything in terms of someone coming into the bank. One of the nice things about being a Maine-based bank is that we know most of our customers. But if we did not know you, we do have other secure ways of verifying that you are, in fact, the customer that we're dealing with. Anything from quietly asking you some confidential questions that we have taken from you when you became a customer of ours. We also know your date of birth. We know your social security number. Those are all things that we can use to help verify that you are, in fact, the Mr. Moriarty standing in front of us as a customer wanting to do a transaction.
Well, what I'm accustomed to, if I go into a bank that I don't ordinarily use, is producing ID and that sort of thing. But I've never been asked personal questions in order to cash a check. I mean, do you actually do that?
If if we have a customer who's come in and, for example, they do not have their ID with them, we may ask them, because we do get some security, we take some security information at the
Well, I
time.
mean like a driver's license. When I say ID, a driver's license.
Right.
I may be asked.
If they didn't have it when they came in, we have other ways of verifying that they are in fact the person they claim to be. If they're not a customer and they're coming in to cash a check, then that may be a little bit more problematic if they have no ID with them.
Okay, so what if they do have the license, a driver's license, a main license, and they're not a customer, and they may have a credit card or something as well? I mean, do you take any further steps customarily to verify identification?
If we don't have any if nothing jumps out at us as being problematic, no, we probably would not. But again, when we're talking about biometrics, we're not talking about someone being there in person. We're talking about someone, in our case, someone being over the telephone.
Okay, thank you.
Thank you, Representative Moriarty. Senator Keim.
Thank you. Yes, just a quick question. When you are using someone's voice, have you already asked them if it was okay? Do you get permission ahead of time?
Absolutely. Yes, we ask them in advance if they would like to participate in the program. If they say no, that's the end of it. If they say yes, while they're talking to us, we are getting all the indicators we need about their voice. We then follow that up with written confirmation that they want to participate in the program, at which point, if they decide not to, they can opt out.
So you're collecting the information at the same time that you're asking them if you want them to use it, if they want to allow your bank to use it.
Correct.
Okay, thank you.
Thank you, Senator Keim. Are there additional questions from committee members? Senator Carney.
Thank you. And Mr. Caney, welcome to the Judiciary Committee. Two quick questions for you. One is, when you say that the voice print or whatever it is 99% effective, what does that mean? Is it effective as far as identifying the right person, or 99% effective as to preventing fraud?
I would say the answer is both, because it's the incidence of error in terms of identifying the person are exceptionally low. They're less than 1%. So that would be also the success rate at preventing fraud, because there are very few instances. Your voice is almost essentially the same as a fingerprint in terms of its uniqueness. It doesn't even matter if you have a cold. It will still identify you as opposed to the rest of the world. So the odds of someone stealing your voice or imitating you are infinitesimally small as compared to someone's ability to perhaps steal your password, steal your personal information, such as the name of your first dog, and using that to identify themselves on the telephone.
I have one follow-up.
Go ahead, Senator.
Which is, and then can you give us some information about how you store that voice print, for lack of a better word, and what you do to ensure that it is not stolen and then used in other venues to commit fraud?
The recordings that we have for people are stored in the cloud by the company that we use to provide this service. That we have to check their security extensively when we vetted them, and then annually every year thereafter to make sure that they're complying with all of the necessary data protection. This is a company that provides this service to literally thousands of companies across the country. But I can assure you that we vetted them very thoroughly before so they're storing the data, we're not. And any of it is only retained for 30 days and then it's destroyed. So the only thing they have is that voice print that they can then use each time that someone calls it. So,
and I'm sorry, you said they destroy that voice print after 30 days?
As we communicate with people on the phone, it's actually recorded. Those recordings are retained for 30 days. The voice print, however, is retained until the person decides they they are either no longer a customer or they opt out of the program.
Oh, thank you. Thanks for that information. It was very helpful.
Thank you, Senator Carney. Are there additional questions for Bill Caney? I am not seeing any. So again, thank you very much for your time and testimony today. I will next turn to Deborah Hart. Deborah, welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you, Representative Harnett, Senator Carney, and other members of the committee. I am not Curtis Picard, and I am not the CEO of the Retail Association of Maine. I am a lobbyist who registers for the Retail Association, which has more than 350 members statewide and represents retailers of all sizes. We are presenting this testimony in opposition to LD 1945. I neglected to say I am a resident of Manchester, Maine, and I own Hart Public Policy. First, as the committee knows, LD 1982 was just released from the revisor's office, and that bill contains provisions relating to biometric information as well. And we would urge the committee to hold off working on this legislation so that it can be worked alongside that bill. In regards to LD 1945, we have a number of concerns. The bill contains a very expansive private right of action that we believe will only benefit trial lawyers. Already heard about some of that action in the state of Illinois, where they had passed a bill that had some pretty overreaching consequences. The bill as written will require entities to make available to the public a written policy that establishes a retention schedule and guidelines for permanently destroying an identifier, and has significant requirements for disclosing to individuals upon request a significant list of data that may be impossible to produce. We believe that this will lead to companies violating the law unknowingly. Biometric identifiers are not new. They've been around for years. What is new, however, are the evolving applications that can provide consumers a number of benefits, such as navigating the need for multiple passwords, increased security systems. You've heard about Ring Doorbell and a variety of other new products that are produced all the time. We live in a world of new developments of products that increase productivity and safety. And in that vein, we would suggest that you look at the language very carefully when you work on both this bill and again, LD 1982, putting overly burdensome constraints on policies that govern the possession of biometric identifiers needs to be crafted in a way that protects an individual rights, but does not hamper or discourage a business from the lawful use of an identifier associated with a person. During your work session on this bill, the Retail Association of Maine will be happy to relay some of our ongoing concerns and the impacts on both Maine businesses and the consumers who purchase their products. It is in all of our best interests to get this right. We thank you for your time and consideration. I'd be happy to take any specific questions back, because I certainly am not an expert in biometric identifiers, although I know I possess them.
Thank you very much, Deborah Hart, for your time and testimony this afternoon. We greatly appreciate
Thank you.
Input. Are there questions from committee members for Deborah Hart? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much for your time and testimony today.
Thank you.
The next person I have who's indicated he'd like to testify in opposition to LD 1945 is Bruce Garrity. Bruce, welcome back to the Judiciary Committee. Please begin your 3-minute testimony as soon as you're comfortable.
Thank you, Representative. Senator Carney, Representative Harnett, and members of the committee, my name is Bruce Garrity. I'm here today on behalf of the Maine Automobile Dealers Association, which is the association of all new car and truck dealers in the state of Maine. And we are in opposition to LD 1945. Let me briefly piggyback on the comments that were made by Mr. Caney for the Bankers Association. Graham-Leach-Bliley applies equally to car dealers. We are subject to Part 5 of GLB. That is the provision that, as you heard, the Illinois legislature exempted. People regulated by that are exempted from the operation of the Illinois law. Let me also point out, if I might, that auto dealers are already very heavily regulated. We're regulated by the data breach law in Title 10. We're regulated by the Superintendent of Consumer Credit. the Attorney General's office, and the Secretary of State's office, and the Federal Trade Commission. We are, just as with banks, extremely heavily regulated already. I'll try to limit my points to things that you may not have heard before. This legislation tries to shoehorn the Unfair Trade Practices Act into this statute. Respectfully, it doesn't work. That deals with unfair and deceptive conduct. That is not what this is dealing with. And we would urge you, if the committee wants to seriously consider the bill, to remove any references to the Unfair Trade Practices Act. In fact, one of the provisions in the Unfair Trade Practices Act is a complete exemption from interstate commerce. That's Section 208 of the Act, and I just don't think it works. Vehicles have a lot of bio identifiers in them. There are cars now that operate by fingerprints. There is voice recognition. There are operating under the influence lockout provisions. There are a variety of different things that affect vehicles, keeping in mind that they are already baked into the car. When you purchase the car, you're purchasing these various features already. I'll briefly point out that the private right of action is an extraordinary remedy. It is something that just promotes litigation, and we're very concerned with it. I'd be happy to discuss that further. I would point out that Section 9604 sub 2 of the bill tries to incorporate non-biometric provisions into the confidentiality and protection provisions of the statute. Thank you, Senator. Driver's licenses, for example. It makes no sense to try and apply that here. Section 96052 requires disclosure of information before you get the information. We think that makes no sense. We think this should be applied to government institutions, and we would point out that one of the bigger data breaches that we've had in recent years was of the state police in 2020. And last, let me just quickly point out, this is a very significant proposal. Whether the committee decides to move forward with it or not, I would suggest it requires a great deal of work, and perhaps more than the committee and the legislature can apply, given the short second session and everything else that's going on. And thank you for the time and opportunity to present this testimony, and for your patience, Senator Carney.
Thank you, Bruce Garrity. Have you submitted written testimony, Bruce?
I have not.
Okay.
I'm certainly happy to do so if that was this committee.
Thank you. Are there questions for Bruce Garrity from committee members? If so, please raise your electronic hand. Representative Hagan.
Thank you, Mr. Chair. I would be very interested in receiving your written testimony. I tried to type, you talked too fast for me to type everything, so that'd be great to have.
I'm happy to do that. One of the consequences of a 3-minute rule is you learn to talk fast.
Yeah.
Thank you, Representative Hagan. Are there additional questions from committee members for Bruce Garrity? Seeing none, thank you very much for your time and testimony this afternoon. We appreciate your input. The next person I had registered to testify in opposition to LD 1945 has just joined us. Charlie Sultan, welcome to the Judiciary Committee. Please begin your 3-minute testimony when you're comfortable.
Thank you, Representative Harnett, Senator Carney, and members of the committee. My name is Charlie Sultan. I am a Maine resident representing Maine-based domestic insurance companies called the Maine Association of Insurance Companies. I testify in opposition to the bill. I do not have written testimony because I would write something virtually similar to what Bill Caney did for the Maine Bankers Association. And I'm sorry I had to leave the hearing to run to HHS to present testimony there about a few minutes ago. So I'll try not to repeat anything. I will simply say that the insurance companies, like financial institutions, and we are considered a financial institution under Graham Leach Bliley, have those same responsibilities for protecting information. Maine was one of the first states to have a specific insurance data privacy statute. We are governed like the banks by our specific regulator, the Superintendent of Insurance and the Bureau of Insurance. They are incredibly strict about our data security. There are specific rules in addition to that that guard that security. One of the many unintended consequences that previous speakers I did hear talked about are things that are beneficial to insurance consumers. Things such as devices for preventing repeat offenders to OUI by blowing into a tube in order to start their car so that the person is deemed not to have alcohol in their system. Fingerprints may also be used to trigger such devices for security reasons. And we know that in the future, testing for things like marijuana and other systems, like that may well go into biometric data. All those things will protect Maine consumers. So we believe that like if you were to go forward, and we think there's a lot of infirmities with the Illinois statute has been tested or has been testified to. Illinois does have a GLB exemption, and we would ask for your indulgence to include that, like Illinois, if you were to go forward. So I'll leave it at that and try not to drag this out any further. Thank you.
Thank you very much, Charlie Sultan, for your time and testimony today. Are there questions from committee members for Charlie Sultan? I am not seeing any. So again, we thank you very much for your time today. Going back to the attendee room, and I will check one more time to see if there are any persons wishing to testify in opposition to LD 1945. If so, please raise your electronic hand. Seeing none, I will ask if there are any persons wishing to testify neither for nor against LD 1945 to please raise your electronic hand. And I am asking Committee Clerk Panett to please move over Jeff Austin and Ann Robinson to panelist status. As I wait for them to arrive, I will begin with Jeff Austin. Jeff, welcome back to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you, Representative Hartnett, members of the committee. My name is Jeff Austin. I'm here on behalf of the Maine Hospital Association, testifying similar to previous speakers about making sure you have an adequate exemption for our normal business operations. The bill is drafted, I believe, is trying to take out normal healthcare operations from the purview of the bill. We've suggested 3 wording changes that we think are more comprehensive, but I have to be honest, the whole thing makes me a little nervous that we do it correctly. This is the challenge for you, whether you do an opt-in bill where you define into the law the things you want to prohibit, or an opt-out bill where everything goes in and you create a laundry list of exemptions for us, bankers, autos, whoever else. Either way, it's hard to draft, but this opt-out format puts a burden on us to make sure we draft our opt-outs comprehensively enough to cover everything we do. So we're trying to do that in our draft legislation. If you agree with us on the policy, we'd be happy to work with Peggy or other members of the committee who would like to work with us. I looked at the Illinois law. I have to say it made me further nervous the way they did the exemptions are for healthcare. Our version of the bill of the law, LD 1945, is not exactly the same as Illinois'. What makes me nervous about the Illinois version is it's a laundry list of potential medical issues that are exempted out. And anytime you create a laundry list, if you forget to list one article of laundry, a court might presume you did that purposefully and therefore it is not subject to the exemption. So if you agree with us on the policy, we are aiming at as broad an opt-out for our activities. Like others, we are extensively regulated, and biometric information is literally what we do all day, every day. So I'm happy to take any questions. I did submit written testimony and be happy to work with you further. Thank you.
Thank you very much, Jeff Austin, for your testimony today. We appreciate your input. Are there questions from committee members for Jeff Austin? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much.
Senator Carney has her hand up, I believe. Or she's just saying hi.
I missed that real hand. I apologize.
I could do both. Thank you. Just a quick question, and I'm probably going to mispronounce it, but I know that the insurance companies and banks said that they were already extensively regulated by GLIBA. Is that something that applies to hospitals as well, or would your exemption be something different than related to GLIBA?
Our exemptions are going to be by and large different. I don't know if we're subject to it on the financial side of the house to the extent we take your financial information. I actually don't know. I will try to find that out. But that's probably less of our concern. More of our concern is that we collect biometric information about you every time you come in, and it is linked to your identity, your name, your gender, your age, your social security, if we have it. So it's more your medical information than your financial information. I don't know that we link the financial side of the house to your biometric, although maybe you can do it somehow.
Well, I think the committee would appreciate hearing about the financial side of hospitals and GLIBA, and also the extent to which you think that the confidentiality protections of HIPAA have anything to do with this issue as well. It would be that would be useful for us to hear at the work session.
Not sure I understand the question. HIPAA covers our inability to disclose without authorization most of your healthcare information, and then in some cases, there are exceptions to that, and we can disclose it.
Does it also apply to how information is stored and information security, or is that not part of HIPAA? I don't know.
It is less about how it is secured. It is more about non-disclosure than it is about the levels of security you have to have for certain types of information. But I will try to find that out as well.
Thank you.
Thank you, Senator Carney. Are there additional questions for Jeff Austin? Seeing none, again, thank you very much for your time and input today. The last person I have who's indicated an interest in testifying neither for nor against LD 1945 is Ann Robinson. Ann, welcome to the Judiciary Committee. Please begin your 3-minute testimony when you're comfortable.
Thank you, Representative Harnett, Senator Carney, and members of the committee. Can you hear me okay?
Just fine.
Okay, great. Thank you. My name is Ann Robinson. I'm a lawyer with Pierce Atwood, and I'm here on behalf of the Pharmaceutical Research and Manufacturers of America, otherwise known as PhRMA. We're neither in support nor opposition to the bill. However, we do want to raise our concern that the bill could negatively and likely unintentionally impact biopharmaceutical companies' ability to conduct clinical trials and to do biomedical research in Maine. And I would note that currently there are 2,055 clinical trials going on in the state of Maine. Biomedical research is subject to an extensive set of protections, including laws protecting patient confidentiality in human subjects research. These existing rules and standards include the federal policy for the protection of human subjects, the parallel US FDA requirements for human subjects research, and standards that are set forth from the International Council for Harmonization of Technical Requirements for Pharmaceuticals for Human Use, and that's known by the acronym ICH. Importantly, I would note that informed consent is a requirement of all clinical trial processes. The use and processing of health data consistent with these existing standards is essential to improving healthcare through research and for avoiding unnecessary confusion and uncertainty that would only serve to distract from the critical mission of providing patient care and biomedical innovation. So we've proposed in our written statement that I have filed, PhRMA's written statement, a few specific amendments that we believe would harmonize the relevant provisions of the bill with these existing data standards related to biomedical research and would significantly minimize the harmful impact that would otherwise occur to the biomedical research ecosystem. So we proposed in that statement the addition of a definition of research that is consistent with existing health industry standards by referencing the definition in HIPAA, and this definition includes clinical trials, as well as a broader scope of research activities that benefit public health in a myriad of ways. And I'm sorry, I'm trying to scroll down on my screen as I'm looking at you. Second, we propose an amendment to exclude from the definition of biometric identifier information, samples, images, and so forth that are collected, used, or disclosed in the context of research, as we've proposed to define it, and that is conducted in accordance with the existing standards that I identified a few minutes ago in my testimony. Third, we've proposed to amend subsection 4, dealing with private entities, to exempt entities that conduct research in compliance with federal policies, rules, and guidelines issued by the ICH. And this is important because LD 1945 would require private entities to delete all biometric identifiers by a specific deadline or upon request, which may conflict with researchers' obligations to maintain and report information collected for biomedical research. So with that, I'd be happy to answer questions or to get back to you for the work session. And I will participate, be present for the work session. Thank you for your time this afternoon.
We're all wishing it was still this morning. Thank you very much.
I almost said that.
And are there questions for Ann Robinson from committee members? If so, please raise your electronic hand and I will be on the lookout for your real hand, Senator Carney, if necessary. I am not seeing any. So again, thank you very much for your time and the submission of written testimony as well.
Thank you very much.
Greatly appreciated. One last tour of the attendee room. Are there any other persons in the attendee room wishing to testify in any capacity on LD 1945? And seeing none, having heard from all members of the public who wish to be heard on LD 1945, I now call that hearing closed, extending out Representative Thorne.
Sorry, Mr. Chair, I was trying to time that after you closed it. My question was in reference to a term that Senator Carney used, and I just, for clarification, what the acronym was. Was it GLIPA?
I used two. I used HIPAA, the Health Insurance Privacy Act, Health Information Patient Privacy Act, I think it stands for. Right. And the other one was something that I had never used before, but came up in some of the bankers' testimony. And I think it was GLIBA, GLBA. But I think we'd have to look at the testimony from some of the bankers to specifically say what that stands for.
All right, thank you. I just was wondering what the acronym was so I could look it up. Thank you.
Okay. And again, with that, you're very welcome. I will close the public hearing on LD 1945. Expressing our thanks to the bill sponsor, Representative O'Neill, for bringing that bill forward today. Thank all committee members and all persons who came to testify. And with that, I will turn the virtual gavel over to my co-chair, Senator Carney.
Thank you, Representative Harnett. And so we'll now open the public hearing and this is our last public hearing of the day, on 1958. Which is an act to amend the Maine Parentage Act with regard to presumed parentage. And this is being presented by our committee co-chair, Tom Harnett.
Thank you, Senator Carney and esteemed colleagues of the Judiciary Committee. My name is Tom Harnett and I represent House District 83, which includes the town of Farmingdale and the city of Gardner. I am here today to introduce LD 1958, an act to amend the Maine Parentage Act with regard to presumed parentage. This bill comes as a recommendation from the Family Law Advisory Committee, known as FLAC. It provides clarification and guidance for challenges to the existing legal presumptions of parentage in the Maine Parentage Act. This clarification and guidance includes cross-references to the best interest of the child factors that are already found in Maine statute. I asked the committee to pay close attention to the thorough report to the Maine Legislature Joint Standing Committee on Judiciary, prepared by FLAC and dated February 18th, 2022. That report is contained in the committee's electronic file. You will see that this bill advances the goals of the Maine Parentage Act that was most recently amended by this committee last year in 2021. That legislation was child-focused and recognized that families can be gender-created in several valid ways, with the parents recognized as legal parents. Maine law states, quote, "Every child has the same rights under law as any other child without regard to the marital status or gender of the parents or the circumstances of the child's birth." It is important to keep in mind that the amendments proposed in LD 1958 do not change or expand the scope of legal parentage under the Maine law. That has already been established in the Maine Parentage Act. As the report supporting this bill makes clear, FLAC believes it is in the best interest of children and families to amend the law and make it clear that when there is an attempt to challenge or rebut the marital presumption of parentage, the court must consider certain factors and reach the outcome that reflects the best interest of the child. LD 1958 also makes some cleanup amendments to the law we enacted in 2021. Those amendments reflect needed language that were inadvertent, needed changes in language that were inadvertently overlooked last session. Representatives from FLAC and others who work with these statutes regularly are here to give you a more detailed explanation of the bill before you. While I'm always happy to entertain questions, it would be in your best interest to defer those questions until after you hear from the FLAC's representative and others. I thank you for the opportunity to present this bill for your consideration.
Thank you, Representative Harnett. Committee members, are there any questions for Representative Harnett? I am not seeing any, so once again, many thanks. And now turning to those in the attendee portion of the meeting, if you are here to speak in support of LD 1958, please raise your hand and keep it raised. And we will bring you over to the panel. And Supi, I have lost my power to move people back and forth between the panel and the attendee space. So could you please move Deirdre Smith and Debbie Willis to the, oh, I see that you have empowered me. Thank you. So we'll hear from Deirdre Smith and Debbie Willis. And if there's anybody else who wishes to speak in support, please raise your hand and keep it raised until you've been brought onto the panel. And Professor Smith, welcome to the Joint Standing Committee on the Judiciary. You can begin your testimony when you're ready.
Good afternoon. Thank you. Good afternoon, Senator Carney, Representative Harnett, and other members of the Joint Standing Committee on Judiciary. My name is Deirdre Smith. I'm an attorney and a member of the faculty of the University of Maine School of Law, and I'm testifying today at the request of the Maine Family Law Advisory Commission in support of LD 1958, an act to amend the Maine Parentage Act with regard to presumed parentage. LD 1958 is a bill submitted by FLAC to provide important clarifications and guidance for courts and litigants in disputes regarding one of the ways to determine parentage of a child under the Maine Parentage Act, and that is namely when circumstances give rise to a presumption that a person is a parent of the child. And by way of brief background, the Maine Parentage Act was enacted in 2015 as Chapter 61 of Title 19A to create a comprehensive framework for determining legal parentage. It sets out 8 different routes to establishing a child's parentage. One of those pathways is presumed parentage, which is described in subchapter 4 of the MPA. Maine has long had a marital presumption as a way to determine parentage. The presumption is that both spouses of a married couple are the parents of a child born during that marriage. And that presumption is now set out at Section 1881 of the MPA. And just as a general matter, a legal presumption provides an evidentiary shortcut to a legal finding. It means that if certain facts are true, a court can assume or infer from those facts alone that a certain other fact is also true. Thus, from the fact that a child was born to one person in a married couple during that marriage, a court can presume that both members of that married couple are the child's parents. But legal presumptions can be challenged or rebutted if a judge concludes that a person has presented sufficient evidence to overcome that presumption. If there isn't enough evidence, the presumption stands. Under the traditional marital presumption and the days before genetic testing, a presumption might be rebutted with evidence, for example, that the spouses were physically far apart at the time that a child would have been conceived. The MPA provides that the marital presumption can be challenged or rebutted, but it must take place within the first 2 years of a child's life, with some limited exceptions, because we want certainty and stability in the identification of a child's parents for the child's benefit. But the MPA lacks guidance on how a court should review timely challenges to the marital presumption. Therefore, LD 1958 proposes a standard to be applied when there's a challenge to the marital presumption within 2 years of the child's birth, including a challenge based on evidence that another person, not one of the spouses, is potentially the genetic parent of a child. And specifically, 1958 would require a court to consider certain best interest factors, which are already set out at another part of the MPA when adjudicating parentage in a challenge based on a claim that a presumed parent is not a genetic parent. And if I can just briefly explain, the approach is consistent with the Maine Parentage Act and Maine Family Law policy generally. I see that my time is up, so I can explain further in response to any questions. And I'm also happy to be available for the work session if that would be helpful.
Thank you very much. And this is such a specialized area of the law that I would ask if you could please continue and explain a little bit further for the benefit of the committee.
Sure, absolutely. As I was about to say, it's consistent, and one of the reasons why FLAC thinks that this standard and using this cross-reference to the best interest standards that are already in the Maine Parentage Act, those standards are set out in a different subchapter, the subchapter with respect to whether or not a court needs to grant or deny a motion for genetic testing. But it's the same policy goal there, which is that when there are disputes about establishing parentage, it's really important for the interests of the child to be a foremost consideration for the court. That's certainly part of the policy goal of the Maine Parentage Act generally, and really all of Maine family law policy as a whole. One of the other amendments that FLAC recommends is part of those factors also include a cross-reference to section 1653.3, which is the sort of standard array of best interest factors that courts are quite used to applying when there are disputes about parental rights and responsibilities. So that's the first reason why this approach, FLAC believes, is very important to ensure consistency within the MPA. The other way that this approach would be consistent is that it recognizes another policy change that the MPA brought about itself, which is that a genetic connection to a child alone does not make someone a parent, and a lack of a genetic connection alone does not preclude someone from being a parent. Again, the foremost consideration really needs to be the child's interests. And LD 1958, as Representative Harnett indicated, includes some other language tweaks and signposts and sort of cleanup language that FLAC picked up while it was developing the proposal that's in 1958.
Thank you very much. Committee members, are there any questions for Professor Smith? I'm not seeing any. I recall, oh, we do have a question from Senator Keim. Go ahead, Senator Keim.
Thank you. Nice to see you, Ms. Smith. So this, basically this change is going to apply only to children who are 2 years old and younger. Did I understand that correctly?
Exactly. Yeah. So when we're dealing with the marital presumption and challenges that are raised before the child's second birthday.
Mm-hmm. And then who can order, can the Department of Health and Human Services order genetic testing? Can they request genetic testing?
I would say Debbie Willis is here to testify. So my guess is that you'll probably get a better answer to that question from Attorney Willis about the specific opportunities when the department would be involved. The primary proposal that's put forward in 1958 that FLAC was concerned about really has to do more with challenges that might be raised by one of the spouses or by a third party before the child turns 2, who is claiming that the presumed parent is not the genetic parent. And so that person might be coming forward claiming that they're the genetic parent, or the other spouse might be denying that the presumed parent is a genetic parent.
Right. So the way I understand this, the court can refuse to order the genetic testing if it's been asked for by someone who's wanting to to fight this.
And that's existing language in 1912 in section 1912. So that's already part of the Maine Parentage Act. All of this is the only change that 1958 is making is clarifying if there's a claim that a different person other than the parent is a genetic parent. It's not making any changes with respect to who can order testing and when testing is appropriate. It's simply that when there's a claim and perhaps there is proof that a different person is the genetic parent of a child, that in itself doesn't answer the question of whether the presumption is rebutted. If it's brought timely, at that point, it kicks over to those best interest factors.
Okay, so, but you're saying, according to your reading of it, that the department on its own, the Department of Health and Human Services, couldn't bring forward a claim to say that they doubt parentage and are asking for, they couldn't be that party on their own.
I only in unusual circumstances, but no, that's not what's contemplated with this.
Okay,
if there are some exceptional circumstances, the department can do that. I'm sure Attorney Willis can address them, but that's not what this bill is aimed at.
Okay, thank you so much.
Thank you for your question, Senator Keim, and for your answers, Professor Smith. Committee members, any other questions? Not seeing any, and we appreciate your offer to be with us for the work session.
You're welcome.
And next we'll hear from Debbie Willis, and welcome back to the Judiciary Committee.
Thank you, Senator Carney. I'm Debbie Willis. I'm a resident of Gardner. I'm here today as an Assistant Attorney General. Senator Carney, Representative Arnett, and members of the Judiciary Committee. As I said, I'm Debbie Willis. I'm an Assistant Attorney General, and I'm Chief of the Child Support Division here in the Office of the Attorney General, and I'm here to speak in favor of LD 1958. I was part of the working group for FLAC. I am not a member of FLAC. I'm sort of counsel, I call myself. The Child Support Division handles over 2,000 cases each year, so we're very interested in family law. The proposed amendments do not add new pathways to parentage. They already exist. There are marital and non-marital presumptions, and I've cited the statute in my written testimony. And we also have, as you heard Professor Smith say, there's also a section 1912, subsection 2, which are factors for the court to consider when ordering genetic testing for a child, or if there's been testing, whether to admit that into evidence. These proposed amendments provide guidance to the court on using these factors when a presumption is challenged before a child turns 2. With a cross-reference to the section 1912. So if someone's bringing this action and the child's not yet 2, here we have a cross-reference. And we also have a cross-reference to section 1653, which is what I call the best interest factors for a child. These amendments are proposed to make clear that the factors must be applied not only in questions of genetic testing, but in proceedings to adjudicate parentage when there is an attempt to rebut a claim of presumed parentage. They also clarify challenges to parentage of children born through assisted reproduction and gestational carrier agreements, not my areas of expertise, both, but they are not, which are not decided on genetic testing alone. There are some cleanup amendments as well to the old wording of acknowledged father and paternity, which were inadvertently overlooked when the Maine Parentage Act was amended in the last session. The acknowledged father was amended to acknowledged parent, and I apologize for not catching them all. Finally, the proposed amendment is also to 1911 subsection 3. It replaces a broad reference to the entire Department of Health and Human Services with a more targeted reference to the Division of Support Enforcement Recovery, which is my client. This change would allow the Office of Child and Family Services, OCFS, to pursue genetic testing in situations where parents have already been defined by the NPA. So it currently says if there is a legal father on a birth record, you cannot ask for genetic testing or challenge that. That prohibits OCFS from requesting genetic testing if there are two parents on the birth record. One practical problem for OCFS is that father is listed on a birth record, but the mother tells OCFS she believes another man is actually the child's biological father. This amendment would allow OCFS to seek an order for genetic testing to determine if he is the biological father. OCFS could then fulfill its core mission of timely identifying and assessing the safety of all parents of children subject to child protection proceedings. Thank you for your time today, and I'd be happy to address any questions now or at the work session.
Thank you very much. You came in right when the timer went off and I was startled by the noise. Thank you for the absorbing and interesting testimony. Committee members, are there any questions for Debbie Willis? Right, I'm not seeing.
Okay. I can answer on Senator Kime's question. Senator Kime, you asked if the Department of Health and Human Services cannot order genetic testing. If we want genetic testing, we have to ask the court for an order on genetic testing, and the court can deny that order for request. But Senator Kime, we do ask for orders on genetic testing before a child turns 2. A good example would be a mom who's married and her husband is incarcerated and has been. So he's has been in a penal institution for say 2 or 3 years. I've handled these cases myself. And a child is born of the marriage. Legally, that child belongs to the husband, but we know that he's been incarcerated, and we will ask the court for an order on genetic testing. That's about the only times I can think of is when the husband has had no contact and no ability to have contact with the mother. And we make that husband a necessary party to the proceeding, so he knows that we're doing something. He's served a copy of the complaint, for example. Well, it is a complaint. Is that helpful? Yes.
Go ahead with your question, Senator Kime.
Yes, that is helpful. So I guess why would the department, unless the mother or the father who's in jail comes to you to say they want that genetic testing, why would the department step in and request it?
Yes, we would do that at the request of the parent. We don't go around looking for family members who to whom these facts might apply. So if the person receives public assistance, they assign their right to support to the department. We might do it in that case. And also we have what we call non-welfare clients of the department. So we have parents who come to the department and ask for services.
Okay, that's helpful. Thank you.
Thank you.
Committee members, any additional questions for Debbie Willis? Not seeing any. We appreciate your testimony today.
Thank you.
And next we'll hear from Mary Bonato. I think that takes us through everyone who wished to speak in favor. And if there's anybody who wishes to speak in opposition to LD 1958, please raise your hand and keep it raised until I bring you onto the panel. And Mary Bonato, welcome back to the Judiciary Committee. You can begin whenever you're ready.
Thank you, Senator Carney, and good afternoon, everyone. It's good to see the whole committee. My name is Mary Bonato, Portland, attorney at GLAD. And, we do testify on these bills because the Maine Parentage Act is just, such an important innovation for everyone and has really been imitated elsewhere, as I've set out in the testimony. But I wanted to say just very briefly that GLAD is extremely grateful to FLAG for catching this omission from the Maine Parentage Act and the work in drafting and putting together the report. And this really does address something that is very, very key. This marital presumption that's been referred to already is something that exists in every state. The law around it can vary, but it's one of the oldest presumptions in law, period. And it's extremely important in protecting marital families in the way that Professor Smith described. You have a child in the marriage, it's going to be presumed that that child is your child. So it's an extremely important thing. But in crafting the Maine Parentage Act, when it came to presumptions, what happened was that there was not an issue. What was not addressed, and what this bill does address, is what you do when there's a married couple and there's a challenge to the presumed parent before 2 years have passed. After 2 years, there's no challenge, because at that point, all the child welfare literature is just so clear about the amount of bonding that's happened, and it would be damaging to the child. So we're talking about before 2 years. So this bill fills the gap, primarily in how Professor Smith and as well as just testified about using the existing best interest factors. But I wondered if it would be helpful to give an example of how this comes up. I'll try to just do that very quickly. So this is why lack of guidance in this area matters. So take an example like this, where a wife gives birth to a son, and the son was conceived through an extramarital affair. The wife informs the husband about this. The couple recommits to their marriage. Husband attends the birth, welcomes the child, raises and loves that child. He's on the birth certificate. They're a marital family. The marital presumption applies. Nobody's questioning this. But then within the 2 year period, somebody else comes forward and says, I'm actually the genetic parent here. I'm the biological father. And even though that person has known about this relationship or connection from the outset, has done nothing about it. So at this point, let's just assume the son is maybe 22 months old. The question is, what is the standard that the court is supposed to apply? And that's what's missing. And so I do think that Flack came up with a very elegant solution of taking the standards that already exist about whether you order a genetic test and putting them here. Because when you look at those standards, sorry, I've got them here. They're really things like, how long have you been sitting on this information, and why, okay, I'll stop. I heard the time. But there are standards, and that's why we think this is a good innovation, and I hope you will consider passing the bill. Thank you.
Thank you. And I think the example was very helpful. Committee members, are there any questions for Mary Bonato? Go ahead, Representative Hagan.
Thank you very much, Madam Chair. I missed the end of that, the end of your story. I apologize. I couldn't hear. Trying to pay attention. Could you just recap the latter part of your story? Thank you.
Sure. Yes, I know. And I was rushing because I heard the little beep.
And my apology as well.
No, not at all. Yeah, so assume that this person comes forward after 22 months. So technically speaking, that person has come forward in a timely fashion because that marital presumption is not ironclad until 2 years, right? But then if the person comes forward, the question becomes, what standard does the court apply in determining parentage? Without a standard, are they left to infer, well, because it said 2 years, this person can come in and displace this marital parent, insert themselves into this married family as a parent. Displace the existing father. So this bill is really intended to address that gap and say we need to have a standard. And as I said, I think there's been a good solution in terms of borrowing from the existing lawfulness of the statute and the standards that you keep hearing 1912, and 1912 is actually referenced in our testimony as well in a long footnote. So you can see those criteria that are very sensible criteria that have to do with definitely the child and the relationship the child has with the existing father and this presumed person, this other person coming in. But in addition, just how long have people been sitting on this information, et cetera, et cetera. Does that help, sir? Representative? Okay.
Committee members, any additional questions for Mary Bonato? Not seeing any other questions. Thank you very much for your testimony today. And I'm sorry that I interrupted you right at the end. I should have let you continue.
Thank you very much.
Okay, thank you. And I have not seen anybody in the attendee space who wishes to testify in opposition.
So I'll ask just one final time. If you wish to speak in opposition to 1958, please raise your hand. And now if you wish to speak neither for nor against 1958, please raise your hand. And I'm not seeing any hands. And so with that, we will close our public hearing on LD 1958. And we are done with our public hearings for today. Excuse me, we have 2 work sessions this afternoon. I'd like to propose that we take a half-hour break, kind of a very late lunch break until 2:45, and then reconvene and do our work sessions. Is that okay with everybody? All right, I'm seeing some thumbs up. All right, see you all at 2:45. Thank you. Hi, everyone. Committee members, if you are back at your desks, could you please turn on your audio and video? And Representative Evangelos, you came back briefly and I had to mute you because your audio was still on. Are you able
That's
to?
bad.
You're back in business? Okay.
No, I mean, how bad was the audio?
It was just shuffling papers.
Oh, thank God, because I've had a constituent matter and the constituent's been here at my kitchen table, dining room table, and it's a really difficult day for him. And, you know, there's been some colorful language.
Oh, no, all I heard was paper being shuffled around and.
Okay, thank you.
Yeah.
Yeah, he's tough. He's 87. It's really, it'll work out.
I hope so.
And
Okay, so
I sent you an update in a text, just so you know. Thanks.
Oh, okay. Give me just 1 minute then. Okay, thank you, Representative Harnett. And so, committee members, I have the virtual gavel for our work sessions this afternoon. We are going to start with LD 1888, and then we'll move on to LD 1310. And for 1888, the bill sponsor is not able to be with us, but I believe that that Senator Bailey is able to be here, and she's the lead co-sponsor. So Senator Bailey, I'm going to bring you onto the panel for the work session. And as always, committee members will start with Peggy's bill analysis. Thank you, Peggy.
Thank you. This is actually the second work session on this bill. And I think you were coming to some kind of resolution. The bill amended the criminal code with regard to contact with minors, and it also amended the family law statutes to prohibit to add a step before somebody could file for a change in parental rights and responsibilities if they had a conviction for certain child sexual assault crimes. FLAC looked at that and gave you a report at the public hearing that said, we think it's really better not to have that kind of barrier for somebody filing an action, but it would be really great to give the court the authority to ask for, to order a forensic risk assessment when necessary, and when necessary, or when it would be helpful to the situation to determine parental rights and responsibilities, and agreed that it would be good to have a new subsection in the parental rights and responsibilities section of Title 19A rather than kind of grafting on the existing law. And so you had some questions at that work session. I think that you were going on, you were kind of adopting what FLAC was recommending with regard to giving the court that discretion and not making it a barrier to filing for a change. And but you had a couple of questions, and one of the questions was who would pay for this risk assessment, and was FLAC recommending no changes to the criminal code. And not only did some FLAC folks work on that and work with me to put an amendment together, but they are here. Frank Brooks and Melissa Martin are both here from FLAC and they can serve as a resource and answer questions. But they did work on this amendment. And I do have one more thing to add after we go through this, which is Kent Avery, an AAG who works with I'm gonna forget the name exactly of the entity. He's the chair of the Sex Offender Management and Risk Assessment Advisory Commission. And he had presented, or he had sent in written testimony on the bill about not using SORNA, the Sex Offender Registration Notification Act, as a shortcut to naming the different crimes that you want to cover. So I'll get to his question later. So you can look at the amendment that replaces LD 1888. Senator Bailey, I'm sorry that I had not sent this to you directly. I think I did send it to Representative Gramlich, and I will be happy to forward it to you, but it's also in the electronic LD file.
Okay. So maybe we should bring Frank Brooks, and I'm sorry, can you remind me of the other?
Melissa Martin. They're both
Thank
members
you.
of FLAC, and they are particularly qualified to talk about this. Frank is actually, he's, I'm not sure what his credentials are, but he provides kind of the counseling aspect and the mental health issues and behavioral aspects to FLAC. And Melissa works with Pine Tree Legal Assistance. And so they worked quite a bit to put all this together for you. So I'm not sure the best way to go. Can I, maybe if I share my screen and show you the amendment, and then if you have questions for Frank and Melissa, you can ask those questions.
I think that's great. First, let's do some welcomes. Welcome, Senator Bailey. Thank you for standing in for the bill sponsor. And welcome to Frank Brooks and Melissa Martin as well. We're happy to have you join us. And then Peggy, I think whenever you'd like to share the screen, we're ready. And committee members, because when we're in this format, I can't actually see your physical hands, please use your electronic hands when you have a question.
Okay, so this is the amendment. I sent it to you last week to give you a chance to look at it. It replaces the bill. So anything that was in the bill is gone. And this creates a new subsection in the section in Title 19A about parental rights and responsibilities. It's going to look very similar to what we last talked about. So either party or the court by its own motion can order a parent to complete a forensic risk assessment that's performed by a licensed clinical social worker, psychologist, or psychiatrist qualified to conduct psychosexual evaluation. In determining whether to order the assessment, the court may consider, so it's not mandatory that the court order it, and the court may consider these things as well as D as any other factor the court considers relevant. So this tries to pull in the concerns that Representative Gramlich had. So the existence of any court findings, including criminal convictions, but not limited to criminal convictions, that the parent has committed a child-related sexual offense as defined in subsection 6A, paragraph A. And there's a whole list of what those are in 6A, that's current law, or sexual exploitation of a minor, or dissemination of sexually explicit material or possession of sexually explicit material as defined in 17A, chapter 12. So those are the child pornography types of crimes, creating it or possessing it. The existence of substantiated findings of abuse or neglect under the child protective system, or an equivalent finding from another state against the parent involving a child-related sexual offense or sexual exploitation of a minor. And whether a guardian ad litem appointed to the case is recommending the assessment, and then any other factor the court considers relevant. The court may order that the person performing the forensic risk assessment, so the person up here, the licensed clinical social worker, psychologist, or psychiatrist, have access to court documents, the ability to interview any parent, records of any interview with the child, and other relevant documents. And the court shall order that the parent ordered to complete the forensic risk assessment be responsible for any fees associated with the assessment, unless the other parent agrees to pay part or all of the fees. So Flack was trying to capture was sometimes the parent who is not the offending parent wants to have that evaluation done. So the court has all the information in front of it and is willing to pay the fees for that evaluation. And rather than saying only the person who's being evaluated can pay for it, this gives the court the opportunity to allow that other parent to pay the fees of that evaluation or that assessment. If the parent has already completed a forensic risk assessment, the court may order the parent to release that assessment to the court, the guardian ad litem, or another party. So that's I think that carries out everything that you were looking for, and it answers the questions you had. And Flack had identified questions and thought they had given you all the answers to those questions. Do you have any questions about the draft itself? Because if you don't, then I can stop sharing.
Let's check in with committee members first. Committee members, are there questions about the text of the amendment? I see that Representative Moriarty has a question. Go ahead, Representative.
Thank you, Madam Chair. Peggy, I have a nitpicking question about the title of the new bill, and I wonder whether the term child custody is outmoded and is used any longer. I had understood it was determination of parental rights and responsibilities.
You are right. If you would like to change that, you're certainly welcome to change the title of the bill.
Well, I just
committee amendment.
Well, perhaps the folks from Flack can verify, but I'd be curious to know what these petitions themselves say as part of the caption among practitioners.
And maybe Melissa Martin would be better to speak to that, but my understanding is the same as yours, that we don't talk about child custody in Title 19A at all. We talk about parental rights and responsibilities, which is, the bigger bundle
Sure.
that includes what we used to call custody.
Exactly. Yep.
Yeah.
Okay.
Okay. Thank you. That's a good suggestion, Representative. And when we're done with the questions about the specific wording of the amendment, we'll move on to ask that question of Melissa Martin.
Sure.
Thank you so much. Committee members, any other questions about the draft that's before us? Not seeing any hands up. So Peggy, I think we're ready to finish with the screen sharing. And then both Melissa Martin and Frank Brooks, could you comment on whether you think it's appropriate to substitute petitions for parental rights and responsibilities rather than child custody?
Yes, and I think we've actually, Peggy can correct me if I'm wrong, we selected where we were going to put this proposal is actually in a section regarding parental rights and responsibilities. So I think that makes sense.
Thank you. Let's see. And I know that both of you worked on this amendment with Peggy, and I think the committee would appreciate hearing a little bit from you regarding the amendment. If you had anything that you in particular wanted to share.
So I'm happy. Would it be helpful to loop back to the two questions that were posed to Flack? Because I don't know that, and I could address those briefly.
Okay.
I'm remembering one of them, but not remembering the other one. So I know one was about the criminal statute and whether Flack was commenting on that. And Flack's position was that it wouldn't have been appropriate in our role as Flack to comment on the criminal portion of the bill. And then Peggy, can you remind me the other question?
I think it was about who would pay for the assessment.
So that's addressed obviously in the portion. So we would only want the parent who, and I think this is sort of part of the original bill, is only wanting the parent who was the offending parent to pay unless the parties agreed to it, right? So we didn't want this to be something that could be distributed on a parent who was trying to protect their child and, filing a motion in court because there had been a criminal case. But we also didn't want to foreclose that option, as Peggy described, if that parent was willing and able to pay, and it made more sense for another, for that parent to be the one who would be responsible and wanted to provide that information to the court. And to be clear, I do think that this will mean that there are cases where parties don't have the ability to pay, and therefore the court won't be able to order the forensic risk assessment to take place. And that's a gap, right? But I don't know that it's one. I don't know that it's one this bill can address, right? And the idea would be to have these forensic risk assessments ordered in cases where it is appropriate, kind of considering all the factors, the ones that are listed in the statute. And then we know that the judges in family court are also going to evaluate things like the cost, the timing, and other factors that they always take into account in making orders.
Thank you. Thank you. That's helpful. Representative Reckitt, did you have a question?
Yes, I just wanted to caution Peggy when she recrafts the proposed title to make sure that it read okay, because I think it's not petitions for parental rights and responsibility. It's probably a petition for change of or establishment of or something. I mean, I
Probably
don't
determination.
Determination of the parameters of parental rights and responsibilities or whatever, but just something that flows. So,
Right, thank
which I know you can do. Thanks.
Thank you. And then Frank Brooks, did you wish to comment as well on the current language before the committee?
No, I agree with Attorney Martin and with regard to the title. And just for your information, I am considered a public member of the commission and representing mental health professionals. And I'm a licensed clinical social worker. And part of my background that is relevant to this particular bill is that at the beginning of my career, I worked on a sexual abuse treatment team at a community counseling center here in Portland. So I have some familiarity with the risk assessment and treatment programming available for folks who are in these particular categories.
Thank you. And so thank you both for your comments. Let's see if committee members have any questions for either one of you before we move on. Looks like Representative Moriarty does. Go ahead, Representative.
Thank you, Madam Chair. I think my question goes to Melissa because I understand that you practice family law. Am I correct in that assumption?
Yes, you are correct. Also, the grant I work under at Pine Tree is I represent pretty much exclusively sexual assault and domestic violence survivors.
Okay, so here's the question. I'm not sure whether or how often it might happen that both parents point at each other and say, in effect, you're not qualified, you're not qualified. And are there cases in which a judge might order both to undergo a risk assessment? And if so, is this language okay? Does it give the judge sufficient authority to order two evals?
I think that would be a pretty rare case, and I'd be interested Senator Bailey's perspective on it too. So as I had mentioned, one of the priority areas in the grant I work under is representing non-offending parents when there are child sexual assault allegations. And I can't think of a case that has come up where both parents have made child sexual assault allegations against each other. It's usually a different type of allegation, right? Maybe one parent is alleging something about sexual assault, but the other parent is alleging something about substance abuse or some other issue. So of course, I think it could happen. Anything is within the realm of possibility. I don't think it would be very common. And I think what the court, you have the judge as sort of a filter, the way we're proposing this, right? So it's not just going to be enough for one parent to point to the other parent and say, I think this is going on. The judge is going to be screening that, and they're going to be screening it through the lens of likely some other professional, right? It's either going to be the guardian ad litem who's already investigating, who's going to say, yes, I think that needs to be done here. The Department of Health and Human Services having made a substantiation, a prosecutor having brought a case based on, a detective's investigation. So although we know child sexual abuse is a lot more common, I think, than many of us thought, I'm going to be hopeful that there won't be a lot of cases where you're going to have that much information against both parents. So I don't think it'll be super common that we're going to have it going both ways, but I don't think there's anything written here that would prohibit the judge from doing that. But my hope is it won't be, there are other types of evaluations, like psychological evaluations, that I see often get ordered by both parents. I think our intent is not that this is going to be happening, that it's not going to be as common that it's happening, and that both parents are going to be ordered to participate in that sort of evaluation. The goal is really that there's a reason why this evaluation is being ordered.
Thank you.
Thank you. Senator Bailey, did you have anything that you wanted to add, or do you think that that covered it?
Just briefly, first, Peggy, yes, Representative Gramlich did share this with me, and her and I actually discussed it. She wanted to make sure that my thoughts on it, and both Representative Gramlich and I are both fine with the amendment, and thank FLAC for their hard work in doing that. And then secondly, just briefly, Representative Moriarty, to your question about if there were credible allegations against both parents, I think the judge would be making a referral to the Department of Health and Human Services at that point. And the department may very well have both parents undergo risk assessments, but I think that's what would happen in those rare instances.
Good, thanks.
Yeah.
All right. Any other questions, committee members, for either Melissa Martin or Frank Brooks, or the bill's lead co-sponsor? Not seeing any. And then Peggy, did we also need to hear from Kent Avery?
Yeah, I don't think, is he? Oh, he is here. Yeah, and that might be better for him to explain. It's not actually issues that you already discussed, but it's looking at the whole kind of universe of the types of crimes or convictions that you might want to include in this. And so I think it's kind of a new issue for you, but it's also related to what's currently in law in section 6A, and I can share that with you as well. So I think that might be really helpful for Kent to talk to you about that.
Okay, and so I've just brought him over to the panel, and I think I'm going to send Melissa Martin and Frank Brooks back to the attendee part of the meeting. We appreciate you being here this afternoon. And Representative Harnett, I see that you had your hand up. Go ahead. No. Okay.
Inadvertent.
So not residual or anew, but inadvertent. We'll have to add that category.
Good afternoon. I don't know if you can hear me.
We can hear you, but we're not able to see you. Are you able to activate your video by any chance?
It does not appear to be working, but let me try one other thing.
Okay.
I'm getting error messages, but I can address the committee. Thank you for having me, Senator Carney, Representative Harnett, and the rest of the committee. We did submit written testimony as well, and I believe that our only concern now with this amendment, and it's not even a concern, just something that we'd want the committee to be aware of, is that there are sex crimes outside of chapters 11 and 12 that the committee should at least be aware of. And I can point out a few that are not enumerated in either the current subsection 6A or in the amendment. And the one that stands out the most is incest. And that's at 17A 556. And there are also several promotion of prostitution statutes that would not be included as well. And I can forward that information directly to the committee as well if you want a better list.
And I can share the email that I received about this if you'd like right now. I mean, I can share my.
That's
screen.
fine with me as well. If the committee wants to see it now, that
Yeah.
might be helpful.
Let's do that because I think we are moving toward a vote on this bill. And so it would be helpful to see the information before we do that.
I'm sorry,
And
is that
consider
really
an amendment.
tiny?
Yes.
It is
It
tiny.
is, okay, let me do something else while Kent talks to you, and I will see if I can.
I'll just continue as that's being done, just by saying that looking at 6A, subsection 6A right now, it appears, which seems to have been enacted in around 2002, that these enumerated statutes were added to this. It appears that the legislature at that point was looking at chapters 11 and 12 of Title 17A, which contain most of the sex crimes in Maine, but not all. So that is why the commission felt it necessary to at least let you guys be aware of the fact, because it's not something that's known to most people. I don't think that there are these certain statutes that fall outside of chapters 11 and 12, but also have a sexual component to them.
Mm-hmm. Oh, Peggy, that's great.
Is that better? Okay.
Fantastic. Okay, and so we do now have that information on our screen. So would you?
Do you want me to just go through some of them and maybe I can further explain?
Please do. Thank you.
So the first item is chapter 30. Is the far left column shows which chapter of Title 17A the offense belongs in. So kidnapping is in chapter 13. There is a subsection of kidnapping that includes kidnapping for the purpose of committing a crime in chapter 11. So that there's a sexual component kidnapping subsection that is out there. Violation of privacy similarly has a subsection that includes, I believe includes, or at least has some component that might implicate a sexual offense. Incest, both subsections of incest are in chapter 23. And then the remaining enumerated offenses are from chapter 35, and those involve promotion of prostitution and patronizing prostitution, but also involve minors as young as, I believe, age 12 and under in the aggravated, at least one of the aggravated statutes.
And just a category question, if we wanted to include these, so for example, the 5 listed in chapter 35, are there other crimes in chapter 35 such that we would need to refer to these specific statutes rather than referring to chapter 35 in whole?
I suppose, I don't know the answer to that off the top of my head. I don't think there are. But I think as a drafting convention, it would be better to name them specifically. I notice, I don't have the amendment in front of me, but, oh, here it is. For instance, the amendment as it's written now, paragraph A ends, dissemination of sexually explicit material or possession of sexually explicit material as defined in Title 17A, Chapter 12. I think it's okay to do that, but I think it's cleaner to enumerate the specific subsections. And so getting back to your question, I think it would be better in this instance to enumerate the specific subsections of promotion and patronizing of prostitution that if the committee chooses that is appropriate to include in the list.
Okay. And one other technical question, I know that we are essentially adding to a list that is found in subsection 6A of this particular section of the statute, section 1653. Should these crimes be added to the list in 6A? Is that the more appropriate way to include them, or should we add them in this new subsection 6C?
I think, my personal opinion, I think it would be cleaner to be in 6A. You've already defined child-related sexual offense. But that would be up to the committee. If the committee chooses to add these sections, that's, I suppose, a policy question that is up to the committee. But if the committee does add any of these offenses, I think they probably should be added to 6A.
Okay. Let's turn for a moment then to the policy question and ask committee members to weigh in on that. And Peggy, would you mind? Yeah, that's great. Committee members, do you need to see the list again from the email, that small chart? Would that be helpful, or? Okay, let's try a discussion first. Representative Harnett, go ahead.
Thank you, Madam Chair. And I'm not sure if this is a question for Peggy or Kent, but do we have any idea why these other crimes were not listed in 6A, 6-A? Because all we're doing is incorporating by reference what is currently listed in 6-A, right?
Right. So the amendment incorporates what's in 6A, subsection 6A, and adds the child pornography pieces, which aren't in 6A. And, you know, I mean, maybe this is for another bill, another time, to figure out if those things should be listed in for the court to take all that into account when 6A is the award of primary residence and parent-child contact with a person who has been convicted of a child-related sexual offense is governed by this subsection.
And I guess that was my question. Is it really a different bill that, as opposed to in this bill?
Yeah, I'm kind of agreeing with you, Representative Harnett, and Peggy, I think it's better added to 6C paragraph A if the committee chooses to add these additional crimes. Representative Harnett, can you comment on that, whether you think we should include these additional crimes?
Well, philosophically, it seems to make sense because they're crimes of a similar nature to what, I mean, they're crimes with a sexual component directed at minors. So there's a logical consistency to having them here. I don't know enough about those. I never practiced criminal law, so I don't know enough about how often those charges are implicated in this type of situation, but they seem certainly similar to what we're talking about.
Thank you. Would other committee members like to weigh in on that policy issue of whether to include these additional crimes? Representative Moriarty, go ahead.
Thank you, Madam Chair. Yes, I agree that they should be added in, because they are essentially of like character to what we already see in the statute. And also, I think that now is probably a good time to do it as opposed to waiting until the next legislature. I realize it sort of complicates the amendment a bit, but I think we ought to strike while the iron is hot if we can.
Thank you for sharing your thoughts. Representative Reckitt, go ahead. But we're not able to.
As you all may remember, I had an initiative last year having to do with prostitution that was passed by the legislature and then vetoed by the governor. And so that's what the only reason I have pause as to whether or not that these particular crimes that you have articulated, sir, Mr. Avery, would be connected to that. And I'm trying to figure it out, and I don't know the answer to that. So that's why I'm a little troubled, just because I don't know whether that would impact what I'm planning to do after I spend several months convincing the governor of the error of her ways and vetoing my bill, which I have not yet done. But
Yeah, well, yep.
so anyway,
just-
the point is, I think I want to know whether those prostitution crimes, which I haven't looked at, have some relevance to kids or not, or custody or parental rights, or just general behavior. So it's hard for me to say whether I want them included or not, just because I haven't read them.
Mhm. Representative Hagan, go ahead. Thank you, Representative Rackett.
Hi there. This seems to be, oh, thank you, Madam Chair. I guess I must have missed the amendment, and I'm a little confused by all the new things that are going on. I originally liked the bill, but I don't feel confident now after listening to what we've been doing in the last half an hour or so. Would tabling be an option with this so we could look at everything more thoroughly, or would I just be the one who needs more time to read the new stuff and understand it?
Yeah, this is our second work session on this bill, but as you point out, it's important, and we're kind of introducing some new concepts. So let's let some other committee members weigh in before we make a decision.
Yeah, I'm not making a motion. I would just,
Yeah.
an inquiry is more what I was doing. Thank you.
Yeah, it's a really helpful suggestion. Thank you. Senator Keim?
Thank you. So I did miss a little bit of the discussion. Sorry, I was on a call. But have we discussed the paying of the fees? So this is saying that the parent that has to take the assessment then must pay for that assessment. And so my question there is, what if they don't have the money to pay for it? And this could be pretty costly, I'm assuming. And did we get any price on what this costs, or who can do it, how readily available it is? Did we get any information on that?
Peggy, did you want to respond to that? And
right.
also
So I think there was some discussion in FLAC, and I think the discussion was they thought it would be around $2,000, and I know that Representative Gramlich thought that it could be done for much cheaper, but I'm not sure if I would think that Dr. Brooks would probably have more information about that if you want to bring him back.
Mm-hmm.
But that's my memory of how FLAC was discussing it, that it could be as much as $2,000.
And Peggy, could you also address the change with regard to discretion as to who pays for it? And I'll bring Dr. Brooks back over.
So the language that FLAC recommends is that the court can order the person who has to undergo the assessment to pay for it, unless the other parent is willing and able to pitch in for the costs.
Right.
And you might, you were part of that. You heard part of that discussion.
Yeah, and I'm reading it here, but I guess then that, then the further concern is $2,000 is a lot of money. So then does someone lose the ability to see their child because they don't have $2,000? So, and then before the doctor comes on, one other question I had was this amendment, Peggy, is there ample time that the people that testified in opposition were able to see this and give us comment on the revised version? Did we get comments? I know in opposition we had the Maine State Police, which I think we handled. I mean, I think this addresses that, but
right. I think that the people who testified against, if I remember correctly, were concerned about the crime, changing the crime, and not so much the parental rights piece of it.
Okay.
I will double check.
And Frank Brooks has rejoined us. Thank you for jumping back and forth on our behalf. Could you please give us some information about how much these assessments would cost?
Yes, I can give you an estimate of what a licensed clinical social worker with whom we consulted would charge for a psychosexual evaluation that included conducting a 3 to 4 hour clinical interview, review of records, and also using certain instruments that have been researched and found to be valid and reliable. And that would be about $2,000. However, the clinical social worker we consulted with said that that could run up much more with a licensed clinical psychologist or psychiatrist, depending on how they approach the case and how much time they spent on it.
Okay, thank you. Senator Keim, it looks like you have a follow-up question. Go ahead.
Yes, I do. Thank you. And the other question I had is also the availability of those types of people. Are they readily available?
There are a limited number of clinicians who are qualified to do those types of psychosexual evaluations. And there are national standards that are out there that help guide those evaluations. But our consultant said there are probably 8 to 10 in Maine who he would feel comfortable referring to and know that they have his level of expertise and experience. So it is limited.
Thank you. Thank you.
Representative Libby, go ahead with your question.
Thank you, Madam Chair. I am not sure who to address the question to, but I'm sure Peggy can be helpful with this. I have no issue. I can understand A and B, but I need to understand C and D a little bit better under the 6C forensic risk assessment on the amendment. And I guess my question for whomever can answer it circles around the guardian ad litem. Would the guardian ad litem's recommendation be stemming out of A and B related to whether that is prior criminal convictions that they know about, et cetera? Or would there be potential for the guardian ad litem to be recommending it for reasons that are not related to a sexual exploitation? I'm just wondering if that is more broad, or if it just leads to judicial discretion. And then the same thing with D, any other factor the court considers relevant. Relevant in that same area of exploitation or different? That's my question. How broad?
Representative Libby, I think Melissa Martin has her hand raised in the attendee space. She is a practitioner, so I'm going to bring her over as well to answer. And Peggy, you can start if you'd like, and we'll hear from Melissa as well.
So I don't think paragraph C is limited to what's in A and B, but also you were talking about parental rights and responsibilities, family matters, where, if you remember, there aren't a lot of guardians ad litem appointed because the parents have to pay the cost. The state, the court does not pay for a guardian ad litem in a family matter case. It's only in child protective cases. Okay. So I'm not sure how often that would be the case, but if it is the case, then of course, if the guardian ad litem recommends it based on whatever, I mean, there might be evidence that didn't rise to the level of a conviction. The court is always asking for recommendations from the guardian ad litem. That doesn't mean the court has to do what the guardian ad litem recommends.
So a quick follow-up then, if I could, Madam Chair. So what you're saying is that this would be a guardian ad litem that would already be in the realm of not a family matter, but a safety a safety issue where the state is already involved. Is that correct?
Maybe Melissa will bail me out. I'm not sure that you're going to get any petitions under this if you're in a child protective case where a guardian ad litem would already be appointed and paid for by the state.
Okay.
You might be. I'm not sure how those cases intersect.
Okay.
So Melissa might be a really good resource for you there.
Thank you.
I think this is going to apply to 19A proceedings because it's in Title 19A. So that's going to be divorces with children, parental rights cases, so unmarried parents who are separating, and then post-judgment motions. So people who already have an original order like this and are coming back maybe because something happened. Maybe the disclosure of child sexual abuse could be the reason they're coming back to court. The reason we put in the provision about guardian ad litems, and I want to let Senator Bailey talk because I see her hands up, but I'll just speak briefly on this point. Because this has come up in some of my cases, you might have a situation where a child discloses child sexual abuse potentially to the guardian ad litem, and there isn't DHHS involvement because maybe they're not seeing the parent that they've disclosed has abused them. And DHHS says there's no safety risk here because you're with a safe parent. There's an ongoing family court case. And for whatever reason, there might not be a criminal investigation or prosecution that happens. Or maybe that investigation has started, but we're not at the point of having a conviction. So there can be situations, I think, and part of the reason we put this in is we don't want these cases to fall through the gaps where you have a child disclosing these types of incidents to someone like a guardian ad litem and the court's hands are tied because there isn't, this other involvement from DHHS or the criminal system, because we see that those gaps happen sometimes, right? There's not always going to be a DHHS investigation or a criminal case. And we want guardians to be able to say, hey, this child disclosed this action to me, this incident to me, or this pattern, right? And I really think that there needs to be a recommendation that this parent get a forensic risk assessment, and the court can evaluate that and decide whether they're going to order it.
The follow-up, if I could. Madam Chair. Thank you.
Yes.
So in your view, then D would not also cover C? Any other factor the court considers relevant?
I think it could. I mean, I think you could have, presumably you wouldn't need to have any factors listed, but I think we wanted to provide some guidance, and we were trying to think of what are the situations, what are the ways that children are coming forward, or that this information is making its way to the court. And I think the most common ones are what we listed, right? So the criminal investigation, DHHS, other court findings. But then I do think there's a chunk of cases where the guardians get told information directly, and they're sort of put in a position of what do we do now? And I think that should be enough to at least trigger the court to say, okay, if a child has disclosed child sexual abuse to the guardian ad litem who's investigating the case, at that point, maybe we should be thinking, do we need to take more steps to make sure that this child is safe, right? I think that should be enough to at least instigate that analysis by the court.
Thank you. That's very helpful.
Thank you. Representative Reckitt, did you have another question?
Well, what I wanted to do is say that now that we've had this discussion, I'm clear about the parameters and where this all came from and how it melded in. And I am fine with the amendment as it's been presented by FLAC, but I would not want to fool around with it, frankly. I think it's fine as it is. I think it will catch what we're trying to do, which is child sexual abuse. And that's relevant to a Family Matters case, and that's fine. So I'm not wanting to, this is going to catch kids that are trafficked. That's part of my concern, but I don't think it's going to be too broad. I mean, I think it's okay. The amendment to me feels okay now that we've had this discussion, although I do share some of the concerns that people have raised around costs. That was the first thing that popped into my head when I read the thing. But on the other hand, if somebody has a history of child sexual abuse and they're trying to get more access to their children, I think they maybe are going to have to buck up and, and figure out how to pay for it. So I talked myself out of that problem as well. Thank you.
Okay. Thank you. Senator Kime?
Maybe Representative Reckitt can talk me out of my problems too. Okay, so my question actually is for you, Ms. Martin. So talking about C&D, they just, given the fact that there's limited people that can do these assessments and they are very costly, as you were talking about how in this instance, the guardian ad litem is paid for by one parent probably, right? Or by both parents?
It could be one parent, could be both parents. There are
Okay.
also guardians who provide their services pro bono.
Okay, so in the instance, I guess, that there was one parent paying for the guardian ad litem, it seems a bit that the guardian ad litem then has some alliance or allegiance to one parent. And then I guess I wonder why we even need that in there, because if a guardian ad litem came to the other parent and said, I think there's a problem and you should ask for this assessment, wouldn't the parent ask for the assessment? And I guess what C&D looks to me like is very broad, like basically anything the court comes up with and anything the guardian ad litem comes up with, they can ask for their risk assessment. So are we just being so broad here that with something that it could also be used as a weapon?
I guess at that point, I would say I don't think, I guess what I will say is I really don't think that because a guardian ad litem is paid for by one party that they are biased at all in favor of that party. With where I work at Pine Tree Legal Assistance, it's very common that the other parent is paying for the guardian ad litem. And guardians have a number of like stringent requirements and ethical requirements to conduct a neutral quasi-judicial investigation. And so I don't have that concern that they're going to be swayed by who the parent is that's paying them. It's also pretty common with the guardian ad litem appointment orders that it is common that both parents are paying some portion, although it may not be completely 50-50 depending on their income. And often they're subject to reallocation at the end of the case, right? So that who paid up front might change later on, it could be redistributed. So I guess I just want to say that right off the bat, I don't think that the guardians, I do think that they come in neutral, and I don't get the sense that they will recommend a forensic risk assessment except when they think it's necessary. But assuming sometimes they are recommending it for what, like you're kind of saying, like thin reasons, right? Like something that maybe you're thinking is not a sufficient reason to make someone pay $2,000 to get this forensic risk assessment. Well, there's a second layer of review because this motion is going to go in front of a judge, and the judge is going to have to be persuaded, right? And I think we see this, in family court for all sorts of reasons. I mentioned the psychological evaluations. Even when we're talking about appointing a guardian ad litem, our family court judges are pretty sensitive to the fact that anything they order in a case has cost and it delays the case, right? And those are always two factors that they are, I think, holding on one side and then saying, but is this going to give me information that will help me make a better decision that's within the best interest of the child? And so I think they balance that well. And you have that second level after the guardian who already is conducting that first level of like neutral child-centered evaluation. You have that second level with the judge. I do think though, if you have a guardian who says, I had this 13-year-old child describe this really horrific incident to me. I found it credible. I think it happened. I recommend that we take some steps in this case because I think this parent is potentially at risk. I think the judge is going to take that seriously, but I think that's the right outcome, right? And I guess the guardian has access to information in that they are doing these direct interviews with the child that the judge does not have. And so I think that is an important path.
Okay, thank you.
Representative Libby?
Thank you, Madam Chair. I think my question is for Mr. Brooks, and it is related to the evaluation. And given the small number of folks in our state who are qualified to do these evaluations, first of all, is this something where telehealth can be utilized? And secondly, sorry, my device is low powering. And secondly, when someone has a forensic risk assessment ordered, is it something where we're talking a 6-month wait for that to happen, or is it something that's relatively swift?
With regard to telehealth, I think telehealth is now a necessity for a lot of, at least certain parts of an interview. But I know that the preference would always be to do that interview in person. And but I think telehealth could be utilized under the present circumstances, even with the improvements that are happening. I also think that with regard to the second part, I think, and Melissa and I discussed this, I think that it could take some time to get onto someone's schedule to get the assessment done. But I know that the consultant we talked to understands the importance of the evaluations and would try to prioritize those. Whether or not other practitioners would do that, I'm not sure. The person, the clinician's concerns mostly were around people who might present themselves as qualified to do these evaluations and not have the breadth of experience and training necessary to do them. That was their major concern. But I can't speak exactly of the time frame that would be needed in all cases.
Okay, a follow-up if I may, Madam Chair.
Go ahead.
Is there a ballpark you've seen in your experience? I'm wondering if we're talking 2 weeks here or 6 months or somewhere in between. And I'm not asking for a specific, this is what we always see, but a best guesstimate.
I would say probably between 1 and 2 months.
Okay, thank you very much. It's very helpful.
And under the best of circumstances, maybe a couple of weeks.
Okay. Thank you.
Mhm.
Representative Poirier?
Thank you, Madam Chair. And I'm not quite sure who to direct the question to, but looking at the amendment and seeing, the types of the sexual exploitation of a minor, the offenses that the people may have had that are leading to this in the first place. Is there any likelihood that the person may have already had an assessment done anyway, prior to this coming about? I'm just trying to come into my mind how many times this may come into play versus are we skipping a whole assessment in the first place because it's already been done?
Yeah, I think that is referenced on the second page of the amendment, but Melissa, did you want to speak to that?
I was just going to mention that we specifically added that because there have been cases where the forensic risk assessment has been ordered in the criminal case and somebody has completed it, a criminal defendant has completed it, and then later filed in family court and made it challenging basically for the other parent to get access to that. That was a problem we wanted to solve. And because I think sometimes that information does already exist and should be provided to the court.
So just to follow up, if I may.
Yeah, go ahead.
So if it's already been done, then they don't have to pay this fee. They can use one that has already taken place. Is there a time frame, how far back that can be, or anything like that with this bill?
Yeah, so Frank and I think can both address this. This was something that came up, and I think, Frank, correct me if I'm wrong, I think the time frame of like 6 months or so was, or 6 to 12 months was something Phil, the person who was qualified that we had talked to, said, you know, he wouldn't, these aren't good forever, right? And obviously also the hope would be that if a person had a forensic risk assessment and there may have been some recommendations of treatment, right? If some of that treatment has happened, then the recommendations could change. So I think that these can be valuable, but I think they do have a limited time frame for which they are useful for.
I agree with Melissa, and I would think a year would be an outside parameter to look at. I also think I would emphasize what Melissa also mentioned, that if there are treatment recommendations, which there should be at the end of an evaluation, I think it would give the court a lot of really important information about whether or not that person was able to fulfill those and follow those recommendations and fulfill those. And that would look very, if that person has been doing that, has sought treatment and is doing everything that was recommended, that would be actually a very good evidence. That would be good evidence for the person who had the assessment done. And there are cases like that where people really have taken the evaluation seriously and have benefited from the treatment.
I think that this raises the original, I'm guessing, and Senator Bailey might be able to speak to this more, the original purpose is the judges are not mental health professionals. So they don't know what to do once they see evidence that a person has had an issue with a child-related offense. And so I think the reason that these are such a valuable tool is because they can really give the judge a guide of what is the appropriate treatment based on this particular person and all the evaluations that are done. And without that, I feel the judges are really don't have the information they need, in my opinion, to make a comprehensive order that will allow that parent to be a safe parent for the child. And they're really guessing, supervised, unsupervised, should there be counseling? Should it be a particular type of counseling? They really don't have all the pieces of information that I think they need to make a comprehensive order.
May I add one thing?
Yes, please do.
To that, I was talking about the advantages of having an evaluation where treatment recommendations have been followed. Also, in an evaluation where none of the treatment recommendations have been followed, that I think would give the court a lot of pause and caution in moving ahead and help from a child protective perspective, and get that information to the court. They may or may not have that without the evaluation.
Thank you, Frank Brooks and Melissa Martin. I feel like at this time, unless committee members have additional questions for either Frank Brooks or Melissa Martin, I feel like we should have some committee discussion about where we're headed on this bill, whether we think that we are prepared to vote on the amendment as presented, or whether we feel like we want to take some time to consider adding those other sex crimes that are outside of chapters 11 and 12. So any final questions for Melissa or Frank, committee members? I am not seeing any. I'm going to send you back to the attendee part of the meeting with much thanks for your work today. Committee members, would it be helpful to have a caucus, to have corner caucuses at this point? Okay, I'm seeing some nodding heads. So it is 3:50. Let's have corner caucuses, and if we could return at 4, does that work for everybody? Okay, thank you all. And Dems, we're going to use the same link that we have been using. All right, see you all at 4. Senator Sanborn, did you introduce yourself this morning, or should we start with that? I don't remember.
Sure. Yeah, I have not joined on screen yet today. So thank you, Senator Carney. I am Heather Sanborn, represents Senate District 28, which is half of Portland, half of Westbrook. I'm glad to join you after my other committee has finished their work.
Great, thank you. And Senator Bailey, we appreciate you being here. I think that the bill sponsor is now here, and so I might swap you out with Representative Gramlich. Thanks for all your substantive contributions to the discussion.
Is there a reason Kent Avery is still on the panel?
Just because I haven't had a chance to move him. I'll do that in just a sec. And so I'm bringing Representative Gramlich over. And then you said, Representative Reckett, you said Kent Avery is still on, so I'll move him. It's funny, there's seems to me no rhyme or reason why some people appear on the screen and others don't sometimes. All right, I think that's everyone.
Is the other caucus back yet?
Yeah, it looks like
Oh,
Representative
yes.
Thorne
Oh.
has just rejoined us and Senator Kime, so I think we're all regathering. All right, it looks like we're back. Senator Kime, go ahead.
So as we discussed this, we kind of, because the amendment is so different than the bill, a couple of things. I was wondering if I could ask another question of, I think it's Ms. Martin. Is that her last name, Martin? I didn't know if I could ask her one more question. And then Peggy, I also wasn't sure if we'd heard from the courts on this at all, because I'm just wondering if it's possible to get a forensic. So one of the scenarios that Ms. Martin gave us was that a guardian ad litem had a child come to tell them that, something egregious had happened to a 13-year-old or something. And so then they would go to the judge and say, I would like to request a forensic risk assessment. But as I think through what this bill, as we discussed what this bill originally, the situation this bill was originally intended to address, now we're sort of in a totally different place with the bill. It doesn't really address the original situation that the bill was brought to us for. And now I'm wondering, we're all wondering if, in fact, a judge doesn't already have this capability. I can't imagine that a guardian ad litem without this law right now would not say, oh, there's a problem, and report it to the judge and ask for an assessment to be done. So I guess I need clarification on, whether or not we're just moving forward with something, whether or not it's needed. Not that it's not a good plan to have happen, but do we need it? Do we need the language in order for it to happen? And so I was hoping Ms. Martin could answer that, and Peggy on whether or not the court looked at this amendment and gave us any feedback on whether they thought they had this capability anyway.
I think let's have Peggy answer the question? And I mean, I think that we could, this is, such an important topic. It's also interesting. And I think we could ask, thousands of questions about it and look at a lot of different hypotheticals. But I also feel like we have had a very detailed and robust conversation in both the first and this second work session. And I would just also point out that I think that this amendment does what the original bill did, but does it in a more effective part of the statutes. I don't think that the purpose or the focus of the bill has changed at all. I just think that it's moved a little bit. But let's have Peggy address your questions and then assess where we are. Go ahead, Peggy. Thank you.
Great, thank you. So I think the question is, does the court have authority to do this now? And I think the court probably does have authority to make a reasonable order based on, evidence. Probably could order a parent to undergo this type of assessment, because I think the court can order other types of assessments. I think the courts would be happy to have the guidance that says, here's the things that it's helpful to think about when you're making this, requiring this assessment. And I think the original bill was identified it as that the assessment was something that had to take place before you could even get into court. And I'm not sure if the sponsor thought that was absolutely necessary so much as it was really important in these situations to have a forensic risk assessment take place. But most of the people who testified either neither for nor against or on this bill thought that kind of hurdle to get into court was probably not appropriate, and that it should be up to the discretion of the court whether such an assessment should be ordered. Am I answering your questions?
Yes, you are. Thank you.
And committee members, I actually, Senator Kim, I'd like to respond to that too. I think that as opposed to if the court does currently have the authority, I think that what this proposal does is it actually puts some limitations and some criteria in place to make it more predictable when a court might consider ordering one of these assessments. And so I think that it's really helpful to litigants and to guardians ad litem and to judges to have more criteria to follow when they're making this evaluation as to whether to order an assessment. So that's my perspective on why I think that this would actually be extremely helpful both to parents and to the court system. Okay, committee members, I think that, as I said before, we have had 2 work sessions on this bill, and we have explored in depth with a lot of experts on the impact of this bill and the importance of it. And so I think that we should consider whether we are ready to move forward to a vote. Representative Moriarty?
Thank you, Madam Chair. I move ought to pass as amended. And I explicitly refer to the proposed committee amendment from FLAC dated February 9, 2022, which replaces the original bill.
And Representative, did you want to add your change to the title of the bill?
Oh, yes, that the title should read an act to amend the laws affecting sex offenders and petitions for determination of parental rights and responsibilities.
Thank you, Representative. Representative Poirier?
I just wanted to ask if we could also amend it to include on that second page somewhere where I had talked about the 1 year for a previous assessment. I'm not sure how we would word that, but having a previous assessment that was done within a year apply versus having to pay for another one. It's not actually explicit in the amendment that the previous one is within a year could be used. Is that something that you would be open to, Representative Moriarty, in your amendment?
Well, Representative Poirier, my thinking is that, I know your point is that, and it was made, I think, by Frank, that after a certain period of time, a prior eval becomes stale. But I think the length of time is going to vary from case to case. And I'm not sure that we need to write an expiration date, so to speak, into the statute, and we can leave that within the judge's discretion. In other words, based upon what a judge sees and hears during a proceeding, he or she can say, no, that other one is just not valid, or I see nothing that materially that has changed in the meantime. So I don't think we need a statutory expiration date.
Can appreciate that. Thank you.
Okay, sure.
Thank you for raising the question, Representative Poirier. Representative Harnett?
Thank you, Madam Chair. I would like to second the motion of Representative Moriarty and speak very briefly to it. I believe the sponsor of this bill brought to us a situation in which a parent was truly stuck between a rock and a hard place in dealing with parental rights and responsibilities. On the one hand, trying to care for her child, keep her child safe, and on the other hand, being told that if there were not a forensic evaluation, she might be placing her child in danger if the offender was allowed back into the scene. The opponents of the bill were concerned that we were expanding criminal liability. I think the amendment has addressed that by putting it in the proper title and not in the criminal code. And in addition, it's addressed the situation where it provides absolute discretion to the court. And in this other case, it didn't seem the court felt it had discretion. And two, it allows the non-offending parent to have the ability to pay if they have the ability to do so in an effort to keep their child safe. So I think it strikes a proper balance, and it addresses the situation that was put before the committee. Thank you.
Thank you, Representative Harnett. Any other committee discussion before we move on to a vote? I am not seeing any, and so I'll ask our committee clerk, Susan Panett. Thank you very much, Supi, and I think that we are ready for the vote when you're ready.
Okay, thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Sorry, yes. Sorry, Supi.
That's okay. Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. I didn't hear.
Yes.
Yes, thank you. Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will recall the absentees. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 3 members in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. And for those who voted no, could you please let us know what your report is?
Ought to pass as amended, but with the year term, like I mentioned.
And would that, Representative Poirier, would you just simply add the word year after the word passed in that sentence?
I believe that would suffice, yes.
Okay, thank you. And Representative Libby?
I would have the same minority report as Representative Poirier.
Thank you. And Representative Thorne?
Mine would be ought not to pass, Madam Chair. Thank you.
Thank you. Thank you, everyone. And with that, we will bring the work session on LD, and I'm so dark in my office, I can't even see the bill number anymore, LD 1888. And I want to thank the bill sponsor who has just been able to join us for bringing this matter forward, and to thank the committee for all your hard work on this legislation.
Thank you, Senator. And I know you all have a long afternoon in front of you, and I hope it goes quickly. Thank you for your indulgence.
Thank you. And committee members, before we get started on our final bill, I think that the bill sponsor is being pulled to another meeting, and I know that we have all been working hard today. I'm wondering if committee members would like to hear the bill analysis and then table and resume our work session at a later date. Peggy, is this our first work session on 1310?
Yes,
Okay.
it is.
Would it be helpful, committee members, to do a work session where we hear Peggy's bill analysis, and that will get us thinking about the bill and make our final work session more efficient? Okay, great. Okay, so let's do that then. I think that's a good way to proceed. And Peggy, thank you once again.
You're welcome. And I know that Representative Talbot Ross has another engagement at 4:30, another commitment at 4:30. So I don't know if you want to pull her over for any kind of engagement with the committee in the few minutes we have left before that. So LD 1310 was a concept draft that the Judiciary Committee carried over from the first regular session and first special session in order to provide a vehicle to move forward with any kind of criminal record review clearing recommendations, in addition to anything that came out of the Criminal Records Review Committee. One of the bills that you voted ought not to pass on in order to kind of clear the decks for the Criminal Records Review Committee was LD 1459, which essentially reinstated a process to limit the dissemination of certain criminal convictions if somebody had petitioned to go through the process to have those. The terminology wasn't sealed, but it was to limit the dissemination of that information. It wasn't exactly the same as what was on the books between 2015 and 2019, because it expanded the category of crimes that could be covered. Originally, it was just Class E crimes, and the people who could petition were only those who had committed that Class E crime between the ages of 18 and 20 before they turned 21. So it was kind of, youthful indiscretion while you're no longer a juvenile. And it was just Class E crimes. So 1459, which built on a bill that was considered in the 129th legislature, which came from a working group that was trying to identify how to seal criminal records or to make them not available publicly. So it identified all Class E and D crimes except a list of those that the people in the working group thought were maybe a little too beyond what should be sealed. So it was different sexual assaults and crimes where a household or family member had been involved as a victim. So that was LD 1459. The Criminal Records Review Committee, one of the recommendations was for the Judiciary Committee to have a public hearing on what was basically included in LD 1459. But the Criminal Records Review Committee also looked at that and raised a lot of suggestions for how that might be improved, or maybe kind of dig deeper into some questions. And so what Representative Talbot Ross did was she had me work on an amendment to pull together what was in 1459, but try to incorporate some of those recommendations. And one of the recommendations was, rather than establishing a separate limitation on dissemination of this information process separate from the Criminal History Record Information Act, to combine them and to use that process where somebody petitions to have their conviction not distributed to the public, have that process still exist, but instead of that being its own kind of silo, that once the person gets through that process and the court says, yes, we want to treat these convictions different than other convictions, then those would be kind of slid into the Criminal History Record Information Act, and those would be called confidential criminal history record information. So they would not have a general distribution. So right now, the Criminal History Record Information Act says most non-conviction data about people, so arrest records that are more than a year old, if charges have been dropped, all that information is not a public record, but convictions are generally public records. The amendment says, okay, we're leaving that as it is, except these folks who petition and the court grants their petition to seal their record. We're not going to call that a sealed criminal record. Its terminology is different, but the process isn't different. And then we'll say that that is confidential Criminal History Record Information Act. Criminal History Record Information Act says confidential criminal history record information is not available to the public. It's available only to criminal justice agencies for criminal justice administration purposes. And any place where the statute authorizes access. For example, child protection workers or the Department of Health and Human Services, they do have access to confidential criminal history record information that's relevant in their investigation. So they can only use it for that purpose, but they do have access to it. So there are some statutes that provide state actors access to information that the public does not have access to. And that's kind of the overlay of how this would work. There are still questions that need to be answered, and that we're hoping that the committee can talk about this and figure out how to move forward. For example, the Maine Coalition to End Domestic Violence, which had strongly advocated for those exceptions for what cannot be sealed, has said, okay, we'll back off on those of those exceptions if you still have the 4 years have to have passed since the total completion of the sentence, whether it's incarceration, probation, restitution, community service. It's 4 years after all of that has been completed, no matter what the Class E or Class D crime is, then we're okay with that being sealed, with the exception that victims would always have access to the convictions that were crimes against them. So that is written into Representative Talbot Ross's amendment. You had a whole lot of questions after the public hearing, and I tried to get through them, and I tried to in the bill analysis, and we put together that binder that has a lot of information from the collateral consequences resource center. It's linked, but we also were able to print it and have it in there so you can see how different states treat different things. You have to keep in mind that Maine's Criminal History Record Information Act really does not provide, at the get-go, does not provide access to a lot of information that's not convictions that other states do. And so when other states say, oh, you can just come and file at the court to seal up your arrest records, Maine's already there as long as the arrest record is at least a year old. So you can't just say we can compare all these states with what the fees are and what the processes are, because each state has their own little kind of take on what can be sealed, what's already public, what the costs are, and what the process is to go through. I know that Representative Moriarty asked about those appeals for when somebody petitions to have their records sealed, and it's a discretionary appeal to the law court for the person who's asking for the record to be sealed, but it's an appeal of right by the state if the court does seal the record and the state wants to appeal that. I'm not sure what the source of that is, other than every single statute that we have that deals with a defendant appealing that type of order, whether it's extradition or post-conviction review. It's always discretionary for the defendant's appeal, and it's always as of right for the state. So I'm thinking that when this was originally enacted in 2015, and that language is copied, that was just assumed that was the normal process. And so that's what's there. If it's something you need to change, we can certainly talk about that. And I would like to get more people who understand that process better to talk about that. But I think it was just a carryover of practice. What was the cost to file a petition under the old law, Title 15, Chapter 310? The judicial branch did not charge a fee. In your binder, there is the form that somebody would fill out to file the motion to seal the record or to limit the dissemination of the information. And I don't think the judicial branch was expecting to collect a filing fee for that. We can talk about the constitutional issues. We don't have a law court decision directly on point with regard to whether the legislature can say a record can be sealed and then ends up getting treated very much like a pardon. We don't have information about that. The closer the legislature pushes activities into what is the governor's exclusive authority, the more likely you're going to violate that separation of powers, but we don't know where that line is. We know that the law court has said the legislature cannot enact a law that tells the court that they can reduce a sentence once it's already been imposed and started being served. We know that the court has said the legislature cannot increase good time and have it apply to somebody who's already being incarcerated. So we know kind of those parameters, but we don't know exactly where the line is. So there's been a lot of discussion that expungement, which if that means you actually destroy the record and nobody has access to it anymore, there's a lot of discussion that would be akin to a pardon, because that the criminal record doesn't exist anymore, and that would probably violate the separation of powers provision of the Constitution, which is why one of the recommendations from the Criminal Records Review Committee was that the legislature should consider how to amend the Constitution to give the legislature the authority to make that recommendation if the legislature decided that was the way to go. And so that's not really incorporated into LD 1310, but that's the separation of powers issue. The draft LD 1459 did give certain entities access to the sealed criminal convictions. The Secretary of State to ensure compliance with federal motor vehicle law. I'm not sure why that doesn't also include state motor vehicle law. The Office of Securities, financial institutions when they have to vet board members and pursuant to a court order. If you decide that those things need to happen, you can do it two ways. You can write it into the sealing process, or you could write it into the statute, such as the Office of Securities. You could write into their act in Title 32 that they still have access to those criminal records that are covered by the Confidential Criminal History Record Information Act that relate to their responsibilities, especially under federal law, to make sure that they are not licensing securities dealers or securities professionals that have convictions that would violate federal law or would violate what the legislature determines is the appropriate credentialing for those folks. I guess that's right. There are a lot more, but that's a good start, maybe.
Yeah, let's take some questions on that. And committee members, I'm going to suggest that we maybe continue our discussion for about 10 minutes and then decide whether we want to table and take this up another day. Senator Sanborn, go ahead.
Thanks. Peggy, my question is, if we were to pass this bill, what are the other issues related to criminal records and sealing and expungement and those types of things that will be the charge of the Criminal Records Review Committee that we have another pending bill to reestablish? So what's left? What does this not deal with?
So this is a petition-based system, and I think there are still some questions about can you use these in subsequent, prosecutions and whatever. But so this would be a petition-based system. There are still questions about clean slate or kind of automatic sealing, where after a certain amount of time has gone by, that maybe, it makes sense to say, here's crimes that after a certain amount of time has gone by and they've completed their sentence, they can just automatically be sealed. It's not a petition-based system. There's the whole question about marijuana violations that are no longer criminal offenses and how to deal with those. There's also, I think those are the two big ones. There's a, question about whether you want to do sealing of criminal records, or you want to try some sort of expungement where the records really aren't available to anyone later. I know that some of the immigration attorneys are concerned about that because sometimes people have to prove what their convictions were or what their criminal record was in order to move forward. So there are some downsides to expungement for the people whose records they are. But those are kind of the big issues that I think the Criminal Records Review Committee still wants to look at. And I'm probably forgetting some. I know there was a whole list. A lot of states have what they call a clean slate, which lets people start over, whether that's petition-based or automatic. And there's also some automated processes in other states. Those are usually more not convictions so much as other records, arrest records or whatever. Does that help?
Absolutely. That's very helpful. Thank you, Peggy.
Committee members, additional questions for Peggy? I am not seeing any. Go ahead, Representative Babbage.
Seemed my clicking ability is very restricted. Peggy, thank you. That all was very helpful. The questions that maybe you could help me understand. I know the list of exceptions. I couldn't see a threshold there, and I guess you won't be able to help me with that. 20-year waiting period was part of two of the exceptions, as opposed to the 4-year waiting period. Do you recall the rationale for that? I know it's family, but what's the idea there that deserves a greater amount of time?
I must admit, I wasn't really privy to those discussions, and that has just been carried forward from 1459. I don't know if you want to dwell on that, because I think that comes from, the domestic violence community, and Andrea Mancuso from the Coalition to End Domestic Violence could probably speak to that. But I think since that amendment was printed, even they have actually withdrawn their support for those exceptions. So I don't know if you want to pursue that. You can probably
that's okay.
have a conversation about
that's
it, but
okay. If I may, Madam Chair,
Go ahead.
You mentioned that there actually was not a fee, Peggy, previously regarding petition. Does that then eliminate what we heard from those who are concerned about the bill, that having a right to attorney and that it was disadvantageous to low income? Is that the cost that they were talking about, or was there another consideration?
Well, I think there's always a consideration when you have to go before a court with a petition, that it's always nicer to be represented by an attorney. And so I don't think that the fee itself is the total concern of them. The language specifically says they can be represented by counsel, but there's no provision for paying for the counsel.
Thank you. Thank you very much, Madam Chair.
You're welcome. All right, committee members. I think unless anybody has other questions for Peggy, first of all, Peggy, thank you so much. Oh, and I see that Senator Keim has a question. Let me just finish my sentence. We can perhaps wrap up with our questions for Peggy for now. We do have a binder full of resources, and I think that it'll be good for us to have a little time to think about this. And so once our questions are answered, we'll table and then return, put this back on our schedule for a second and final work session. Senator Keim, go ahead.
Thank you. I'm along the question that was just asked. I wonder, Peggy, if you can maybe run this by the AG, but I'm wondering if we say we're not providing counsel, if that's actually unconstitutional.
I don't think the Sixth Amendment, as interpreted by the U.S. Supreme Court, requires counsel for the sealing of a criminal record. It might be different if it was the conviction itself, but because that's already done and gone, I don't think it's something that rises to the level of constitutional requirement.
Okay, thank you.
Thank you for the question, Senator Keim. Committee members, any other questions for Peggy?
Thank you for the binder. Really answered a lot of questions, seriously, though.
Good.
Thank you.
Good, I'm glad.
Yeah, it's very helpful. All right, is there a motion to table LD 1310?
So moved.
Moved by Senator Sanborn, seconded by lots of different people. I saw Representative Moriarty's hand first. And so to vote on the tabling motion, we'll just use our actual physical hands and see if we need to do a roll call. So if you're in favor of the motion to table, please show your physical hand.
Looks like everybody.
I think so. All right. Thank you very much, committee members. And the final item today is, do we have a motion to adjourn?
So moved.
Thank you. Actually, before we adjourn, I did just want to mention one thing about the bills that we heard last week, in particular 1626 and 585. They have been scheduled for a work session on March 3rd. That work session is really going to be focused on learning, asking and answering questions. It seems that both of those bills are complex enough that we probably would want to do a work session focused on answering questions and then have a little time to think a bit more, and then have a second work session where we talk policy. So I just wanted to alert people that I think that that might be a good path forward. Feel free to let me know your thoughts via email or or you can speak now if you'd like. Did you want to comment on that, Representative Moriarty?
I did, Madam Chair. I just wonder, is it appropriate at this point to make a request for materials that might be useful during that work session?
Not at this point. You can perhaps make a list, but right now I think we're all pretty tuckered out.
Yeah.
And I think that it would be helpful for everybody to have a little bit of time to kind of reorient toward those bills, but thank you.
Okay.
Representative Evangelos?
I think what you just stated was a good idea.
Thank you. Any other thoughts or comments about that? All right, now Senator Kime, did you want to comment?
Yeah, I had sent an email asking that we not work them that day because I can't attend, but I'm assuming you got the email and you're saying that you can't change the date.
I did get the email, and I'm sorry that I've not been able to respond, but I will respond right now. I understand that's actually my son's birthday, and I would very much like to be with him that day as well. But we have only until March 11th to vote out 100% of our bills. And because of that, we can't really, I don't know that we have room in our schedule to bring it forward, to bring it closer to today. And I also think, given that we're going to have to do 2 work sessions to make sure everybody has the information they need, I don't think it's appropriate to push it back, because we're going to run into that March 11th deadline. And I'm sorry, as I said, I am missing a family gathering that day. So I understand that it's not ideal, but it's that time of session. Anything else, committee members? Peggy?
It's not about the tribal bills. It's
Okay.
about, okay, so Thursday afternoon, we have to do some finalizing work on the Government Evaluation Act, and also on reviewing the quasi-independent entities, procurement and financial policies. So I will be putting together some information for you that will be sent to your seats again tomorrow. So you'll have that with you for Thursday's work session in the afternoon on that. And I know Janet is sending some information to you too. So you'll have a packet of stuff at your seats to greet you.
Thanks. Representative Thorne?
Thank you, Madam Chair. Just want to let you know also that on Thursday, I won't be attending that in the afternoon, as my coronation is scheduled for that afternoon.
Okay.
My dentist said I'm getting a crown, so I assume.
Well, we'll look forward to seeing it, I suppose. Anything else, committee members? Senator Sanborn?
Is Friday morning the time when I'm presenting for HCFS confidentiality reviews? Is that right? And that's the 9 a.m. legislative meeting that's noticed.
Yes.
All right. Okay. Wonderful. I'll be here.
Great.
Right. Yeah. If you've looked at your calendar, we're doing freedom of access reviews Friday morning. So, and I have the memos now, so we'll be distributing those in the next day or so. Thank you.
Great. Anything else, anybody? I am not seeing anything. All right, is there a motion to adjourn? Moved by Representative Thorne, seconded by Senator Sanborn. All right, everyone, see you tomorrow at the State House.
Yes.
Take care.
Thank you.
All right. Have a
Bye,
good night.
thank you.
Senator is gone.
I'm still here. You're talking about wondering about planning?
Yep.
I'll get in touch with Ann.
Okay, so I'll sit tight.
I guess so.
All righty. Hi, Lois. Bye, Lois.
Let me actually, I'm going to run to the bathroom, and that may be where Ann went too. So I hope I'm broadcasting that to the world. Okay. But that's what I'm doing. And you're muted, Peggy, because you're
Right.
smart.
We will start a new meeting, so you can just close out.
I can close? Okay.
Yes,
And
close.
I will let LIO know. Thank you.
Done that a minute ago. Bye.
Bye.
Bye.